So today I will be reading some of the letters from Sarah Boone to the judge in her legal case. As noted in our original coverage, Sarah is a narcissist who is completely unable to see herself as she is, as narcissists are apt to do. In statements she would give to the police, she would describe herself as a workaholic who strived for success in everything she did. She was a loving mother, a great wife, and a pillar in her own community, but none of that was actually accurate. All of Sarah's accomplishments had occurred early in life, and she hung desperately to those lone moments of validation, going so far as to tell police that she was a straight-A student when she was arrested and interviewed, despite it being decades since she was in school. In her adulthood, she had become a lazy, rude, and entitled person who would often drink the day away with other men. Her husband would end up divorcing her after she, while drunk, invited multiple people over to their home with their child sleeping in the other room. She had begun dating Jorge Torres, Jr. after her separation, and the pair was extremely toxic. Both abused each other, and Jorge's family had asked him repeatedly to end the relationship. Boone was charged with domestic violence by strangulation in July 2018. She and Torres had been living together for a year and a half. Torres grew upset, according to Boone, when she spoke to another man at a pub. Torres took her upstairs and kicked her in the right eye when they arrived home, she claimed. Meanwhile, he informed detectives that Boone had attempted to choke him. He claimed he had to kick her off in order to survive. Police investigated both stories, but as it was a clear-cut case of he said, she said, there was no way of knowing which story was accurate. Torres was charged with battery, while Boone was charged with aggravated battery with strangulation. They declined to bring charges against each other, and the case was subsequently dismissed. Torres was accused of punching Boone at least twice. In June of 2019, the cops once responded to a domestic violence report at the couple's residence. Torres allegedly struck Boone on the head, face, knees, and arms. Torres was arrested in September of 2019 for breaking his probation. He broke through Boone's bedroom door while she was sleeping and hit her in the head, according to the criminal complaint. But, despite these and other issues, they continued to see each other. That is, until February 23, 2020. According to Sarah, it had been an average day, when at night, Jorge and her decided to split a bottle of wine. Once they had finished, she apparently stated that they should play a rousing game of hide-and-seek, and she asked Jorge to try and stuff himself inside of a suitcase that was lying on the living room floor. He did so, thinking she would let him out, but she never did. Instead, she filmed the suitcase, laughing as he struggled to get out, and saying it was punishment for everything he had done to her. He repeatedly told her that he was unable to breathe, and she needed to let him out, but she did nothing but laugh. The next day, around 1 p.m., Sarah called the police and said, quote, "My boyfriend and I were playing last night, and I put him in the suitcase when we were playing, a hide-and-seek kind of thing." She went on to say she fell asleep and didn't realize Torres was still in the suitcase when she woke up a few hours later at about 11 a.m. She claims she unzipped the suitcase and found Torres unresponsive and not breathing. She phoned her ex-husband, who urged her to call 911. Sarah was subsequently charged with second-degree murder and as of today is being held in Orange County Jail without bail. The original video will be left in the description box if you would like a further explanation of events, as well as a breakdown of Sarah's behavior and psyche. That will be necessary viewing, as there will be instances in the video where I reference that. But since her time in prison, Sarah has not been very happy. As far as she's concerned, she is innocent of all charges, and everything that has occurred in the case has been a great miscarriage of justice. She has gone through multiple lawyers, with them filing court documents stating that she is hostile, controlling, and argumentative with them. Moreover, she refuses to listen to their advice, repeatedly stating that they work for her, not the other way around. Like Tony Todd and other narcissists we have covered on the channel, she is of the belief that if she just talks to people and is left in charge of her own defense, she will get off scot-free. The reality that she exists in is one where she is in the right, and those who don't agree with her are simply the ones with the issue. In her mind, her defense informing her that the evidence against her is vast, and there is a literal video of her laughing while her boyfriend dies at her own hand, and that she should be open to taking a plea deal, is a massive betrayal. Similarly, she refuses to let her lawyers do their jobs, thinking that they need to bend to her schedule first and foremost. When working a legal case, lawyers will spend hours a day reaching out to experts, interviewing family and friends, getting arguments together, and trying to build a case for the client. It's very common not to speak to a lawyer for weeks at a time because they are off trying to build their case. But that's unacceptable to Sarah. Each lawyer that has worked with her has reported that she calls them repeatedly, multiple times a day while they're working on her case. Sarah believed that her lawyers should be at her beck and call, willing to take calls from her daily and field all of her questions as she thought of them. When her lawyers refused to act in the manner that Sarah deemed acceptable, she would become agitated, getting friends and family to call the lawyers as often as possible, and yelling at them whenever they did talk. The following is her first bit of correspondence with the judge on her case, which was sent April 20th, 2022. Honorable Judge Wooten, thank you foremost in advance for your invaluable time and concern in this very unexpected and incredibly confusing matter. All right, we're off to a good start. I am writing in regards to the requested withdrawal, most importantly, of my attorney, Mauricio Padilla, and his/my team filed on April 18th, 2022, along with a continuance. Forgive me if this is the wrong approach in contacting you directly, but I wanted you to be fully aware of the magnitude of my shock and disappointment in the betrayal of Mr. Padilla, because I have not in any way, by anyone, been provided any explanation for the aforementioned withdrawal, etc. To be clear, this is the motion to withdraw that her lawyer has turned in. As you can see, it states, the undersigned is forced to withdraw as irreconcilable differences have risen between undersigned and defendant that have made it impossible to represent the client, meaning simply, he couldn't move forward because they weren't seeing eye to eye on how to move forward. It's fairly clear-cut, but the explanation is unacceptable to Sarah. I unfortunately had to learn of these documents by my former husband when calling to speak with my son. After making a commitment to me as my attorney over the past 2 years and 2 months, ongoing to fully and sufficiently represent me, also being made to believe we are a team, I am completely blindsided. Nonetheless, in how this was and is being handled by a quote, professional, I do not understand. With that being said, Your Honor, I am graciously requesting in present pleas at this hearing on Friday, April 29th, 2022 at 9:30 a.m., so I am able to learn more and also explain the ongoing legitimate hindrances I have been facing, along with my inability to amply progress in the preparation for my upcoming trial and future. Sarah is very keen on trying to make herself look more intelligent than she is, which is why you see her using bigger and bigger words than are necessary, instead of simply saying, I am shocked at my lawyer at the motion to withdraw, and I am unhappy with how it is being handled, which is concise, easy to write, and gets your point across easily. She feels the need to use multisyllabic words that don't necessarily make any sense in the context she is using them, saying she is graciously requesting to be present and that she wants to learn about the legitimate hindrances. It's all a ploy to make her appear more intelligent and reasonable than she is. Most people have a belief that using this kind of flowery, overcomplicated, or abecedarian language is a sign of acute intelligence, when in reality it's just too much. In my opinion, these concerns are what spurred these requests by my attorney in the first place. It is undoubtedly of the utmost importance to me to fight for my truth, and in which I thought my attorney was doing also. So again, I get what she's saying, but that was genuinely a stupid way of saying it. Moreover, fighting for her truth in this scenario is ridiculous. In case she wasn't aware, there's a video online of her while she's killing her boyfriend and sort of mocking and celebrating his death. There's no explanation of events that makes her actions acceptable or good. My truth is a phrase that should be used when talking about a situation where your interpretation of events differs from others. Not when you kill someone but don't think you should be in prison. Thank you beyond measure for your very much needed assistance and understanding. I am flying blind. I don't know the process, procedure, or protocol for any of this, since I have never been in the current situation or situations I am in. Yes, obviously, most people in prison awaiting trial for murder have never been in prison awaiting trial for murder. I am eager to meet with you to further explain any and all question or concerns whomever may have. Please know with great emphasis, I just want to move forward, especially for the length of time already being incarcerated, and remedy this entire predicament, however that may be, in the best possible manner. Have my best interest and security above all else. As previously mentioned, Sarah believes if she can be left alone with the judge, if she can talk to them for just a few moments, she'll be able to convince them that she is a good person, and therefore, her leaving her boyfriend to suffocate in a suitcase was just an unfortunate accident. She's going out of her way to use flowery, overly kind words in order to appeal to the judge, and make them think of her as just a nice woman who might have gotten caught up in something unscrupulous. Again, I thank you profusely. I await your response with further direction in order to be in attendance and proceed forward. Exceptionally grateful, Sarah Boone. The next letter she would send would be on October 3rd, 2022, this time to her new lawyer, Frank Bankowitz. Because this letter is to her lawyer and not the judge in the case, pay attention to the tone and the words she uses, and compare them to how she sounded in the first letter 6 months earlier. Mr. Bankowitz, I am writing in regards to not hearing from you and am becoming very concerned after receiving no response to any of my daily calls or from the letters I've sent. As previously stated, to expect to hear from your lawyer daily in a case like this is highly unlikely, especially if this is a lawyer who is trying to catch up to a case this size. He would be going over all the previous lawyer's work, meeting with experts, talking to friends and family, character witnesses, and trying to get an argument together. He wouldn't be able to sit down and give his client a rundown of his daily tasks, and to think so would be incredibly strange. As of today, October 3rd, you have been my court-appointed attorney for almost 3 months, 12 weeks, 84 days, and only spoken to me 3 times. July 14th, 2022, video instruction, 15 minutes. August 2nd, 2022, video update, 15 minutes. August 22nd, 2022, visit in person, 90 minutes. I have written 2 letters in the meantime also. My most recent I sent September 12th, 2022 with no response. I am unaware of the difficulties you're having in communicating with me, video, phone, in person, especially via phone, which to me is the simplest form of doing so, even if just for a brief update, which takes only minutes. I believed you. I believed by you giving me your personal cell number, you were going to answer. I would at least known all is well and have a better understanding of the status of some things, what to plan on, or what I may need to work on. With no communication makes my end more difficult, drawn out, and painful. Please figure out whatever necessary for my phone calls to be answered, which you will be reimbursed for when you submit your cost. It feels at this rate of communication and meetings, and you just coming on board, not having all of my discovery to go over on top of everything else to be done in depth. How much longer am I really going to be here added to the 32 months already? Especially if we communicate however you eventually do only 1 time a month. If that, as for all of the month of September, I know nothing from hearing from you. It's strange that Sarah seems to be aware of how much work and pressure her lawyer would be under, given that he has to catch up to 2 years of work done by other lawyers, but is unable to grasp that because of that, he wouldn't be available to her at all hours of the day. Again, he would be going over years of court orders, discovery, and details, and that's before considering that he has other clients. For her to want to talk to him daily is absurd. I understand that you have other clients, as I am one also, and you've been recuperating from your back. But remember, please, how long I've been here. You are my 6th attorney, not by choice. In the magnitude of my case, with not knowing what's going on, or where you are, how much harder it is for me. It is not, in fact, harder for her. I want to get on with my life, Mr. Bankowitz, and not miss any more time necessary from my son. I've already missed 4 of his birthdays, and I've already spent 3 of my own in here. Please understand. Again, she's under the belief that, at the end of the trial, she will be getting out, and I cannot emphasize how that will not happen. There's no way forward from what she did to where she gets away with murder, but she's completely unaware of that, and fully believes that if her lawyer calls her every day, if she can have one-on-one time with the judge, she'll be found innocent, and maybe even given financial compensation by the state of Florida. No, too. I am patient. She sounds like a mob boss. I am the danger. Clearly, after all the time already invested. And still smiling. See, Sarah's fine. She doesn't give a fuck. And Sarah is willing to go above and beyond whatever we need to do to properly and truthfully convey my very convoluted, misunderstood side of everything, which I boldly told you in our meeting last month. I am dedicated, ready to state, and overdue. Have you ever met someone who continues to do things that harm others, all the while stating that they're the victim in every situation? Someone who seems to lack so much self-awareness to their own issues that it seems impossible that they even understand reality. I think in modern times, a person like this can be called a lot of things. Overdramatic, delusional, and in some cases, a Karen. Sarah is all of those things. In her letter, reprimanding her 6th court-appointed attorney after the previous lawyers left because she was unreasonable and aggressive for not making themselves available to her every day. She states that she is an incredibly patient, understanding woman. Every part of this case and her behavior shows the exact opposite, but she wholeheartedly believes that that isn't the case. I am so very grateful, Mr. Bankowitz, for you, all that you're doing, have done, and will do. We're in this together, and I'm so blessed that you're my attorney. God has put us in each other's paths for a reason, and I can't wait to see what you and he will do. I'm praying the 6th time is the charm. Please respond. I await your response. Thank you profusely, Sarah Boone. 1 month later, Sarah would send this letter to the judge, November 3rd, 2023, 4 weeks exactly since last letter. Honorable Judge Wooten, forgive me in advice for having to utilize your invaluable time to ask the current progress of my case, but after not having any form of communication with my attorney appointed by you now, after 11 weeks and counting, after sending 4 letters to my attorney appointed by you with no response, and after finally finding an outside source to inform me of the uneventful, confusing filed documents online by my attorney appointed by you, I am still waiting with the perpetual question mark over my head. The perpetual question mark over my fucking head. Where the hell is my goddamn attorney, bro? I don't know how she thinks this is going to be productive, but I mean, here we go. This letter is notably different from the first one she sent to the judge, in that in this letter, she is now holding him directly responsible for her attorney's actions. Her attorney not having time for her and calling her daily is now the judge's fault, because he was the one to appoint him to her case. She is beginning to believe that there is a conspiracy against her in this court, and that the judge is secretly behind it. Why else would he appoint an attorney to her case who wouldn't call her back? No letters, no video visits, no face-to-face visits, no answered phone calls from my attorney, or even a response from you, Your Honor, regarding my letters expressing my legitimate concern of what's going on in my case. And where's my attorney? To be clear, a defendant talking directly to the judge in a case, especially over matters of their own defense, the way Sarah wants to here, is ridiculous. She's basically asking the judge to work as a go-between between her lawyer and her, and give her special treatment. In no way is that a reasonable request. It has now been 4 months since being appointed another attorney, number 6, and not by my decision, influence, or choice. In almost 3 of 4 months not hearing from said attorney, 8/22/22, last correspondence. Why? What is the reason? Why haven't I received a letter, a 15-minute video update, anything? Even after my PTC on October 25th is what truly confuses me and nonetheless upsets me is the fact that I was not in attendance so I could know what is going on in my case, especially considering I have not heard from my attorney in 11 weeks and should have been included. Okay, so no, she shouldn't have been. The reason that the defendant isn't included in every court hearing regarding the case is straightforward and simple. They do not need to be. Especially a defendant like Sarah, who believes she knows better than her lawyers and feels like she should be involved in her own defense. It's clear that she would not be able to handle sitting in the court and not responding to each and every statement that she doesn't agree with, which is why she isn't given the chance. She knows what is happening in the case, because in her past letters, she describes what her lawyer is doing. He's going through old discoveries and making up for past times. But in her mind, she needs to be included in that, which, to be clear, would only make things take longer. The respectful, flowery language has completely dissipated, and now she's basically yelling at the judge in her own case, which I find to be mildly amusing, obviously. Why was I not? This is my case. She says that as if she is the one in charge of the case, and not the person on trial for murder. Was Mr. Bankowitz even there to represent me? I don't know. Anything. Still. The problem is that my constitutional rights are being waived without my knowledge or permission. I've never signed anything nor verbalized the idea that I wish to, quote, waive my appearances to any of my court dates. I want to be present for all dates. Going forward, please, regardless of significance. All are significant to me since my attorney fails to relay any information in any way. If he's not going to, I must myself and for myself. As always, my entire life. What else can I do? Who else can I seek help from? I have you and God Judge Wooten. If I do have an attorney, where is he? There's so much to do all over in my case. Hopefully the right way this time. Because off to a rocky start, where I wonder, how more extended will my time be on top of the almost soon-to-be 36 months, 3 years already? Statements like this are why her lawyers have left. If you are working with a lawyer and you repeatedly make statements like this, your lawyer will believe that you are dissatisfied with their services and request to leave, especially if you are writing the judge directly stating that you are unhappy with their services. Is this how the justice system really works? Am I being penalized for wanting to be fully involved in everything in my case and intelligent enough to know how my case is being handled is just unjust? And from my point of view, disastrous, considering I'm still sitting in Orange County jail counting the days and praying my sixth attorney contacts me and we can move forward. Finally coming to an end, this seemingly endless debacle. the murder the murder that you filmed was a debacle. That's just, who knows, it's crazy misunderstanding. I don't know how I got here. It's just so wild. You would think, considering the circus show my entire case is being made out to be, with all the hype, sensationalism, and publicity, I received a letter all the way from across the pond, England, the other day. It would be being handled more professional, better. Sarah believes because people have watched videos about her case and people are horrified at her behavior that she is a celebrity of some sort. I learn something new every day about facts, events, and outcomes in my case, from all the inmates and officers as well. I wonder if they might know where my attorney is. Bottom line, please understand I don't want to be here any longer. I don't want to be hindered any longer in just getting to the starting line again. I don't want to be suppressed and being heard finally, truthfully, and correctly. So when, Judge Wooten, when will I hear from my attorney? Or you, please? Just some type of response, other than a copy of my letters that I keep sending, which I already have. In the meantime, it is my understanding that the following documents have been filed in my case since the appointment of Frank Bankowitz. My attorney, MIA. 7-11, Bankowitz appointed. 7-12, PTC order. Pre-trial 10-25, trial 11-7. 8-29, pre-trial, canceled. 9-23, notice of unavailability. State 10-7, correspondence, my letter to Bankowitz. 10-12, correspondence to defendant. Copy of my letter. 10-24, notice of appearance. For what? Had 3 years ago. Not guilty pleas. Already filed. Waiver of appearance. Never signed or agreed to. Compensation. For what? What's been done? 10-25, substituting conflict counsel. Who is my attorney? 10-25, PTC. 11-17-2023, trial. 1/30/2023. That's it. In the almost 4 months I've been a client of Mr. Bankowitz, this is the only, quote, progress? What's next? And where are my copies of everything filed ever? This is one way I can have some idea of what's happening, and please remember, I have no access to a computer, not any reliable outside source to check anything for me. Please mail copies. I'm trying to come up with any solution possible to keep me, the other party in my case, informed and updated. This also is part of the court's responsibility. I would especially think, knowing I've not heard from my attorney in any way for 11 weeks. I want to be included. As always, I thank you for your time and understanding. Please help whenever able. I am not helpless. And I am ready to get the show on the road and hear from someone other than myself asking the same question over and over and over again. What is going on in my case? Or how many more pen will I exhaust asking? Grateful and patiently waiting, I will await your response. Sincerely, Sarah Boone. By the end of her letter, Sarah has exhausted all pleasantries. Her repeated statements about being kind, understanding, and patient went way out the window, and she very aggressively let the judge in her case know that she doesn't think he's doing his job. The next letter Sarah sent was exactly a month after. Summary of progress. Numbers only, it's all I have. Before we get into the meat and potatoes of her letter, she has always been sure to address who she is speaking with, writing a ceremonial, dear or honorable judge, before scolding them, of course. But here, she doesn't do that. She is well and truly sick of everyone she has to speak to, not least of which is the judge. In her mind, he's someone she is completely comfortable talking down to. Number 1. Since appointed by court, Frank J. Bankowitz, attorney number 6, July 11th, 2023, 21 weeks, 147 days, and counting. Number 2. Since last spoke to Frank J. Bankowitz, attorney number 6, August 22nd, 2022, 15 weeks, 105 days, and counting. There is something incredibly funny about the fact that Sarah believes repeatedly writing that Frank is her 6th court-appointed lawyer is somehow a slight to him and not to her. Most defendants don't go through 6 lawyers in the course of their first trial. Most only get 1, and they work with them throughout their entire trial. But Sarah is so rude and demanding that 6 separate lawyers have left her defense team because of her behavior. But she perceives them leaving not as a sign of her own poor behavior, but somehow a sign that her sixth lawyer is somehow deficient, which is obviously ridiculous. Number 3. Since pretrial conference, no response from attorney or court. October 25th, 2022. 6 weeks, 42 days and counting. Number 4. Since my last letter to judge regarding MIA attorney and case. November 3rd, 2022. 4 weeks, 32 days and counting. Number 5. Total hours represented by Frank J. Bankowitz. 3,528 and counting. Total hours spent with client, Sarah Boone, 2. Where is my attorney? Where are you, Judge Wooten? I understand the holiday mode everyone is in, as we inmates sit and wait for it to pass. But before we come to the end of the year, and another year, almost 3 for me, in Orange County Corrections Department, it would be respectful of the court to please advise the status and location of my attorney forevermore, and also provide any real progress of my case, which is difficult to do and further without an attorney. Nonetheless, after being appointed so many, I thought hopefully the level of dysfunction would have lessened. To be clear, the level of dysfunction in this case is being caused by her, almost like it's some sort of judicial quicksand, but she seems entirely unaware of that. Bankowitz is a court-appointed lawyer, meaning that he has a plethora of cases he's needed on, and cannot solely focus on Sarah the way she wants him to. Similarly, Judge Wooten is a judge. He oversees multiple cases, and can't follow Bankowitz around all day to relay what is going on to Sarah. Meanwhile, Sarah wants a progress update on a case that isn't close to going to trial, given how much work her lawyer has to do. Unfortunately to date, I am sadly mistaken and feel I've been severely misled. Even more unfortunate seemed to be the lack of representation from any part of my case. Other than myself, just look at the numbers. In the meantime, and in preparation for the upcoming, quote, status hearing on 12/20 at 10:45 a.m., which I just received notice of, thank you for the inclusion, I am in the process of writing our governor regarding the mismanagement of my case and the multiple obstacles and deterrent I am experiencing, trying to avoid any further time hindrances or setbacks going forward. Sarah is basically telling the judge here that she is going to complain to his manager, believing somehow that that will quicken the court case, which it won't. No sane person working in the legal system or in government would look at how this case is being handled and believe that Sarah is being unlawfully penalized. Again, she murdered a person. There is a video of her laughing as he's trapped in a little suitcase. She isn't going to explain that away and be released. Some of the major legitimate concerns of mine are the violations of my constitutional rights, the degree of neglect, and the nonchalant approach by everyone in my case to substantially progress, and the illegal, non-permissive release and distribution by the Orange County Sheriff's Department of crucial confidential case files, as well as videos, photographs, documents, etc., pertinent to my case, which I have not even seen or even know about. Everyone knows more than I do about my case. So this isn't actually illegal. It's in line with Florida's Freedom of Information Act. This is also the reason why the existence of Florida Man and Florida Woman headlines are so prevalent. Florida's Freedom of Information Act is the Sunshine Law. The Florida Sunshine Law are a series of laws designed to guarantee that the public has access to public records, including all documents, papers, letters, maps, books, tapes, photographs, films, sound recordings, data processing software, or other material, regardless of physical form or characteristics, or means of transmission made or received pursuant to law, to ordinance, or any connection with the transaction of the official business by any agency. This means if you commit a crime in Florida, all relevant court records and accounts will be found online, which is how I and many other people have gained access to her letters. This is also why all relevant interrogation footage for this case has been released to the public. As a result, it is impossible to choose a jury that will be impartial, fair, and uninfluenced by all the mutated, exaggerated, hyped sensationalism. I do like the usage of the word mutated there. I think that's fun. Sounds like some sort of horrible beast of justice. But this is not true. Though Sarah's case has been widely reported on, not everyone living in the Orange County area will know anything about her case. It's very easy to think that millions of views and media attention means that everyone in the world knows about something. But some people don't watch the news, others don't watch YouTube, and fewer still read newspapers. This being a significant reason I requested a change of venue previously. At this point, it will make no difference. There is nowhere I am not known. Again, patently false. But this has more to do with her ego. I have made a video on her and have kept up with her case. But truly, if she were walking down the street, I wouldn't know who she was. The premature, unfair judgment by everyone has wrongfully and inappropriately already been made. I haven't even seen my discovery, or know where my attorney is, my sixth attorney. Not only am I, the other party of my case, still in the dark with everything, I am blind and in the dark. This is wrong, unfair, especially for a still proud citizen of the United States of America, and unacceptable. There is more to everything, much more, and in which I have been patient to an extreme to explain, interpret, and educate what now seems to be the whole world. Okay, no, that's too much. Too much again. There is no way you can explain away locking someone in a suitcase and leaving them to die, all the while recording them and laughing as they plead for you to let them out. You could argue that Jorge was abusive and that you were acting in self-defense, but that argument goes out the window when he was defenseless in the suitcase. Had she left him there, gone to a neighbor, or called the police on him in the way she had done before, she wouldn't be on trial for murder. But she convinced him to get into her suitcase and left him to die. This is beyond the scope of a misunderstanding. I am hopeful the governor will be able to untangle the chaos and mistreatment. No one else seems to be available or willing to abide by the protocol of our, quote, justice system and rightfully, eagerly apply themselves. I'm hoping still these aforementioned topics can be further discussed at the hearing on the 20th, and in which I am bringing to everyone's attention prior. I have not heard from my court-appointed attorney to date, so I am unaware of what else may be on the docket. It's time to finally move forward and in all the right ways. Happy holidays, Sarah Boone. But she was not done. In that same letter, she continues writing, Mr. Bankowitz, I am also sending a direct copy to you in case the court and/or judge does not, therefore giving no reason of any unsurety of my ongoing concerns regarding having no communication from you in any manner for almost 4 months. I believed the court and/or judge would have sent copies to you of all of my letters of them, but since I have been unsuccessful in receiving a response or update by their side also, I am taking it upon myself to make sure everyone is aware I am still sitting here waiting for you. Please respond. I look forward to seeing you at the hearing, if not before then, with very much overdue and anticipated progress. Thank you, Sarah Boone. 5 days after writing this letter to the judge and her lawyer, Bankowitz filed this motion to withdraw from her case, citing irreconcilable differences, which makes sense, given everything we have just read. However, the court denied this motion to withdraw, partially because of how long this trial has been dragged out. So, on January 10th, 2023, Sarah wrote him this letter. Mr. Bankowitz, hello and Happy New Year. I hope the holidays were lovely and very memorable for you and your family. I just wanted to check in as I have not heard from you since the, quote, status hearing back on December 27th, 2022. I want to confirm that you were still my attorney after your motion to withdraw was filed December 19th, 2022. It is my understanding you are, which is why I am writing you directly, but also including Judge Wooten, for fear I do not receive a response like the last almost 5 months, 21 weeks, 147 days. It's very important to me you are aware of my questions and concerns for the anticipated pretrial conference on January 17th, 2023. If you are unable to speak to me beforehand, which I am very much hoping you will be. Unfortunately, I'm unsure what else to inquire about, as I am unaware of any other, quote, progress going on in my case. Sarah continues to put status, progress, and words similar to those in quotations to still show how annoyed she is that she isn't hearing any updates. But the issue is that there aren't any updates. No progress has been made because it's not like her lawyers are able to go out and track down some expert who will be willing to go on the stand and say that locking your boyfriend in a suitcase is a reasonable thing to do. The trial hasn't started. Her lawyer hasn't found a breakthrough piece of evidence that exonerates her, and she has yet to come up with anything that can be used in court, so there's been no progress, and it's her own fault. In the meantime, please see below, and thank you in advance for the information and clarification. Number 1, pretrial conference, Tuesday, December 17th, 2023. I would like to be in attendance. What time, please? I have not received a notice via mail or heard from you to ask, and no time was stated during the status hearing. Please make necessary arrangements for me to be included. It is my right. Number 2, waiver of appearance. Please mail or bring appropriate document or documents to unwaive my appearance going forward to everything I am able to include on, so I am updated with any and all status of my case. It is my right. Please note, I have not signed any paperwork for you since the start of your presentation, 7/11/22, as my attorney, so I am unclear how my right to appear was waived in the first place. nor have I verbally given permission for the waiver either. Please provide the quote, signed copy at your earliest convenience. Number 3. Reason for withdrawal. It was not made known by you as my attorney or stated by the judge to the court during the status hearing. I was completely blindsided and still massively confused for the attempt, as our attorney-client relationship hasn't even been established from the 2 hours we have spoken out of 4,536, and the general information it was when we did. If you had genuine legitimate concerns, I thought from a professional, moralistic standpoint, you would have discussed it with me, or at least mentioned, rather than being uncommunicative for almost 6 months, an entire half of another year, for me just sitting here with nothing to show but the perpetual question mark still over my head. Sarah being blindsided that someone doesn't want to be her lawyer after sending them multiple letters stating that she doesn't like how they're doing their job, and calling them multiple times a day, then trying to report them to who she believes is their boss, then going as far as to try and talk to that person's boss when they don't respond the way that she likes, is more than a little ridiculous. She has repeatedly demeaned this man, been combative in her language, and tried to imply that he wasn't able or fit to do his job. She's been reluctant to listen to any and all legal advice given, and instead of helping the case, she has repeatedly hindered it by trying to distract her counsel with needless requests and inquiries. Her own letters talk about her own dissatisfaction with the situation, so her complete surprise is ridiculous. I would have hoped if you were unable to maintain your workload, which still presently includes me as your client, you would not have made the decision to take on my case and even given me selling points on all of your capabilities and resources. Again, Sarah refuses to see her behavior as being a factor in his motion to be removed, and is now stating that he is just too overworked, which is nonsense. She has access to the motion to withdraw, and knows that the reason given was not that he was simply too busy to handle a case of this magnitude. Rather, he said it was irreconcilable differences, but to acknowledge that would be to potentially find fault in herself, which she cannot do. Why? Please help me understand. We are supposed to be working together and for each other rather than against. It worries me futuristically. Also, I have not to date received a copy of your withdrawal. Judge Wooten said I was included on when reading the certificate of service during the hearing. Please provide me a copy. Number 5. Phone account. It was previously told to me by you in our one-person meeting, 8/22/22, that you already had this set up and were having your assistant look into so we could use. After not answering any of my calls, the few I did make in an attempt to touch base with you to provide requested information you asked for me, I stopped calling you, Mr. Bankowitz, and have not to date since September 2022. I kept hoping you would call me or set up a visit, even for 15 minutes, which has not happened. Please help me understand why you gave me your personal cell phone number. Also, to clarify, the judge, etc., I did not avidly search for the statement regarding your public reprimands in 2015 and 18 in an attempt to speak with you from no response to my letters or calls, cell or office, when having someone look up any contact alternative and confirm your address from a letter I sent that was returned then resent. The reprimands were discovered, and for the same complaints as mine, lack of communication. During the status hearing, when I made this known, I was not clear in the end if you were going to actual set up, again the phone account, to be used, which any and all callers, inmates, must have established in order to speak to family, friends, attorneys, anyone. It was nothing new or extra, and all cost incurred can be submitted for payment to the court as you have done in the past already. To clarify, while in court, Sarah deliberately tried to reprimand her lawyer for not speaking to her every time she called, which was nearly every day. She thought that was them being callously uncommunicative, and she looked up other cases he had worked on and brought up past reprimands he had gotten to support her case. But now she's shocked he doesn't want to represent her, and filed a motion to withdraw. It's like complaining about how someone made your coffee, attempting to get them fired, and then being shocked when they refuse to serve you again the next time you complain at the coffee shop. This is how attorneys communicate with their clients here at OCCD. Another option, in addition to 45-minute video visits, 15-minute at-home visits, in-person visits, and of course, the Postal Service. It would definitely have made sense to use an avoidance of even more time being exhausted in the length between any visits in the future, which will only help the progress of everything. Will you be utilizing? I think the biggest issue that Sarah has is thinking that she can help this court case at all, and that she can be of service to her lawyers. Between the times they've seen each other, no new information has been made available. She hasn't changed her story, and she hasn't stated that she wants to argue the case in a different way. There is nothing to be gained from a phone call. Number 5. Discovery/case materials. In the status hearing, you stated you have 2 boxes of information that are out of order and unorganized. Have you organized and reviewed? How long have they been in your possession? When will we be going over? It is extremely concerning that this is all you have. It has been said there were 3, 5, 6, a ton from some of the attorneys prior on my case. Which is it and what is there? 3 years later, I'm still wondering. I have also put in numerous hours, pages, pen ink of my own information, which I am praying is in either of the boxes you currently have. Please let me know, as the added amount of even more time to locate, receive, review anything missing from everyone receiving beforehand withdrawing will most definitely be extreme. I don't know what you have. I could also assist in organizing what you do have, considering it's part of my case. I am eagerly waiting and more than willing to help with this and everything else. I just need to see what there is, which I have yet to see 3 years later. Again, Sarah is operating under the delusion that she can be helpful to anyone, much less a lawyer. She is so incompetent that even if her heart was in the right place, she would undoubtedly ruin the paperwork. Number 6. Prosecutor. Is there no one new in my case? I noticed his attendance during the 3 status hearing attempts and came to the conclusion that there is. Since you have not communicated with me this or any information, not an announcement was made by the court, I do not know. If so, what is his name? What is his background? Mr. Bankowitz, you must understand how insignificant I have been made to feel with the never-ending debacles, hurdles, and stumbling blocks I have and am going through and still facing since becoming incarcerated. No one seems to listen ever. I refuse, absolutely refuse to believe this. My entire experience to date really is how our justice system operates. I refuse because, as said to you, Judge Wooten, the court, to everyone else in the status hearing, and to anyone who truly cares, my reason is hope. Never-ending, no matter what, hope. This being the entire reason I am even here for my incarceration. As opposed to what? You killed a person. You aren't incarcerated by choice. You had no other option. The fact that Sarah continues to act as if she is the one in control of the situation, that her being in prison is because she is allowing it, is obviously ridiculous. Nothing is impossible with God, and I await my day to say my truth and side of everything. Please don't give up. I have not and will not ever. I await your response or responses. Always, Mr. Bankowitz, thank you. Sincerely, Sarah Boone. 2 months later, on March 22nd, Sarah sent another letter. Mr. Bankowitz, this is my 3rd letter trying to reach you over almost a 6-week period now. The same two phone numbers you've given me still don't work. The one number, your personal cell, goes to voicemail directly and doesn't even ring. I've had this number since you personally gave me back in July of 2022, upon your appointment as my attorney by the court, not working still 8 months later. The other number rings and rings and rings until it automatically disconnects me, not working either. This is also the number you continuously tell me it just needs to be activated. Please activate. I even, in my desperation to speak with you, had an outside caller try to reach you on my behalf, who tried calling your office 3 times over the last almost 3 weeks. We're both hoping that you're able to replay her email she sent today as another form of trying to communicate with you. I've exhausted my resource and am just sitting here waiting for you to contact me in whatever way you're able to, and as soon as possible, please. Time-sensitive matters are at hand, as I have made you aware of previously, verbally and in my letters. I know you have attempted to schedule the minimum 15-minute video calls within the last week, the first having technical difficulties and canceled. Then the second was a no-show. What it seems to be is every time on your end, whatever the disconnect is, I am extremely frustrated and worried, not being able to communicate with you, even just sometimes, especially when there are very important, pressing discussions needing to be had already, but have not, from no means of successful communication. Mr. Bankowitz, why do the phone numbers 2 still not work? You've given me over 8 months ago, and you keep telling me to call. Neither work, and have yet to be answered. Why are you not responding to any of my letters? 3 so far this year. Why are you unable to correctly set up a video call if you were even on the call? Please know, Even though I am temporarily an inmate and incarcerated, I do have a schedule with classes, dorm trustee duties, and medical appointments which I have to be excused from for nothing. Please fix the connection problem. Remember too, please, I am just back at the starting line, barely, with you as my attorney, and I have yet to be able to speak with you on the phone. I am genuinely concerned with the numerous promises you've made, and even suggested yourself that will or can be done, but they do not yet. I need your help, and you have graciously offered to. But when? Please. My pretrial conference, I found out, is now March 31st, 2023, which you have said previously, for whatever reason, I'm unable to attend any of these conferences. How am I supposed to know what's going on, and what are you reporting, and what is being discussed between all other parties except me, the main component in my case, especially if we, in a still unestablished attorney-client relationship, are not in regular, proper communication with one another? Why can I not be in attendance and participate in my pre-trial conference? How else am I to be kept updated in real time in actual minutes during my conference if not there myself? I have no way of knowing anything if not updated by you, my attorney, and I do not have a computer to use/view myself. Help me understand, please. How can court TV, different news channels, and even, quote, professional YouTubers, that's us, attend my pre-trial conference and I cannot? How? I'm sure one of the other parties can help me with updates, since they all will be in attendance for me also, should you be able to provide. Why can I not be included for my PTC for my case? I'm sure also everything from the conference, collected from everyone else, will be vomited all over the internet just like everything else has been, not permissively, and can add even more dysfunction and ignorance to my prejudgment already made by the world in the great court of public opinion. I would like to be a part of all of this, seeing as it all pertains to me. Please, it is my right. So many questions, concerns, piling and piling up from not being able to remedy or complete from no communication. Please change, answer, fix, or present. Please. Everything you've given me to complete has been done on top of everything else I am dealing with, keeping at bay and really trying to figure out by myself, since you were unable to, even by just answering the phone once. I don't know what else to say that has not been already many times. I am still here, still waiting, still hoping, 3 years later and counting, with you, Mr. Bankowitz, 8 months and counting, ready whenever you are. Trying my best always and thanking you in advance. Sincerely, Sarah Boone. The following month, she writes the following letter. Strangely enough, this one was written with the public in mind, not her lawyer or the judge. To whom it may concern, the enclosed letter I sent March 22, 2023, was scanned incorrectly on the clerk's website, only first and third page, so I am resending with nothing on the backs to avoid confusion, and were missed previously. I also received a copy of my copied letter today, with only the same 2 pages included. Are my letters even being read? I wrote 4, but only 2 were copies, uploaded and mailed. Clerical error. An update while already contacting you. Mr. Bankowitz has not met with me personally, face to face. Ongoing now 2 months, 8 more weeks. The 2 phone numbers given still do not work, or his office phone answered when someone trying on the outside. Just Wooten, can you please have Mr. Bankowitz fix the phone problem? He asked me for information, some critical and time sensitive, which I complete expeditiously for him, but then have no way to relay successfully, in turn hindering progress and creating even more to discuss in a 15-minute video visit when he does actually schedule and at work. Even PDs answer their calls, and I've yet to be able to speak to my court-appointed attorney on 2 phone numbers for 9 months. July 11th is my 1-year mark, another milestone while here, with Mr. Bankowitz as my attorney. It is also my next pre-trial conference. Will I be able to attend and be included as I was with my last? Thank you. Please also include me in the, quote, status hearing you mentioned to the court during the last conference, which is supposed to happen sometime prior to the next pretrial conference in July. I am still waiting patiently and respectfully, 6,480 hours later, with Mr. Bankowitz as my attorney, waiting for him to contact me and hoping just one of his phone numbers will finally work so we can pick up speed to provide significant progress in my upcoming meeting. Thank you all for reading my entire letter and uploading correctly for all the world to read. Also, critique and judge wrongly and incorrectly as usual. Ignorance is bliss. I wonder what platform of popularity I will be featured on next, and how much wasted time, effort, and thought will be put into mutating and grossly exaggerating my case information. Racketeered to the World Wide Web. Shaking my head. Run with it. I wonder, too, if I have a panel of, quote, letter readers dedicated to all the ones I've written. Enjoy. There's more to come. Oh, I bet there fucking is. Shout out to my supporters. Heart. Everyone is waiting. Not on me. Hopefully, no matter what, Sarah Boone. And that was the last letter, until the day I am writing this video, when the clerk uploaded her longest, angriest letter to date. Sarah is now well and truly aware of the coverage of her case, with the JCS video racking up a cool 13 million views and multiple channels breaking down her letters in detail. At this point, she believes that she is being victimized by the world at large, not just her lawyer and the judge. So let's read that. Judge Wayne C. Wooten, Attorney Frank J. Bankowitz, World Wide Web, Perspective, Merriam-Webster Dictionary. I wonder how many people are going to actually look up the definition to see if it's the same. I also wonder how many website hits the word perspective will get. There comes a time when someone being negatively discussed on the internet begins to use that virality as a sort of calling card or a thing to be proud of. Mind you, Sarah's case has gone viral for her antics and her ridiculous behavior. She isn't being discussed because she is creative, clever, or witty. She's being discussed because the manner in which she behaved after killing her boyfriend was so ridiculous that people couldn't help but laugh. But all she can see is that it went viral, and she on some level is famous, and that by her defining the word perspective in a letter, the searches for the word are going to skyrocket. Definition 1. The science of painting or drawing so that objects represented have apparent depth and distance. Number 2. The aspect in which, as subject or its parts, are mentally viewed, a view of things, as objects or events, in their true relationship or relative importance. Please review so everyone has a clearer, better understanding of my continued concerns, hindrances, questions, and frustrations with the justice system and the solid, absolute remissness of my case in the due process of. I am and have been waiting very patiently and maintaining what I can, since no one else has or will, it seems. And I feel, at this point, 6 attorneys later, 39 months, almost 3.5 years, which I will make, and not by choice, I need to make all aware of my immense struggle with the extreme mismanagement of my case to date. Let's look at the bigger picture, or perspective, to get a better view of what I've had more than enough time to see and realize. I'm hoping by doing so, eyes can finally be opened, and very overdue, longed for progress and finalization can be had. The growing amass of ignorance, manipulation, slander, and advantageous gain must stop. My truth needs to be heard, and it is my right. Do not give me rights, expecting me not to fully utilize them. I voted for the president and governor while here in jail, and stop violating what I've been trying to utilize or lessen the value of my capabilities and opportunities. I am not apologetic in any way for being an observant, hardworking, above average, non-stereotypical inmate. I can only imagine, sadly, how other, not as outspoken as myself, have been and are being mistreated, overlooked, and dehumanized. Get it together. Judge Wayne C. Wooten. Number 1. At what point do you evaluate and intercede in a case to make sure there is proper advancement, regular communication between attorney and client, ethical treatment of client is being upheld, time frames are met, etc.? Clearly, you know and have known the prolongation of my difficulties from your comments regarding my letters, but with no intervention from you to change anything for a better, less problematic process. You've told me in the past, when I've tried to voice my legitimate concerns to you in the courtroom, 5 times in total in 3.3 years, and in my letters to save it for the next attorney, if told anything at all. Do tell me, Your Honor, which attorney? Sarah still fails to realize that she is the problem. In every situation thus far, she has been the issue because she simply refuses to acknowledge the situation that she's in. She does not have unlimited access to her lawyers. Because they are court-appointed, they have other cases, some of which are more pressing than her own, and her daily calls, where she questions their authority, tries to undermine their intelligence, and repeatedly states that they don't know as much as she does. All of this does not help them do their job. She creates an environment where in order to get any work done, they have to be holding her hand, and each and every lawyer she's worked with asks to leave. Because of that, she's been told by every lawyer she's had, as well as the judge and the public, to wait. All she has to do is wait as they put together the best case possible for her, and she refuses to do that. I'm on my 6th, whom I've not seen in person for over another 3 months period, 12 weeks, 89 days and counting. Frank J. Bankowitz has been my appointed attorney by the court to, quote, represent me in my case, and has been for 10 months and counting. Total approximate hours of representation, 7,200. Total times attorney has met with client, Sarah Boone, 6. Phone numbers given to client by attorney, 2. Phone calls answered from client by attorney, 0. Outside sources calling attorney on behalf of client, 3. Phone calls, emails, voicemails, answered by attorney, 0. Letters client sent to attorney trying to communicate, 7. Letters defendant/client sent to judge trying to communicate, animate attorney, and unsuccessfulness, 5. 15-minute video visits between attorney and client, 3. Attended court dates scheduled, 2. I was attempted withdraw. The other an allowance to finally be included in my PTC, which was the same information carried over from all the others. Now what? What she said right there is very important, and why she wasn't at the other pretrial conferences. Most of them were reassertions of the same basic premise. The prosecution was ready to move forward with their case, and the defense was not. She was told this by her counsel and the judge, but she refused to believe that that was the case until she went herself, and is now angry that that's the case. She's gone through 6 lawyers, all of which have other cases, all of which have to wade through everything in this case to try and make an argument in defense of Sarah's indefensible actions. It's not going to move as quickly as she would like, especially if she continues to antagonize everyone involved in the case. Number 2, why are you allowing/enabling my constitutional rights to be continuously violated? History lesson for everyone. First Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment, Eighth Amendment, 14th Amendment. Number 3, why am I being judged for my legitimate letters that I write in order to know the status of my case or attorney and how much longer before something substantial occurs in the progress of 3.3 years later, other than the inappropriate prejudgments being made due to the excessive amount of my case information online, bigger and meaner fabrications of my case-sensitive details in which I have not seen, or even greater, mind-numbing, one-sided ignorance. If I didn't write my letters, would you or anyone be aware of all of my rightful concerns, still and ongoing? Is a perpetual question mark over a defendant's head the norm during a case due to inactivity, no communication, no help or intervention, or answers being given by anyone in the justice system? Honestly, what has been done about or with any of my letters, other than being scanned and uploaded incorrectly? I made sure to correct so everyone is up to speed on my case status. Unfortunately, it is all I have to report on at this time. Sarah rightfully surmises that with her letters being uploaded online, more and more people will be able to talk about them and gawk at her antics. However, as we've seen time and time again, she seems unable to realize that that is her own doing. If you're in a situation and you note that every time you raise your hand, you get a violent shock, you would likely stop raising your hand. Sarah is basically in that position. Every time she writes a letter demanding to know the answer to the same questions that have already been answered by all of her lawyers and the judge, the public gets access to them and can further ridicule her due to Florida's sunshine laws. But instead of deciding to keep her communications with her lawyers private and foregoing writing letters, she writes more of them. That is the complete opposite of problem solving. Number 4, why are you allowing numerous case safety and protection elements to be breached, violated, and manipulated? Why has a gag order never been implemented? My case is turned into an unnecessary witch hunt from the innumerable violation of my case details being leaked and racketeered illegally in exchange for website hits, viewer rating, etc. In exchange for $. What is your cut, Your Honor? Yeah, got him, Sarah. That was rad. She is now accusing the judge in her own case of being corrupt before the case has even begun, and she believes that this is helpful. You choose who knows what, where, and how in your courtroom. When did court minutes become live? I believe in Florida the sunshine laws were passed in 1955. So 1955. Are you the one who authorizes and upload to the internet? It's all about how much, rather than how did it happen. No matter the destruction caused in the meantime and is irreparable, it's not even about the suitcase anymore. Yes, it is. This is about you murdering someone. My case is now a global event with the video receiving over 3 million hits. depending on the website, in turn making me realize that that's over 3 million less unprejudiced, unbiased, non-discriminatory, fair jurors I have access to on my case. While that is true, there are over 7.8 billion people in the world, meaning that those people only make up 0.0384615384615384644% of the population. So a fair jury would still be relatively easy to find. How is that going to work? Now what? Number 5. Factoring important private details should not be made ready and available for the whole world to know before I, the defendant, does. Correct? This is wrong, as well as unconstitutional and unfair, and not how the justice system is supposed to work for anyone. I'm tired of having motive attributed to me that are unreal, assumed, and inappropriate. This is not legal. Number 6. This is what a trial is for, correct? Number 7. At this point, what can even be rightfully suppressed in my case? Once you ring the bell, it can't be unrung. It's already been heard and seen. I don't even know where the bell is or who is ringing it. Number 8. When do I, the main component in my case, actually get to know, see, or hear anything everyone else already has? When am I going to be included also? Number 9. When is the next status hearing you stated would happen before my pretrial conference, 7/11/23? My attorney's 1-year mark. Am I included? Number 10. What else can I do to ensure the productivity, communication, incorruptibility, appropriation, and intellectualism of my case? It is my right to know so I can begin or continue to true progress of any kind to fully be succeeded. Attorney Frank J. Bankowitz. Number 1. Where are you? Our last in-person meeting was February 15th, 2023, 3 months. Number 2. When is our next meeting? Remember, please, there are still time-sensitive matters pressing. FYI, in the 10 months of your representation, here are the 6 meeting dates which have occurred so you can see, prospectively, the massive time gaps between while I have been sitting eagerly, waiting, wondering. Number 3. Why aren't you fixing either of the 2 phone numbers you gave me upon your appointment back in July of 2022? Every time I speak to you about it, it's a different excuse. Much progress can be had in a very expeditious manner, if completed. Why has it not, almost a year later? Why do you keep telling me to call when you know they don't work? As said before, public defenders answer their calls and reply to mail. Why are you unable or unwilling? See the difference it will make. I halfway can't believe she's still talking to her attorney like this, but in a weird way I can. I can believe that. This goes on and on. Why is she like this? Jesus. Number 4. Our agreement made from one of my letters I wrote earlier this year, after not hearing from you in a solid 5 months prior, was to connect every 2 weeks, with or without significant progress. Why have you not been upholding this agreement, even in a 15-minute video visit? Remember, a phone call is another option and not as difficult technologically. A working number is needed, just one. Number 5. What are your anticipated dates of completion for anything already discussed? And will eventually, when do you actually show up for an in-person scheduled meeting? There are 1,000 little fires needing to be put out, and you're holding the fire hose. Please see, from my perspective, the botched, eye-rolling experience I am going through still, and how I believe anyone would act or do if in my slides doing the same. What would you do? Do not fault me in trying to make the best, most successful outcome possible for myself in every aspect in the convoluted predicament I am in and have been over the past 3.3 years. I would rather be called a narcissist, a pain in the ass, arrogant, strange, or whatever anyone else wants to waste their time thinking of. Just don't call me a murderer, which I am not. Okay, but you literally are though. Even if I give you the benefit of the doubt, you murdered someone, and you filmed it. Your actions caused someone else's death. You are a murderer by definition. No one knows me except for this ludicrous insanity that's been made up, mocked, edited, and spewed all over the internet. It is not me. I did not hit her. I did not. No, but it is though. It literally is you. I'm hoping and praying my highly anticipated day will come, whenever that will be. It's God's timing. I continue to wait, smiling. At least everyone will know I'm not sitting around eating bonbons watching soap operas. Application is the product of lesson. Give me my chance appropriately, correctly, and fairly in court. Unfortunately, my perspective of our justice system is incredibly dim and dull. I hope my very overdue blinding light has shone brightly for all to see a glimpse of how it really works. And being a system, we all have to work together to function in unison. Please help. See the difference I am trying to be and make. Waiting and wondering. Keeping it real? Now what? Sarah Boone. And then she puts down the telephone and turns around to walk away in slow motion. Hand delivered 7/21/23. Revisions made 7/20/23. Original not uploaded to date. Second attempt to make public, like everything else in my case, including all of my other letters. Freedom of speech. Mine. All for your review, critique, judgment, understanding. Try it. Clarify. To become or make clear. Clarity, clearness. Per the Merriam-Webster's dictionary. Where do I even start? Through the officer inmate grapevine and a letter I received from my, quote, fan mail. And usually the only way I find anything out regarding my case, sincere, there is no communication from my current attorney, now 10 weeks more of complete silence. And yes, my 6th attorney, which I will clarify momentarily. I was made aware my last letter was featured on the news locally, realistically meaning globally. Apparently, my very legitimate, lawful, real questions and concerns I asked, and am still, caused a stir on top of the already engulfing whirlpool my case has become and made out to look like, which it is not. I cannot emphasize enough that this makes no sense. I understand from reading her letters prior to this what she's saying, but without context, she just sounds like she's trying to hit a word count on a topic that she knows nothing about. Hence my questions from said letter. I am trying to protect and maintain my truth, which no one knows, since no one else will, however I can. Since no one else will, however I can. Since no one else will, however I can. What the fuck is she saying? That doesn't sound right. And keep some of the illicit ugliness at bay. Mismanagement at its finest, in everything. Okay, this we can comment on. Sarah's case is not being mismanaged. In fact, what's going on with her case is about as by the books as it comes. Her lawyer, who was not speaking to her for weeks on end, is working to try and make a case for her. They are trying to find experts, character witnesses, and evidence that will show that Sarah acted in self-defense. They cannot do that if they are talking to Sarah at the rate that she wants. Granted, I think talking to her every month just to tell her that they're on track and explaining that the justice system is extremely slow-moving would be beneficial. But after reading all of her letters and seeing how she refuses to take on any information that she doesn't like, I don't think that would go very well. Again, this is a murder trial. She has gone through 6 different lawyers. To get fair representation, she's going to have to wait a good amount of time. Nothing in this is being mismanaged. Moreover, her letters being made public is not mismanagement. It's again part of the Florida Sunshine Laws, and is done to make sure that everything that occurs in this trial is above board. Why wasn't I included at all? Why was I asked prior to being highlighted so I would know what was said or asked or criticized, so I could rightfully defend myself? What was so newsworthy? The news does not have to ask the subject of their reports for their opinion. This again makes no sense. By not including me is unfair and adds to the assumptions of what everyone wants me to end up being and thinks that I am. This is wrong, and also adds to the prejudgment of my case. All of the idiotic theories, empty opinions, false accusations is all the ignorant world knows from all the pertinent private case details available to everyone except me, the defendant in my case. How can I defend myself? I can't, so everything gets meaner, more evil, corrupt, and out of control. I believe this is what my trial is for, right? The world is supposed to learn everything about my case during the trial, right? This is not justice or a system, right? All fairness has been completely removed, right? So were any of my questions answered? Was anything at all clarified regarding evaluations, amendment violations, case sensitivity protection, suppression? What has the video's hit count reached now? My last letter said it was over 3 million. How much does that shareable income make for everything? Did anyone locate my attorney or discovery? Everything, everyone, everywhere in the world knows, has seen or listened to all of my discovery. Again, except me. In the meantime, here's a corner piece to my convoluted puzzle. All are wondering when it would finally be put together to see what a neat picture it is, and also a huge disentanglement of only an inkling of some of the misunderstandings and ignorance swirling about in my case. Before you try wearing my, quote, slides, know where they've been. Yeah, that's right, stupid fucking know-nothing attorney. Sarah's on fire today. She's gonna go free any day now. Alright, anyways, my attorney's number 6. When, as I've said numerous times in my previous letters, why not by choice, I'm on my 6th attorney. Here is some clarity so everyone can finally have some understanding why my slides are so worn, but most definitely walkable still. Sarah is particularly sassy today. Hashtag free Sarah Boone. Attorney number 1. Private, February 2020, May 2020. This attorney sold me the world, promised exoneration, and supplied an overabundance of other continuous false hopes, so I would accept his offer to become my attorney. Cutting in here again to say I doubt this is true. Lawyers are incredibly careful with the verbiage they use when working with someone prior to when they became their client. It's why lawyers on YouTube often start their videos by repeating that the video itself isn't legal advice. I doubt any lawyer would see the facts of this case and tell Sarah that she has an open and shut case, and they can get her off scot-free. It's much more likely that the first lawyer explained to her that the details of her case would lend to a battered spouse defense, and would explain how those cases had been argued and won in the past. Given that Sarah and Jorge had called the cops on each other, and multiple people witnessed how violent their relationship had been, that defense wouldn't be unheard of. But as we have seen through Sarah's interviews and her letters, she has a very warped interpretation of events in reality. She has repeatedly stated that she is incredibly smart, as well put together, and that the majority of people in her life hold her in the highest regard. But the opposite is generally probably true. She is a drunk who is widely ignored by friends and family because they simply don't trust her. He had no idea what my case is going to be or was really about. That he deserted me, his client, naive and new. I think she means naive, but it's alright. 2 weeks before my first scheduled trial due to irreconcilable differences, meaning I was not persuaded enough to agree with what he wanted me to say or do, and was not what happened. So let's break this down. She is claiming that her lawyer never knew what her case was about, despite the fact that he was going to represent her in trial. They got all the way to the trial, and self-admittedly, Sarah never told him her side of the story, or as she put it, the truth, meaning he would be going into the trial completely blind as to what she believes exonerates her. Mind you, if you are going into a homicide trial where you can be found guilty or sentenced to life in prison, you need to be honest with your lawyer and agree with how you want to proceed. You have to agree on how you're going to argue the case, and from her own statements, they were not on the same page. He didn't feel comfortable representing her the way she wanted to be represented, and so he left the case. This is a good thing. That lawyer was responsible and handled that as best he could, and Sarah trying to state that he was unprofessional on his end is false. There was no trust. There was no strategy, and if there was, I was never included in on it, or an innumerable amount of other case-defining details and questions left unanswered before going to trial. I felt he was sabotaging my case and setting me up for failure due to his micro amount of experience, which I found out after the fact and was not disclosed prior to my acceptance or his representation in my macro-sized case. This is an entirely unfair way of perceiving that situation, and is so unfair that it borderlines on being delusional. She hired this lawyer. This was not someone who was appointed by the court, but someone she sought out and hired out of her own pocket. Had she felt he was unqualified to represent her, or was ill fit for the position, she would have fired him herself, or not hired him in the first place. Again, the outcome of this case is going to determine the rest of her life. It's important. You would think, with how she perceives herself and how put together she claims to be, she would have heavily researched the best attorneys in the area and made sure the lawyer she hired would be up for the job. But she apparently didn't do that, and only took issue with him when he disagreed with her way of proceeding at trial, and she is only forcing her frustration with that said lawyer years after he left the case, citing irreconcilable differences. Nonetheless, when we did meet to discuss my case, and I asked for updates about any progress, he would start talking to me about his client in Colombia, his clown of a sister-in-law, his nephew going to water parks, trips he's taken, his regrets, where he bought his gold sneakers, and many other unrelated, unimportant, and time-consuming stories. All the while, I'm trying to figure out what's going on and why he's not answering my questions. Nothing was ever completed or accomplished or communicated. Building 1,000 fires, waiting and needing to be put out before making another left ablaze. I was always ignored and in the dark, conjuring the dreadful, perpetual question mark still looming over my head. So much so, I prepared an 8-page packet for Judge Wayne C. Wooten to provide during both court dates, defending myself against my attorney's untrue, unresearched withdrawals. No one asked me nor permitted me to speak my truth to help him in the court understand my real concerns along with all the carryovers since day one. I was trying to avoid going through any of this again going forward. It had already been 2.3 years. I wanted the judge to include me and know I have a side also in everything. Plus I knew Judge Wooten would be appointing my next attorney in hopes he would listen and appoint a more suitable, experienced one accordingly to save time for everyone to progressively move forward. He must have been throwing darts at a dartboard blindfolded. A lot of Sarah's attorneys have stated in court documents what they plan to argue in court, and there was a lot of it that didn't frame Sarah in the best light. They were going to confront her alcoholism, how she had left her child alone in her home to drink, and how her friends and family no longer trusted her in their home or around their children. But they were going to use that, along with the abuse between her and Jorge, to paint a relatively sympathetic picture of her in court. But by Sarah's own admission, she didn't want to do that. She didn't want them to state that she had an issue with alcohol, or that she had let herself slump into a depression after her divorce. She wanted to continue the narrative she gave in every police interview she has given. That being, she is a smart, enterprising young woman who simply made a little mistake, and should be let go because of that. But that isn't based in reality or fact, so whenever her lawyer would put forth an argument that made her look like a depressed person dealing with alcoholism, she would take that as an affront and feel the need to fight that, even though the alternative was to say she purposely and maliciously killed her partner. Sarah doesn't want to look bad in any way, shape, or form, even if that means her going to prison for the rest of her life. This attorney, number one, was and is untrustworthy, unreliable, unprofessional, with poor leadership skills, and is extremely unorganized. He was unable to perform ethically and as an adult, ignoring his client, misleading and deceiving. He didn't even respect me enough to speak with before his withdrawal to try and remedy or figure out anything out to stop. I was totally blindsided. Again, let's think about what she's saying. She hated this attorney. He was incompetent. He couldn't focus. And she felt the need to fix all of his work on her own because he was so bad at his job. And yet, she is upset that he withdrew from the case. It was more a shot at her ego that this person left her case, even though she agrees that he wasn't right for it, and their differences were irreconcilable. If anyone else was in his position, working with someone whom they felt didn't have their best interest in mind, they would be happy that they left. But Sarah is resentful and angry, likely because all the claims she is making against him and how horrible he was probably aren't true. Attorney number 2, 3, and 4. Public defenders appointed by judge and court, May 2022 to June 2022. Judge Wayne C. Wooten and the court repeatedly appointed me public defenders, number 3, without any research or care, and after I continuously explained to each and tried to the judge/court, they could not represent me due to their representations of the decedent. Okay, so when you're given a court-appointed lawyer, it's not like a dating app where you put your wants in a lawyer in and are given a selection of only the best in your area. A judge doesn't write down your wants for a lawyer, then go out to a bunch of interviews to pick one they think is right for you. You are given a lawyer who works in the area and can handle the case. It's that simple. Sarah is angry that the judge didn't take in her specifications when giving her a court-appointed attorney, which, if you recall, is something she didn't even care enough to do. We've done our homework, I was told. I received 3 withdrawals, none by choice. Definitely not systematic. Attorney number 5, conflict. Appointed by judge and court, June 2022 to July 2022. Upon our first and only meeting, this attorney expressed his mass confusion in why he was appointed by Judge Wooten, as he was leaving for a teaching job out of Orlando within the week. I learned more from this attorney in one meeting regarding my case than all prior combined. It was extremely disheartening he could not continue representation and set the bar going forward, especially regarding honesty and respect. I received only 2 letters from him, 1 introduction and 1 withdrawal. He also did not know where any of my discovery was or notes. Now, 5 attorneys later, not by choice. I'm theorizing that because this lawyer couldn't represent her for longer than a month and was straightforward with her about the fact that he couldn't represent her because of a teaching job, not because of anything they did, she will believe this man is the one that got away. I doubt he was any more professional, courteous, or honest with her than her previous lawyers had been, but the fact that he literally couldn't stay to help her made her believe that he was perfect. Attorney number 6 conflict. Appointed by Judge Court, July 2022 to present. 1 year mark, 7/11/23. 13 months, 365 days, 52 weeks summarized. 8 total months, 240 days and counting. Are, with absolutely no communication in any form, completely inactive. Total amount of hours, as court-appointed attorney, over 8.760. Total times met with me, the client, 6. Total hours spent with client, 7. Total phone numbers given to client from attorney, 2. Numbers that work, 0. Total time speaking to client via phone, 0. Total number of 15-minute video visits with client, 4. Total number of letters sent to attorney trying to communicate, 8. Total number of letter to the judge trying to communicate my unsuccessful communication with my attorney in hopes he will communicate with him to communicate with me, 7. Letters to other parties to communicate, 3. Total times in court, 3. 1 was an attempted withdrawal. 2 carry over and over. The last time I spoke with, saw my attorney, May 18th, 2023, which to be clear would mean that she saw her attorney last month. Where is the progress after 1 entire complete year? Unknown. Everyone, please look on the Orange County, Florida Clerk of Courts website to see for yourself. Am I looking at it wrong, reading the contents incorrectly? The mass majority of, quote, work seems to be from my correspondence. If not my letters, there's minutes, some live, to view my non-progressive, lackluster court dates, stating the same information and same continuances, and, of course, none of my comments, concerns, or questions from any. I don't just sit there, edited, like my case. Of course, it seems like nothing is going on in the case. The trial hasn't started. Her lawyer, the one she has harassed and directly claimed is working with channels like mine to undermine her, has worked over 8,000 hours trying to put together a case that is ready for trial. He is working on the case, and according to him, they aren't ready to argue the case in court. I feel it important also to communicate to everyone so you understand the undertaking it is for an inmate to attend court and why it is so important to me to have progress to report to make the day count. We are woken up at 3 a.m., taken to a holding cell and wait plus 4 hours, then taken to the courthouse and put in another holding cell for however many hours until court time, for only a 5 to 10 minute opportunity in front of the judge to say anything, if at all. Then taken back to another holding cell, wait for however long, then taken to another holding cell, then back to our dorm. Most court dates are court days, spending between 8 to 14 hours for little to no time to speak. It's important to me/us. We matter. Hence my letters. What will be said for this one, I wonder? I'll tell you what will be said. So, if you remember our initial coverage of the letters, Sarah was first annoyed that she wasn't attending these pre-trial conferences, which consist of the judge asking Sarah's lawyer if they are ready to proceed with the case, them saying they're not, and then stating that they need more time, and then the judge deciding when to reconvene. She was not being brought to these pre-trial conferences because she wasn't needed, and they took about 5 or 10 minutes. She demanded that she be there, and now she is complaining that she is going and nothing is being done. Again, the bulk of a lawyer's job is done without the client present in their office, putting together a case. But because Sarah can't see that or be a part of that, she doesn't believe it to be true. If she doesn't want to go to the pretrial conferences, she doesn't have to go. Her attendance is not mandatory, and it's more than likely neither the judge nor the lawyers involved with the case want her there. Like Lois looking to the skies for Superman, I'm hoping/praying for any attorney to step up and truly represent me with honesty, intensity, understanding, respect, and perspective. When they introduce themselves, they can me, also the real me, properly. Not the Frankenstein monster I'm being so wrongfully and incorrectly pieced together from all the propagandized, lucrative defamation and attempted destruction of my character and still intact integrity. Clearly, also, everyone can see all of the aforementioned information regarding my attorneys was not ever a strategy of mine, nor will be. It is a strategy of the judge in court? Man, I don't know what the fuck she even means. Judge Wooten, will I be included, please, in my upcoming, quote, status hearing prior to my PTC, which is also the 1 year mark of attorney number 6, on 7/11/23? Will I be permitted, I was not, attendance from you, like all the news channels and professional YouTubers? How's it going? I hope I finally see my attorney, whom will I'm sure tell me as you so graciously explained to me in my last PTC I was made a part of. consuming my minute minutes of your invaluable time that you and he have other clients. I am a client and have been for over a year with this attorney and paid tax dollars to utilize all of my available resources, including and not limited to a state or government attorney appointed by the court. And you will always have clients. You never know when you may become one yourself. Please do not discredit my truth. I am who, not what. Respectfully and diligent, Sarah Boone. To summarize, she hates going to court dates, believes they are a waste of time, but she wants to go to each one. Her lawyer won't meet with her despite seeing her last month and going over their strategy for the case, which she doesn't like. And none of her lawyers are any good and is still holding out for a new one, despite the fact that she also thinks Judge Wooten is corrupt and, per the letter before this one, is working with YouTube channels like mine to make money. She wants to go to trial so she can see progress done in her case, but also wants a new lawyer who will do everything she says and argue the case in the way she wants to, which is a terrible idea. And that's where we are. Again, her perception of the world is so entirely wrong, it's almost unbelievable. So if you've made it to this portion of the video, thank you for being a patron, and more videos will be coming soon. Welcome back to another video going over more of Sarah Boone's correspondence from prison. Today we are going to be covering the case updates, specifically the fact that Sarah's sixth attorney has, for the second time, filed a motion to withdraw. The first time her counsel filed a motion to withdraw was in December of last year after speaking with Sarah and noting her dissatisfaction with his representation. Frank J. Bankowitz is a court-appointed attorney, which means that at any given time, he has a plethora of other clients he needs to attend to, and is likely in court, representing another party. Unlike many private attorneys, Bankowitz does not have a significant amount of time to dedicate solely to Sarah, and for months she has complained about that fact, reportedly writing to the judge that Frank should be reprimanded for not doing his job. The judge has not reprimanded him, as he has done nothing wrong. In his original motion to withdraw, Frank wrote the following: "Comes now Frank J. Bankowitz, Esquire, counsel for the defendant in the above-styled cause, and hereby requests that this court enter an order permitting court-appointed counsel to withdraw from this case and from further representation of defendant. In support of such motion, the undersigned states to the court as follows. Number 1. On or about July 11th, 2022, the undersigned was court-appointed to represent the defendant in the above-styled causes. Number 2. Due to irreconcilable differences which have arisen between the undersigned, his client, and his family, the undersigned will be unable to effectively and properly continue representing the client herein. Wherefore, undersigned counsel respectful requests his honorable court enter an order granting this motion to withdraw as counsel for the above-named defendant." Meaning in layman's terms that Bankowitz wouldn't be able to dedicate enough time to Sarah as he was going through family issues. Upon reading her letters, these issues could be a surgery he was going into that required him to take off work, or a family matter that we weren't privy to. In some of her correspondence, she also alleged that this time was used for a vacation, but there was no evidence of that. This order was above board, and basically reiterated what Sarah had stated in her letters previously. He wouldn't have been able to give her case the attention she so desperately needed, and she would be better off working with someone else. However, the main issue with this case has always been that Sarah wants someone who will work full-time on her case, someone who will be available to take her calls daily and simply act as an extension of her in all ways, but she cannot afford that. The first lawyer she had was a private attorney, one that her ex-husband had gotten for her, who could dedicate all of his time to her. But they couldn't afford that, so she was forced to use court-appointed attorneys time and time again. She refused to temper her expectations of them and would routinely talk down to these attorneys, accusing them of not listening to her or sabotaging her case, and in the end, they would all file a motion to withdraw, citing irreconcilable differences and leaving it at that. Judge Wayne C. Wooten has seen this time and time again with this case, and it's prevented the case from going to trial for 3 years now. Bankowitz's initial motion to withdraw 8 months ago was denied, and for the past 8 months, he has attempted to work with Sarah while working with his other clients. But as noted, nearly every month, Sarah will write a letter disparaging him in the court, claiming to be a victim of the American legal system, and placing the blame squarely on his shoulders because he doesn't make enough time for her. And so, before we read Sarah's latest correspondence to the public and the court, we will be reading his new motion to withdraw and seeing how it differs from his previous. Comes now. Frank J. Bankowitz, Esquire, counsel for the defendant in the above-styled cause, and hereby requests this court enter an order permitting court-appointed counsel to withdraw from this case and from further representation of defendant. In support of such motion, the undersigned states to the court as follows. On or about July 11, 2022, the undersigned was court-appointed to represent the defendant in the above-styled causes. Number 2. Due to irreconcilable differences which have arisen between the undersigned and his client, the undersigned will be unable to effectively and properly continue representing the defendant herein. Number 3. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Miss Boone's case. Number 4. The undersigned has been in murder trials over the past 60 days and is presently defending a capital murder case in Lake County, Florida, which absorbs all of his time, including weekends. Number 5. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. So, that motion to withdraw is incredibly different from the first one. The first one is extremely standard, giving us the reasoning without emphasizing any of the differences Sarah and Frank have had. It doesn't attack Sarah's character, but it does show there are issues, and they are bad enough that it would be in her best interest to work with someone else. But this one, it names names. It tells us why he is leaving, and we get a sense of why communication has been so difficult. Frank, his team, and his office staff have no doubt communicated with Sarah that he has been in court the last 60 days, and the fact that he has other clients has been communicated to her by the court itself, but she has written countless disparaging letters, stating that he is a hack, and he is a terrible lawyer, and that she is going to be persecuted wrongly. And when we have gone over her letters in our videos, we have even heard from people who agree with her, not knowing the legal system and the workload that Bankowitz and lawyers like him are under. Her letters have no doubt led to Frank's reputation being hurt and harassment, which is what Sarah wanted to have happen. So, this latest letter, he is directly given reasons as to why he can't represent her, why this case has not progressed, and he is demanding to be taken off the case. 4 days after this motion to withdraw was filed, Sarah wrote the following letter. Judge Wooten, how do you feel about your attorney withdrawing? During an attempted video visit by a misrepresented, shifty reporter, this is how I was made aware of my attorney, Frank J. Bankowitz, cowardly and for the second time trying to ungracefully bow out of my case. Mr. Matt Johnson, please honor the integrity and ethics of a real reporter and not camouflage yourself as my friend in order to push your way through the rules and regulations of the correctional facility. Professional is also an option when scheduling, but clearly does not pertain to you. Just don't schedule at all, as I have nothing to report to you or court TV altogether. You're not even a real news channel, and only add to the confusion and hysterics wrongfully, illegally, and inappropriately concocted in my case. Do not contact. Pausing here. So, as always, after publicly disgracing her lawyer in a plethora of letters that she knows are being made public by channels like mine, she's upset that her lawyer has chosen to file a motion to withdraw without telling her. This is now the 7th motion to withdraw in this case, 2 being done by Bankowitz, and none being done with her permission. And she continues to emphasize the point that she believes her lawyers need to ask her before they do this. But let's think about the scenario a bit differently. Let's say you're getting a cup of coffee at a local coffee shop, and the woman in front of you orders a drink, takes a sip, then begins to get angry with the barista because she feels that her drink was made wrong. She causes a scene, begins bad-mouthing the service workers to everyone in the shop, purposely spills her drink, then starts filming herself, now stating that her coffee was purposely made wrong and she's being poisoned by the employee. The workers are then well within their right to stop working with her and kick her out of the store. Moreover, they don't have to ask said person if they consent to being removed from the store, because their behavior is so abhorrent. To be clear, Sarah is that person. She has disparaged her lawyers, called them constantly, even when they have told her that they are in court and cannot speak, and she has repeatedly claimed that they are conspiring against her to put her in prison. Them reading her letters, reading how she believes they cannot do their jobs and cannot possibly handle her case is cause for them to withdraw. You can't really take back those words, and if you tell your attorney that you don't believe they are the best suited to help you, they will leave the case. You cannot insult someone's work, then expect them to keep working with you, especially in the criminal justice system. The fact that she doesn't understand this basic concept is astounding, given her age and the fact that this has happened now 7 times. From my perspective, I am surprised my attorney is trying it again to give completely. No. Is it a blessing? Yes. Let's be honest. Frank J. Bankowitz is a dud of an attorney. He's unprofessional, hides, lies, and is disrespectful. I had a feeling when other attorneys spoke about him and winced, signed, or rolled their eyes, saying they have some of his clients. And after dining his 3 public reprimands, I announced to the court, in which he said pissed him off, being the reason for his first attempted withdrawal. This was going to be an adventure, but nonetheless hoped for the best. Unfortunately, I seem to have gotten the worst. Thankfully, there are many other professional and scrupulous, valiant attorneys still available, and hopefully, after all my previous letters and 6 withdrawals to date, not by my choice, Judge Wooten, you will remove the blindfold this time when throwing your darts of justice at the "remember everyone has constitutional rights and should be treated fairly" dartboard. Okay, so we said this the last time she was assigned a new court-appointed lawyer, and complained about how she didn't think they aligned with what she demanded in her letter to the judge. But a judge is not a matchmaker. They do not go over your case details with a fine-tooth comb, pore over every letter you've sent them, read your birth chart, and then match you with the perfect lawyer that you're compatible with. They assign you a lawyer who has handled cases like yours in the area, who is available. You do not get to make demands if you cannot afford your own attorney. Please, thank you in advance for hopefully caring this time. Also, if you are insistent on continuing to be my judge, as revolution is supposed to happen every 2 years, I'm ongoing 4 now, and you've stated to me in your courtroom previously, I have not because I ask not, may you please observe and act independently as a judge and utilize your judicial authority to judiciously maintain forward direction or proper, lawful, ethical treatment in respect of the client in any case. Effective communication between all parties, especially the client and attorney, is being made productive, regular progress is being achieved, and all around fairness of and every aspect of constant. Alright. A judge is not a lawyer's teacher. They do not make assignments to the court and walk by their desks as they do them to make sure they aren't making any errors and provide them assistance. They do not hold the hands of lawyers and guide them through the legal process, though maybe they should because that might be kind of cute, or give them a cookie when they do something right. Also, might be kind of cute, and a demerit when they do something wrong. Asking a judge to supervise your lawyers because they are so incompetent is not normal, and again, is why every lawyer she works with eventually leaves. Moreover, she fundamentally doesn't understand that she is the reason the case has taken so long to go to court. Every single time her lawyers back out of the case and file a motion to withdraw because of her negative behavior, she's adding months, if not years, to the trial date. Her antics, namely her entitled and aggressive behavior, ensure that she will not see this case go to trial within the next year. But she's entirely unaware of that. In her mind, all of her actions, no matter how negative and bad, are justified. But anyone else's actions, no matter if they are well-intentioned or by the book of the law, are all malicious, evil, and worthy of scorn. Aren't you tired of getting my letters, always asking about the same questions, concerns, and drab information? Please do not ignore and avoid what I have to say any longer, as I'm sure the taxpayers are unapproving of their tax dollars, mine too, being wasted for all my attorneys that you keep blundering. Once more, she is unable to take personal responsibility. Everything is someone else's fault. Everything is because of someone else. She left Jorge in the suitcase, but that wasn't her fault. That was Samsonite. They were just playing, and it was an accident. Her being arrested and going to jail, the police are corrupt and don't understand her. Her first lawyer withdrawing, her dumb ex-husband can't afford to pay him and pay for their children's schooling. Her second lawyer leaving, he was a coward who sucked and didn't have enough time for her. So on and so forth. And you know what? This whole case reeks of Big Suitcase. I bet this whole thing's being funded by Big Suitcase as we speak. But I digress. People like this who have a victim complex can never see their part in any negative action, and they're truly exhausting to be around. They refuse to acknowledge any of their bad behavior, or believe that the world simply happens to them. She had 7 lawyers leave her case. That's not her fault, it's the lawyer's fault, or it's the judge's fault, and her ex-husband's fault, and the governor's fault, because she went so far as to write them a letter too. And who is even saying that Sarah travels? Is there any evidence that Sarah wants to travel or has any intention to travel? So why would she even have a suitcase? I don't think Sarah's even seen a Louis Vuitton Horizon 55 brown monogram suitcase. And you know what? I don't even think Sarah wants to see a Louis Vuitton Horizon 55 brown monogram suitcase. But I rest my case. It took almost 14 months before my I told you so moment with Bankowitz and all my other attorneys, 42 months total. Please also see finally the absolute unfairness, fabrications, impediments, illegalities, and dysfunctions ongoing in my case, and how truly, unmistakably ransacked by the quote justice system and perverted by the whole world my entire case has been and become. Add yourself to the mayhem, hype, and added difficulties. Just so we have a comprehensive list, here are the people that Sarah blames for Jorge's murder and her being in jail. Jorge, her ex-husband, the police, her 7 lawyers, the judge, YouTube, everyone who has watched any video about this case, court TV, any YouTube channel that has discussed the case, the news, the justice system on the whole, the mayor, the governor of Florida, and you watching right now, and the only person who has been left off the list, notably, is herself. Which is weird because she is the one, why do I have to say this? Because she is the one who put Jorge in the suitcase and locked him in there for 12 plus hours to suffocate. What, did he fucking slip and fall? Oh, I'm slipping and falling. I have an unfair opportunity and everything with all the predisposed, non-permissive, illegally distributed, case-altering, sensitive information and details spread globally for everyone's viewing except me. My hand is known before the cards are even out of the box. There's not a bell anywhere that hasn't already been rung for all to hear. Seeds have been planted, all illegally and unfairly. For the monumental amount of time, allowing the world to abuse and devastate my private case information, lack of proper orders, not having an appropriate attorney, and non-existent security and protection of any kind, for all said information becoming so easily mutated and, quote, shared without my permission and before my trial, it is unfair and unlawful that a heavily prejudiced, ignorant, incorrect prejudgment has been made as a result. This could have been stopped, lessened, or averted if someone was doing their job correctly. I am still doing mine by telling you so. I am not wrong. But she is wrong. The issue, Sarah, because I know this has been explained to you many times, is that you killed a man in Florida, one of the states with the most open sunshine laws in the U.S., which means that any person can request to access police files, recordings, or footage and be given it with no questions asked. As mentioned in our first video going over her letters, this is the reason why we see so many Florida man/women headlines about some wacky crime happening. It's not because Florida is insane and everyone there is constantly committing crimes, it's because reporters can easily access police records and documents for their stories. No, still, I believe it all depends on how much money, notoriety, and benefits anyone and everyone can get for themselves and however, no matter the destruction caused or the ominous, irreparable shadow made along the very lucrative way. A system for all the wrong reasons. Alright, so 3 pages in and Sarah is once again accusing the judge of being crooked. Sure, that won't affect anything else going forward. As for Bankowitz and his irreconcilable differences, this means because I asked again about his phantom phone numbers and any progress occurring since not speaking to him in months and after. 408 days, 58 weeks, 9,792 hours of his representation, from only his date of his appointment, 7/11/2022, to withdraw attempt, 8/22/23, with only 6 in-person meetings, totally 7 hours out of 9,792, 4 to 15-minute video visits, and 2 phone numbers given, 0 working, 0 calls answered, 10 letters from me, client, trying to communicate with no response, 8 letters from me, client, to judge, no response productively, 4 letters from me, client, to my investigator asking him to attempt communication on my behalf to Bankowitz, 5 unknown attempts by my investigator, see letter 8/2/23 letter, by himself directly and on my behalf, no response, 9 attempts made by outside sources on my behalf, including phone calls, voicemails, and emails, no response. Also, trying to use recycled components in my case, no discovery, witness list, research, orders, instructions, records, depositions, downloads, etc. after 13 months. Nothing by confirmation of his lack of professionalism, principles, disrespect, lies, and not caring. And please note, 11 out of 13 months are with no communication. None in any forms. The only, quote, difference is I want progress, productivity, honesty, respect, and results. If he were such a professional attorney from the beginning and not selling me on his stable of witnesses, historical background, and all of his abundant resources, he wouldn't be still avoiding and cowering behind his now 2nd attempt to withdraw, number 2 promotion to withdraw. He's not cowering or avoiding her. He is literally actively working another capital murder case which requires his full attention. Clearly, everyone can see, anyone not lobotomized, in my slides, would be highly unsatisfied with Bankowitz's overall performance as an attorney. See prior data, and no dedication has been made on his part in my case or any productive progress or effort. What times has been put forth solely? The 7 out of 9,792 in 13 months? Again, this man is constantly working other cases. He's a court-appointed attorney. He cannot make a living off of working for Sarah, and she can't pay him. Moreover, his work can only really be done away from her. The reasons that they haven't had so many in-person meetings is because he literally can't do that. In his motion to withdraw, he cites that she will not be satisfied unless she is working the case, and she proves that to be true. She wants to be her own attorney. She wants to be in charge of what is said in the case, as well as what is asked and how it is done. The concept that he worked on her case without her present, without her behind him telling him what things meant and how to think, is unbelievable to her. As I reminded Bankowitz during one of 4 video visits and him repeatedly telling me how, quote, busy he is with all of his other murder cases after, again, no communication for months, I politely raised my hand to the camera where he could see and said, "Murder case. I am your client also, and have been. When do I get to go to trial like all the other clients?" He said he had to think about everything and disconnected. No word since. 100 days later, except for the withdrawal I learned about from court TV and not him. Okay, so she's lying. Within this letter, she lied. I'm not terribly surprised, but the fact that she can't keep her story straight for one letter is kind of silly. Sarah stated that Frank is callously uncommunicative with her, that he would disappear for months at a time, never telling her where he is going or what he's doing, so she would be left calling him repeatedly, hoping for an answer. However, she just said that he has told her directly that 100 days ago, he told her he had his hands presently full with a case that was about to go to trial, one that he has been in for the past 60 days. He wasn't telling her that as an excuse. He was telling her that because he was telling her that he wouldn't be able to speak to her for the next coming months. So the last couple of letters that she has written, asking where her lawyer is and complaining that he is being callous and rude, she knew where he was. He was in court for another case, and he told her that, but she ignored it because in her mind, she is his priority. Mind you, her asking when she will go to trial is rich, because her trial would have been over and done with already, had she stayed with any of the lawyers that she had gotten prior to Frank. Judge Wooten, with everything I have stated and all my information produced to you, and all my previous letters so you are aware, clearly Bankowitz should not continue being my attorney. Wouldn't you agree? Clearly, you should have listened and reviewed much earlier when I was trying to communicate with you 10 letters ago, just about him. Please listen and include me going forward. It is my right. With that being said, and because in the past you have stated to me you have other priorities, not allowing me rightful, appropriate time to speak in your courtroom, when I am allowed permittance to my meetings, and I am on your schedule for that day, 4 times going to court with Bankowitz, total times with all other attorneys, 3, 7 times in ongoing 4 years. Number 1, April 29th, 2022. First attorney withdraw attempt. Judge made revised twice. Number 2, May 10th, 2022. First attorney withdraw attempt. Agreed and granted. Trial was 5/23. Number 3, December 17th, 2022. Sixth attorney withdraw attempt. Denied. I never even knew about this until stated in court during status hearing. No copies received yet. Number 4, February 10th, 2023. Status hearing. Carryover. 5, March 31st, 2023. Status hearing. Carryover. Number 6, May 25th, 2023. Status hearing. Carryover. Judge stated I was delaying trial. Me. Hence, my letter, dated 6/29/23, hand-delivered, second copy, 7/21/23. Number 7, July 21st, 2023, status hearing, carryover. Judge stated he has other priorities for the day when I was trying to address the court. Please grant Frank J. Bankowitz motion to withdraw as my attorney. I, Sarah Boone, permit Judge Wayne C. Wooten to release Frank J. Bankowitz entirely from my case for obvious aforementioned reasons. Stated. I will allow withdraw when it should be termination. We all know it, me and my hope. Next. Sarah is exactly the type of person who goes into a restaurant or store and tells the service workers that because she is paying for her meal, they technically work for her. The judge does not answer to you, Sarah. In the meantime, of my selection of my next attorney, aim please, and also going forward. Please enable and support me in trying to utilize my constitutional rights and as a proud citizen of the United States, and stop willingly, actively allowing the violation of said rights. See previous letter dated 5/5/23. Please include me. Please listen to what I have to say. No one else does or has. It is my case. Hopefully, futuristically with a better, more appropriate, professional attorney of your choosing. Less letters, if any, will be generated, and more time you will have to dedicate to all of your, quote, priorities you made known to me in the past. Please know also, Your Honor, I know I am not a priority, as you condescending and incorrectly stated, nor am I making myself out to be, or ever have been, in anything my entire life. In one of the pretrial meetings, assessing if the lawyers were ready to take the case to trial, the judge, who had other cases on the docket, said that this case was not his highest priority that day, because he already knew that Sarah's lawyer wasn't ready, and they weren't going to be making any big decisions involving said case. Sarah, in her delusion, took this to mean that the judge hates her and doesn't think she is a priority in anything, that her life is worthless and she should basically stop existing. The leap in logic you would have to make is not insignificant, but she is going to use this statement as proof that she is being victimized by the criminal justice system. I am a client to my attorney, now 7th and all prior, an inmate to the county jail and criminal case for your righteous judgment still. Clearly, after yet another letter from me and another withdraw, not by my choice, and 42 uneventful months later, still looking for the starting line, and 7 times more, nothing has been made a priority. Please help Bankowitz wipe the sweat from his brow and inform him that he can stop the self-sabotage. He is no longer my attorney. Amen. My perseverance is real. So is my truth. I can't wait to meet the bullseye. Court appointed. Audacious gratitude. Sarah Boone. 4 days after that letter, Sarah sent another one. Clerk of Courts, Judge Wooten. Anyone. So confused, so tired of the perpetual question marks over my head. As usual, thanks to the ongoing convolution of everything from no communication, no system not including me, and no care. And I can't ask my attorney because he's trying to withdraw again. I wouldn't get a response anyways. It's funny how the only piece of correspondence via mail I have actually received from Bankowitz is his own motion to withdraw as counsel number 2. Judge Wooten, please clarify my requested information as follows, so I, the defendant in my case, can prepare and plan accordingly. What is going on? This information in question is all I have from an outside source looking on the clerk's website to keep me updated since no one else will. I have tried to dilute some time of the question marks, but need you, Judge Wooten, to help me get it correct and begin my preparation. Please clarify and send copies for. Filed July 21st, 2023. Title, Notice of Hearing. 4. Pretrial Conference. When? September 8th, 2023 at 9 a.m. Defendant received copy? Yes. Is the defendant attending? Unknown. Why didn't I receive a copy from attorney? Filed July 26th, 2023. Title, Notice of Ex Parte. 4. Notice of Ex Parte. When? September 8th, 2023 at 9 a.m. Defendant receive a copy? No need copy. In defendant attending? Anonoa. I thought the pretrial conference was on this date. Is this meeting for the recycled psychologist? Why didn't I receive a copy from court? Why didn't I receive a copy from attorney? Filed August 22nd, 2023. Title, Notice of Hearing. 4. Status Hearing. When? September 15th, 2023 at 9 a.m. Defendant receive a copy? Yes. From court. Is defendant attending? Unknown. Is this for the motion to withdraw? It was filed the same day. If not, what for specifically? Why didn't I receive a copy from my attorney? Filed August 22nd, 2023. Title, Motion to Withdraw as Counsel. Defendant receive a copy? Yes. From attorney. Why didn't I receive a copy from court? Filed August 22nd, 2023. Title, Notice of Hearing. 4. Motion to Withdraw. Bankowitz signed document. When? September 15th, 2023 at 9 a.m. Defendant receive a copy? No. Need copy. Is defendant attending? Unknown. 2 meetings are already scheduled on this day. What is correctly happening? This was filed the same day as attorney's motion to withdraw. Why didn't receive a copy of this from him also? Why didn't the court send a copy with the status hearing notice filed the same day as motion to withdraw? Which date is correct for actual notice to withdraw? Again, what is going on and when? I rarely am included in on the certificate of service for any document filed, or anything else. I should be an automatic inclusion. Please send revised and/or all correct copies of the aforementioned documents, so I have for my records, and is the only way I know unless able to find an outside source. Again, receiving copies of notifications, updates, schedules, everything to all of my meetings/conferences should be automatic so I know. It is my right. Please include. Finally, am I really the only one who is trying to figure anything out for ND about my case to finally conclude? Should I, the defendant of all parties in my case, be included overall and receive necessary needed copies? Please clarify everything, Sarah Boone. I think the issue that Sarah is running into here is that she believes she is the smartest person in the room, when in fact, she's not. The issue is, all of the filings are easily understood to anyone working in law. Because she has no experience with the legal system, and thusly is ignorant, she needs everything explained to her as if she is 5. The reason that her lawyers and the judge don't want her in the courtroom and don't want her to take an active role in her own defense is that it would mean they would have to explain every little thing to her and go over how the status hearing and pretrial conference are happening on the same day at the same time because they will be discussed by all parties at that time and date, and it's not a clerical error. They would have to stop and explain extremely simple concepts to her, and because everyone else involved doesn't need those concepts explained to them, Sarah would believe they are lying to her or withholding things from her. To be clear, I do not think we will see this case go to trial before 2025. I think Sarah will get another court-appointed lawyer, and she will likely bash them the same way she has bashed Bankowitz, and I think, like them, they will leave the case. I think they will also have to do multiple motions to withdraw, and I think at the end of the day, Sarah will be put in a position to where she feels like she has to represent herself, because the whole system is corrupt, and she is the only person with the gumption to stand up for what is right.
You know, I know the court's in a difficult position, but at this point, we're at that impasse of, if she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
Okay. Ma'am, you said there was something else that you had other than a 58-page submittal or letter. What other information is it that you're seeking to have me take a look at?
It's things that I've been working on in the meantime. It's things that she likes to tell me is not necessary, but I know for a fact it is necessary. She likes to, in quotes, put things to rest all the time and constantly tells me I'm not having this conversation with you. So I'm not going to waste my time, and I, being in jail, have supposedly abundant amounts of. She's not going to waste my time because she's not going to explain something to me. And I have taken it upon myself to explain it to myself because she refuses to do so. I don't understand what it is that she has against me. I have told her from day one that her snotty attitude was inappropriate, and I try very hard to bear with her and her attitude. I don't know what it is that I'm doing wrong to her, but I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she's supposedly representing my life.
Okay.
Welcome back to another episode of Dreading, or if this is your first time here, welcome. Today, we are once again revisiting the case of Sarah Boone. While the case itself is incredibly cut and dry, with Sarah filming herself laughing at her victim as he lay dying, it still has not gone to trial 4 years after the crime was committed. Sarah still doesn't think she's done anything wrong. She believes that while yes, she did technically kill her boyfriend, and yes, she did film herself enjoying the fact that he was perishing, that she isn't technically responsible because, in her own words, she didn't mean to do it. In her mind, if you didn't mean to commit the crime, but still committed said crime, you should be let off with a warning and a slap on the wrists, especially if you were someone like her who did really well in school. That is almost a verbatim quote from her, which is really astounding. I'll leave a link to a playlist with all of our coverage of Sarah thus far in the description box down below. But be warned, that is over 5 hours of content, not including this video. If you have watched all of our previous coverage of Sarah, then you would know that the reason for this case not moving to trial falls squarely on her shoulders. Sarah refuses to comply or work with her lawyers, as they are public defenders who have other cases. Initially, she had a private attorney, who her ex-husband was paying to help her, but given her position in prison, he has opted to stop supporting her outright. After this private attorney, she began to use public defenders who Sarah admonished for not giving her case the time and attention it needed. We know this because Sarah began to write letters to the court, telling the judge in her case that her lawyers were working against her, which were lazy and stupid, and that she was being railroaded. She would also remark that it would be impossible for her case to go to trial because of coverage like our own. She would say because millions of people have watched the video of her laughing as her boyfriend lay dying, she would not get a fair trial, and she should be released from custody post-haste. Those initial letters regarded the judge in her case as being fair and noble. However, when he refused to give her what she wanted, her ire turned his way. In later letters, she would state that he was corrupt, that he was personally profiting from the continued coverage of her case, and that she was going to be writing to the governor of Florida regarding the matter. Again, she framed this as being a sort of trump card in her letter, as if she was telling a barista that she was going to call corporate over a bad coffee and get them fired. It would surprise only Sarah that that didn't work. At the time of recording, she has gone through 8 different lawyers and accused them all of ignoring her and not giving her case the time and attention it needs. She has accused the original judge in her case of being corrupt, and has even gone so far as to state that her ex-husband was somehow behind why she is still in prison. Our comprehensive coverage of this case and the previous letters will be linked below, should you want to hear her statements for yourself. We last covered Sarah 8 months ago, when her 7th attorney asked to be removed from the case, citing irreconcilable differences. Notably, this has been the 2nd time that the lawyer has asked to be removed, given the first time they were told by the judge that they needed to try and work things out with Sarah. Since that time, the judge on the case has changed from Judge Wayne C. Wooten to Michael S. Kranick. Directly after the new judge was assigned to the case, Sarah wrote the following letter. January 19th, 2024. Honorable Judge Kranick. Finally, a new judge. It's strange how the Lord works, as I was in the process of trying to disqualify Wooten after being my judge for 4 years, and me still incarcerated with nothing new to show other than 7 different attorneys, not by choice. News clips of me walking in and out of the courtroom and everything relative to my case permitted to be slathered on the global internet, and in which I have not seen myself. So, pausing just for a second, we're already starting off strong. Immediately, a few things jumped out at me about this letter. First being that she is back to calling the judge in her case honorable. If you recall the first time we read out her letters, they were full of ass-kissing praise and reverence toward the initial judge. She spoke to him as if she were a kid, wrongfully sent to the principal's office over a prank. She stated he was a noble and kind person, and would obviously see that a miscarriage of justice was taking place and release her. When that didn't pan out the way she believed it would, he became the subject of her ire. If he refused to see her as a penitent victim, he would come to know her as a thorn in his side. She illustrates this for us by stating she was trying to get him disqualified before she ever actually went to trial. But to be clear, at least in this case, he hadn't done anything worthy of being disqualified. As we mentioned previously, Sarah is upset that details of her case, including these letters, are easily accessible to the public, and that there are people like myself who review their contents online. She believes that to be a violation of her rights, and that somehow the courts are conspiring against her. However, that's just what happens if you kill a person in Florida. Florida has some of the most robust sunshine laws in the United States, and that's the reason why you see so many examples of Florida man or woman, crazy true crime story. Sarah has been told that countless times by her lawyers, by the judge in the case, by channels like my own, and by people who watch videos like this one, who then feel compelled to write to her in prison. People have made her aware that she is not being unfairly targeted and penalized, but she refuses to acknowledge that fact. But it does not align with her need to be the victim in this case. She has shown herself to be incredibly narcissistic, so anything bad that happens to her has got to be the worst thing that has ever happened to anyone. As far as we are able to tell, she believes that the entire criminal justice system, including the previous judge and all of her lawyers, all conspired against her after she murdered Jorge, as well as illegally distributed the video of her mocking her dying boyfriend and having made millions off of her name. And how exactly have they done this? She doesn't know, but she is the hapless victim who needs to be saved in this scenario. Sarah has also reverted back to the statement, not by choice, which she has used in nearly all of her correspondence with the court in this case. We've seen this in other letters, where she recounts how her awful, ill-equipped, stupid lawyers keep filing motions to withdraw on her. In her perception of events, she has done nothing wrong to her lawyers that would make them want to leave her defense, and yet they keep dropping like flies. But therein lies the issue. Sarah wants to be allowed to publicly admonish her legal team, to say they have no idea what they are doing and are bad at their job, while still working with them. She only states that they are bad at their jobs because they are not doing what she wants when she wants them to do it, and believes that they will be more motivated to help her by doing so. What she doesn't realize is that that tactic hardly ever works when dealing with someone working alongside you, but it would never work with your legal team on a criminal case. If a defendant publicly states that they feel as if they are getting bad legal representation, that is cause for the defense to withdraw entirely. Every time she speaks ill of her lawyers, they have all almost immediately turned around to file a motion to withdraw, and have told Sarah that that is the reason behind their decision, yet she cannot accept that. In Sarah's mind, if she believes you have wronged her in any way, shape, or form, she is allowed to respond however she sees fit. She can tell people that you're stupid, you're bad at your job, leave you locked in a suitcase all night until you die, anything. The sky's the limit. But if you respond, you are the antagonist. No matter what, you are in the wrong, and she is in the right. I suppose you can kind of do whatever you want, but you do so at your own peril. You're really only allowed to do what she wants you to do. Anything else is an affront. But let's continue and see if anything I have said is substantiated. I felt he was the ticket holder to my overly hyper, illicitly distributed, misconstrued criminal case, and great reason I am still here. Again, ongoing 4 years and 7 attorneys later, not by choice. See letter dated 6/29/23 on clerk's website, while still waiting to properly elucidate the court. Alright, I'm pausing again. So we're back to this. Sarah is busting out her thesaurus for these letters, like she did in the first 3 she sent to Judge Wooten. This is how Sarah attempts to align herself with people she views as important. She did this when she was arrested and described herself as an intelligent woman who got really good grades in high school, despite the fact that she was multiple decades out from said grades and was a non-functioning alcoholic. Sarah isn't stupid. She knows that the judge in her case is an important person and someone she needs to get on her side. He needs to see her as a good woman in a bad situation and wants to help. So naturally, when addressing him, she's going to bust out her big words and try and indicate that she is too smart to be in prison. Continuing on, while still waiting to properly elucidate the court, public, and world, and after whatever the dysfunction was in the attendance part of my most recent pretrial conference/status hearing, which I am trying to ensure my automatic attendance futuristically. Please see my draft motion that I included. I am still trying to have my attorney submit on my behalf. I wanted to bring to your judicial attention the following information so you and the world are aware it is not who I am ever delaying trial, as Wooten inappropriately accused me of doing in a past hearing, especially now that you've mandated a trial date to be had in May, with no further continuances, leaving less than 4 months to put together and complete what should have been done already. What happened in the 4 years prior? Please read all of my correspondence online. Pausing before we read Sarah's list, I think it's important to note that what Sarah is saying here is likely what she actually believes. As ludicrous as it sounds, Sarah's mind does not work the way yours and mine would. She does not see her own faults, and does not acknowledge them at all, which leaves her constantly scrambling for other people to blame. In her mind, she genuinely does not see the correlation between her actions and the response that she's gotten. She does not see anything wrong with talking poorly to her lawyers, writing essays to the court about how she is being undermined by her own team. And so, when they leave, saying that that is the reason they need to go, she simply doesn't believe them. Though we can see and understand that she is the problem in the situation, she cannot. But, continuing on to the list. To date, Winston E. Hobson has been my court-appointed attorney for 133 days and counting. To date, Mr. Hobson has only met with me 1 time for a total of 3 hours. To date, no phone calls have been received by Mr. Hobson, as his phone does not work properly for further immediate, much-needed communication to be made between client and attorney. To date, I have mailed 5 letters to Mr. Hobson, trying to communicate my urgent need to speak with him. To date, I sent 1 letter to the investigator in my case to contact Hobson to contact me to see if he can assist in correcting the phone problem, also to inquire when anyone is coming. To date, I feel I am not being included or heard or cared about in my case again from the continued miscommunication again with Mr. Hobson, and time-consuming, undiscussed entries being made on my behalf. The continuance I did not know about. The waivers of appearance I did not know about, along with other documents. and I am never sent copies of anything filed, so I know. I keep trying to tell him about, with no response furthering the already massive dysfunction in my 4-year case. So pausing here for just a moment again, Hobson is a public defender. The man is busy with cases just as pressing as Sarah's. He doesn't have time to guide Sarah on every filing that is being made and everything that he's doing in her case. Because, to be quite blunt, Sarah is still an idiot. By her own admission, she states that she cannot understand that locking someone in a fucking suitcase would result in their death, even when the person directly told her they were dying while they were dying. If he were to try to explain every decision being made in the case, why he needed a continuance, why he filed a certain motion, and everything he is doing, that would take an ungodly amount of time, especially since Sarah believes that if she continues to state that she didn't mean to kill Jorge, she will simply be released. If she wants a more hands-on approach, where someone is being paid to hold her hand and explain legalese to her, she would need to get a private attorney. In my opinion, one of the main issues that keeps popping up in this case is the fact that Sarah believes she is a legal expert, or at least as intelligent as her lawyers. She thinks she can mentally keep up with them, and that everything she has to think and say about the case is vitally important. But to be frank, she has nothing of value to add. She weighs down the case with her idiocy, and even when her lawyers have tried to appease her, it doesn't help at all. Sarah continues on. I was hoping in the pre-trial conference/status hearing on Tuesday, January 16th, 2024, I could at least play catch up in the courtroom for 5 minutes, so many of my attorneys have done prior, including Mr. Hobson, and the one court date I've had for a continuance to express and emphasize the need for him to communicate and schedule a second very overdue meeting. I still have not even heard from Mr. Hobson about our missed pre-trial conference/status hearing. What's the status? To date, 1 out of 133 days and counting, attorney and his client have met. To date, 2 out of 3,192 hours, attorney and client have discussed partial general case information. To date, I still have not seen my discovery. Your Honor, when is the next status hearing, please? Especially since I/we were not at the last pretrial hearing/status hearing. And especially since I am trying to communicate with my attorney in more than one way to fully maximize and utilize the minute amount of time allotted before trial. My fair, appropriate, lawful trial? Pausing again, once more Sarah believes she is an asset to her legal counsel. She believes, despite everything and everyone in the world telling her otherwise, that she is the only one capable of creating a solid defense in her case. Sure, she recorded herself killing someone, but she can just easily explain it away. The only issue is that seemingly every lawyer in the state of Florida is incompetent and out to get her, which makes a lot of sense if you really think about it. I'll give everybody a moment to think about it. Alright, and moving swiftly along, whenever Sarah details all the ways she has tried to get into contact with her lawyers, it reads as harassment. Her lawyers have communicated with her, she just doesn't like how it's done, so it simply doesn't count again. She doesn't like that they are in charge of her case, so she admonishes them publicly, with the idea that they will bend to her will. So she's basically a nightmare. And every time she loses another lawyer, that's months of catching up her new lawyers have to play, trying to determine how they would argue the case and how they will handle Sarah's personality. It would be irresponsible and unethical for her to be assigned a new lawyer and immediately charged into court. But alas, she doesn't see it that way. She is the victim in this circumstance, so every time she writes a letter like this one, she is the scrappy underdog, fighting for justice. Meanwhile, it's her stupid fucking ex-husband's fault that she is in prison, or her lawyers, or that goddamn Judge Wooten. The onus of responsibility is never hers. But she continues on. I am still wondering why, though I've had to wait 4 years for something to finally happen on/in my case. Ask Judge Wooten. I wonder also, was I the oldest case on his docket? Either way, I'm still here, waiting patiently and very excited to get this highly anticipated, quote, show on the road. I await your overdue and very needed judicial direction, supervision, and intervention. Thank you in advance, Judge Kranick. Welcome. Sincerely, Sarah Boone. And that concludes that letter, and following said letter, Winston Hobson filed a motion to withdraw from the case. In his motion, he cited ethical considerations as being the driving factor behind not wanting to work on the case any further. Sarah was then assigned her 8th lawyer, Patricia Cashman, on February 9th, 2024, and for the next couple of months, things were radio silent on the Sarah Boone front. Usually, Sarah would write one long, scathing letter a month, detailing all the injustices she has had to face since killing her boyfriend, and how the entire system is set out against her, but she stopped. Everything was silent until June. According to the county clerk website, on June 7, 2024, a status hearing was held regarding the case, just to see if all relevant parties were able to take the case to trial. Since the withdrawal of her initial lawyer, all these conferences have been her lawyers asking for more time, stating that they aren't ready to go to trial, and detailing their issues with Sarah. But this time was different. Sarah had not written any letters to the court between February and June, but not because she was satisfied with her legal representation. According to the court minutes, during the status conference, Sarah stood up and spoke about her concerns with her new lawyer, Patricia Cashman. Cashman attempted to address Sarah's concerns, and Sarah responded by providing a 58-page letter to the court. Great. We are about to read this letter, but it should be noted that the same day of the status hearing, when this letter was given to the court, Sarah's lawyer filed a motion to withdraw. Once more, this motion to withdraw cited ethical considerations that prevented her from working with Sarah. So whatever is in this letter, whatever Sarah said in court was the final straw for Cashman. So let's tackle this monstrosity. I dig it. Sarah begins. Honorable Judge Kranick. Okay, pause. This is already interesting. Despite the passage of time that has lapsed since she last spoke to this particular judge, I was wondering if she would continue to hold him in such high regard, or if she would decide that he, like Judge Wooten before him, was a part of a larger conspiracy against her. It took a couple of letters for her ire to focus onto him, and seeing as she has been relatively well behaved, it seems he is still in good standing. For now. All this means is that this letter will likely place him on a pedestal. She will regard him as being her final hope, and attempt to endear herself to him. I also want to preface this by saying that she starts this letter writing in a form of cursive, so it's a bit harder for me to read. So please be a bit patient with me as I might get some of the words wrong. Okay, I'm probably going to get some of the words wrong. But Sarah continues on. Ongoing 5 years. Why can't I use my constitutional rights? Am I the only one who cares about the ongoing violations of, or have a bond? Okay, pausing again really quick. Her constitutional rights are fine. I haven't stumbled across any actual violations of her rights. And despite the fact that she is a murderer, I would have pointed those out. And the bond is an easy one. You can't bond out of prison, mostly because you murdered someone. You were considered a dangerous person who recorded yourself gleefully murdering someone, so that's why you were not allowed bond. Though it can change case by case in Florida. If someone is charged with second-degree murder, which she is, they are not eligible for bond. But again, she continues. Have all my medical records, have all my digital evidence and discovery, have all my paperwork, notes, letters, pictures, everything of mine returned by former attorneys, speak to my investigator, have a complete download of my phone, have any of my witness lists, give any insight, understanding, clarification, truths about my case, especially to my attorney, be listened to by anyone, especially my attorney, be respected for who I am truly, especially by my attorney, and not be disrespected for the mutated, malicious murderer all the world has falsely, incorrectly created and believes me to be? No, okay, pausing again. Sarah murdered someone. Even if that was an accident, her actions directly led to a person's death. That is an undeniable fact, with undeniable evidence that she created herself. The story of what happened to her has not been mutated or falsely represented. She locked her boyfriend in a suitcase when they were drinking. She drunkenly filmed herself mocking him as he pleaded for his life, and she left him in the suitcase to die overnight. Those are the facts, plain as day. There is debate on whether she meant to kill him or not, but her actions led to his death. Moreover, her legal team has access to all the discovery in the case. They are the ones putting together a legal argument for her, and they are actually competent enough to put together a case that could benefit her. Giving her access to all her medical records, the discovery, and everything else she listed would be highly irregular and only make things harder on them. She's not an attorney. She is a drunk who believes she is a genius. Giving her access to everyone on the witness lists and all the evidence would only allow her to do more idiotic things like witness tampering. Though anyone would want to feel like they have an active role in their own defense if they found themselves on trial for murder, that is not advisable in this case. Her giving insight on her case, as she so eloquently puts it, is her either lying about what happened and saying she didn't mean to kill Jorge, which is as stupid as it is unhelpful. And after seeing Sarah burn through 7 other lawyers, Cashman likely believed that if they were to examine the case without Sarah's input, they could provide a better, more succinct argument. Sarah wants to be treated like a lawyer and continues to get upset when the court points out that she isn't one. She continues on, be treated fairly, lawfully, and be protected by the quote justice system, properly, rightfully, completely defend myself. Bingo, there it is. Pausing again, we've been saying since our first video on Sarah that she desperately wants to represent herself and she will not be satisfied if she is not allowed to say and do what she wants at trial. She's not a lawyer, and she doesn't have the knowledge required to provide a robust defense. But she believes that if her lawyers acted as an extension of herself, simply doing and saying everything she wants them to do, her case would be wrapped up in a second and she would be a free woman. At every point in the case, she has shown that she believes that she can talk herself out of any situation, despite it never working, and now she is saying it outright. She continues on. See all and know the same as the world can and does, including my attorney, from all the phenomenal, non-permissive amount of my case being available online globally. Before my trial, and most important, before I have seen myself, what doesn't anyone know already about my case? How about my side on everything about everything? Be correctly understood that I am not the problem for reasons I am on malappointed by the court attorney number 8, see my letter 72123. Say what I want and should, but all the world can, and say it all wrong and warped? Why won't my attorney give me an honest answer? Show me everything she says she has and finished reviewing for my case, but withholds from me after I ask repeatedly for and about? Give me an answer other than, I'm putting this to rest. That's not necessary. Or, I am not having this conversation with you. Pausing once more, Sarah is telling on herself a bit here, because she has gone from saying my attorney isn't answering my questions to saying my attorney only answers my questions in these 3 ways. However, it goes a bit deeper than that. The phrase, I am putting this to rest, tends to be only used when a subject matter has been exhausted. It means her lawyer has said all she can on the matter, and therefore she is done talking about it. But Sarah doesn't like the answers she was being given. We know at least one of the subjects that this is about, that being videos like this one, discussing her case and court interactions. She believes that by people reading her letters, reading the court documents, and commenting on the fact that she's guilty, her rights are being infringed. She has said on numerous occasions that she believes videos like this one should be investigated because it's likely that we work with the prosecution and potentially the entire criminal justice system just to make a profit. In her last letter to Judge Wooten, she directly accused him of selling the video of Jorge's murder himself and demanding to know how much money he made. Her lawyers have likely explained to her on numerous occasions why that video is publicly accessible, why it is not grounds to dismiss the case, and why it being viewed millions of times does not directly mean her future jury will be tainted. But she does not like their answers, so she ignores them and pretends the answers were never given in the first place. When she asks the court questions, she doesn't actually want an answer. Sarah wants to be told that she is right and she is a victim, and to be doted on as such. She continues again. Grant me access to anything I ask her for in and about my case? Like the detectives in my case, stop putting words in my mouth? Tell me what's going on in my case. It's been well over 100 days. She has been my attorney, and I still do not know. Ongoing 5 years. Answer any of my questions. Ever ask me any questions? How can she supposedly know everything she needs to know from what she's been told, heard, read, or seen? Reassure she's on my side, not against? Why have I already been judged in the court of public opinion? How did that happen? Why have I been sentenced by anticipation and condemned before my predicted trial? Why does my attorney and all of the world think that my case is already over? Pausing again. No one thinks her case is over. In fact, most of the people who are apprised of the case details are waiting for the case to go to court with bated breath because they are both disturbed and amused by Sarah's antics. Also, I think this goes without saying, but most people believe she is guilty because she recorded herself taunting her dying boyfriend before he perished. It doesn't get more cut and dry than that. She continues. Your Honor, during our first introduction at my last withdrawal of court-appointed attorney number 7, Hobson, you stated to me your uninvolvement with any of my letters I write. I am still going to write my letters, as conduitely they are to the world where my potential jurors are located, and this is the only way anyone, including myself, knows the very necessary insight to my continued disadvantages, hindrances, impediments I am still experiencing on top of new, spurring my intentions to write. The race to the pulpit is unfair, and it is important to me that you are aware and understand what transpires when the news cameras are off, and we're all in between my, quote, status hearings. Alright, so pausing again. On the last page, Sarah spoke about how her voice is being squashed down by the system, and how she felt like she wasn't allowed to speak about her case while everyone else could. She thought it was unfair that her legal team had asked her to stop talking, because everyone else is allowed to say what they want. But here, she blatantly admits that she writes these letters with the understanding that they will be seen by other people, that the judge does not look at them, and that the only purpose of the letters is to speak to the world at large and tell them how she is being unfairly penalized. The issue is that she doesn't realize that her lawyers have told her not to talk about the case, and not to speak publicly for her own protection. They aren't trying to silence her. They aren't trying to throw her under the bus. They're trying to give her the best chance of getting out of prison someday. But Sarah is too stupid to realize that. Every time she opens her mouth, every time she writes a letter and accuses a new party of framing her, that is the evidence that the prosecution can use against her. These are issues that are going to be brought up in court to make her look paranoid and vindictive. One of her first lawyers has spoken about the defense strategy they wanted to use in this case. They wanted to focus on the abuse Sarah was put through at the hands of Jorge, and center their arguments on the fact that Sarah was a normal person who had simply made a mistake after years of torment. Their goal was to make her look fresh-faced, mournful, and timid, to present her as if she couldn't hurt a fly. But every time she writes a letter like this one, that defense becomes a harder sell. She's coming across as argumentative and aggressive, like she cannot handle when things don't go her way. She has too much pride to go along with her lawyer's strategy, so she continues to run on this hamster wheel, forcing her lawyers to withdraw, then using that as evidence when she claims that everyone is against her. She continues. 2. As so many of the advantageous embezzlers, racketeers, mindless lemmings, and just altogether mean people can use their quote-unquote freedom of speech, not knowing me in any way, other than what's being said by all the other mean people, and being said incredibly incorrectly, so can I. Pausing once more, it should go without saying that it is not mean to say that Sarah is a murderer, because she objectively murdered someone. That is a fact. Moreover, I do not need to know Sarah personally to say that, or to pass a third-party judgment on them. Similarly, people are not mindless lemmings if they watched a video of you committing a crime, then believe you to be guilty. Continuing on. As the compelling, annoyed detectives in my case, Copesal had to falsify documents, and Lowen wore his gun for me to see. I am sure you are familiar with after watching all of my plastered, highly misconstrued, over 30 million plus views just on one site, quote, interviews, and in which they both attempted to, quote, unquote, feed me their incorrect, incomplete, hypothesized opinion by stating to me, quote, everyone has their limits, at the seemingly endless point of perpetuity of nonsense and lawlessness, still growing, and I very much want to advance to the next level after ongoing 5 years now. A genuine concerned limit has been reached. Why am I still not being included in my case? How much more of my case and self is being added hourly, especially after this letter gets loose, to the internet, increasing the mass infection and destruction of my hopes to have a fair trial? Anything fair, my side foremost, and wondering now if my attorney, quote, drank the punch, just like everyone else. All aforementioned reasons, and so many more, for this letter to be written, hoping to deter some of the unfair, one-sided finger-pointing of corruption and malpractice being directed at me only by those in the, quote, justice, quote, system, who are trying to deflect the shame and shock from me fearlessly challenging the status quo. And it must be so, because it's in my face, on the computer at the same time, on my boob tube television, brainwashed, ignorant, followed of disbelief, conformity, and greed, trying unsuccessfully to make my life, by character assassination, seem worse than theirs. No, 2. When anyone points their finger, 1. It's impolite, and 2. 3 point back at you. How many tried to see? Put the stone down, as there will be no casting of anything together, except for maybe for the role of my part of the all pre-conclusioned, quote, documentaries, and crystal ball, real-life stories of, quote, true crime, incorrectly formulated from everyone supposedly knowing me and judging who they think I am, what really happened and is going to futuristically. Remember, 3 more point back. Soothsaying is not a real job. Alright, so pausing again, but throughout most of her letters, Sarah does a decent job sticking to a couple of ideas. Sure, what she is saying is mostly nonsense and her trying to validate murder, but she stays on topic for the most part. But here she really loses the plot. I might be daft, but I've yet to see anyone who claims to be a psychic talk about this case with any sort of authority. The only thing I've seen is channels like mine state they believe Sarah is either going to represent herself at trial or be held in contempt for her behavior. And each time they make it clear that these are just assumptions based on what she has already done. She continues on. To sum it up in the words of my attorney, after I told her to Google me, she stated, there's a lot. To sum it up in the words of myself, the defendant stated to my attorney after she stated that to me, when can I see? How much longer do I have to wait? Or how many attorneys must be withdrawn for me to be included in my case? And be included more than the world presently is. Pausing once more, after reviewing Sarah's letters, it's clear that she feels blameless in all areas of her life. Jorge dying, not her fault. Her lawyers withdrawing, not her fault. Her ex-husband not wanting to be around their child, not her fault. These are all random things being done to her. She has done nothing to earn. But that's not really how life works. If you had 8 competent lawyers working for you and they all separately withdrew, citing ethical considerations in your bad behavior, you would think that that would be cause for introspection, that you would take a moment to realize the way you've been handling yourself might be a bit abrasive, or that you had made multiple social faux pas. There'd be a bit of self-doubt, and you would be forced to examine if you are the problem in these situations, since you are the only common thread. But not Sarah. She does not live in a world where she can be wrong, or she could have caused any of this chaos. Sarah continues, "This is my case in every aspect. See all of my aforementioned ongoing 5-year questions I am still waiting on for answers. Also, I want to make it known, I walked out on my attorney in our last meeting due to her unwarranted, uninformative, unprofessional, snotty attitude and her untruthful answers to my questions and beyond. The quote, retarded vicious cycle we enter every time we meet is a waste of time. And I'm that being in jail with supposed endless amounts of. How she treats me is extremely prejudiced, hostile, and unconcerned. She is very frustrating. Number 1, to balk in defeat in an endeavor. Number 2, to induce feelings of insecurity, discouragement, or dissatisfaction in. Number 3, to bring to nothing. Alright, so pausing once more. As previously mentioned, whatever is said in this letter is so bad that her lawyer immediately filed a motion to withdraw from the case. But something that should also be noted is the fact that Sarah has talked this poorly about every single one of her attorneys, but never fired them herself. She will emphasize that much in this very letter, drawing attention to the fact that it's always the lawyers quitting on her, not the other way around, which poses the question, why does Sarah want to work with people who she doesn't have faith in? If you've ever been around an individual who acts in a similar way as Sarah, then you would know that they are prone to throw any and all accusations at the wall when they are upset with you. In my personal experience, it doesn't matter how small the perceived slight is. They will throw everything they can at you in anger. You could have implied they made a small mistake, and they respond by exploiting a sensitivity you told them about in confidence, only to downplay what they said and did afterwards. This is truly a linguistic ability that some consider to be unnatural, as Sarah doesn't actually believe her lawyers are bad. She doesn't think they are incompetent and unable to provide her with a good legal defense. She just doesn't like the fact that she isn't the one in charge. Every time they tell her no or rebuff one of her suggestions, she takes it as a personal slight, then feels justified in telling the whole wide world that they are bad at their jobs and should be disbarred. Does she actually want them to be disbarred? Does she actually want them to quit? Probably not. She just wants to hurt them for hurting her ego. Keep that in mind as we continue on, because despite everything she states, she doesn't actually want her lawyers to quit. Continuing on. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added, quote, pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. She seems, like everyone else, to not remember I am innocent until adjudged otherwise. She treats me as if I'm not. After my introduction and explanation with, quote, pretend judge, in the room or on the phone, I am trying to help her understand how she is making herself extremely unwelcoming when in front of a real judge, and in the courtroom is how she treats me, her client, at all times. I should not have to invent, quote, pretend judge, in order to be, and not at all wrong for wanting to be, respected, no matter the outcome. I am innocent until adjudged otherwise. My attorney, everyone's, should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. These lawyers should be automatic, they should be systematic, and hydromatic. Okay, but really, I should feel secure, highly confident, proud in her, quote, representing my life. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her inimical attitude towards me. I am hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, as so many unmotivated, overwhelmed, weak attorney prior who have bowed out ungracefully and crept away from the battlefield unsuccessful. What I also appreciate is that Sarah just put it all out there. She wants her lawyer to be subservient to her, to provide her with everything she asks for regarding the case, and to treat her as if she has done nothing wrong. But she has done a lot wrong. She murdered someone, she's in jail for murder, she has harassed 8 lawyers to the point where they quit her case, and she sees nothing wrong with it. The only way Sarah would be happy with a lawyer would be if they told her that they believe she is innocent, only responded positively to the stupid things Sarah is constantly saying, and never provided her with any sort of legal counsel. But she continues on. My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. This does not mean my case can't equal success in more than one way. While everyone else continues to ring their, quote, bells of malevolence, I am ringing mine of hope, honor, plausibility, boldness. Listen, I am not a murderer. The justice system should equal fair, faith, trust, respectful, innocent until and if adjudged otherwise. 3-point back, Sarah Boone. Heart, confused cat meme? Yes, thank you. So that is the end of the first portion of the letter, but it's far from over. I was originally going to read the entire thing, but as some portions are just legal definitions copied down, I will skip those portions for the sake of brevity. I will be leaving a link to the county clerk's website, should you want to look up the whole letter for yourself. The letter continues. June 4th, 2024. Video visit, 12 minutes. In addition to my previous letter, intended for hand delivery on 6/7/2024 at my, quote, status hearing, today my attorney made a video call to go over everything I've been asking her for, and I've also sent to her personally in 2 letters, 5/20, 5/25, all in the public video visitation box, where on both sides of me, other inmates were having their visits also. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having an in-depth, private meeting regarding my entire criminal case on the visitation box where there is no privacy whatsoever, and hold in an open bay dorm with more than 62 other interested, all-ears inmates. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried reminding her of my insecure environment, barking at me that I can listen or not, still going, over-speaking, and not at all allowing me to respond. Pausing again, in every other letter that we've gone over of Sarah's, she states that her lawyers refuse to speak with her at all. She talks about how she writes them letters. She has her friends and family call them at all times of day, but they refuse to correspond with her. But now we are getting a more detailed picture. She probably won't shut the fuck up. Sarah only wants to be communicated with on her terms. She wants her lawyers to come to the prison to reserve a private room and speak to her as if she is on a legal team with them. She wants to be talked to not as a client but as a peer, and the fact that they are not doing this is upsetting to her. The fact that her lawyer had the audacity to schedule a video visit instead of an in-person visit is too much for her to take. While it's not ideal to conduct a legal meeting via the visitation box, it's also not ideal to be in a prison awaiting trial for murder. Sarah doesn't have a lot of options, and the fact that her lawyer is willing to sit down with her once more to try and answer her questions is a good thing, but all she can do is disrespect. She continues, after repeating to her over and over and over while she's beginning to speak louder and over me, still to please schedule an in-person meeting where all can be discussed further, privately with no success of being heard, I disconnected the visit telephonically, she uncooperatively. She is impossible. See my previous letter or ask her for a copy of the 2 I sent to her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. My next question, please. Who acts like that and is still able to call themselves, quote, professional? Pausing again, there is something incredibly ironic about accusing someone of being unprofessional for trying to work with you after stating that you hung up on them. She continues, the visitation box is primarily for family and friends to connect, and, if a must, from an attorney. Reminder, notices, quick questions, not high-level confidential case information. She, like other former attorneys who always blame their dysfunctions on me, said, I'm trying to do this without yelling, you don't like the answers I give you. What answers? See pages 1, 2, and 3. I am not the problem, except that I want to and should be treated fairly with respect, acting more professional than the paid. I've been doing this for 40 years, professional. After so long, and in all the experience, common courtesy, customer service, and listening skills should have been acquired. Okay, so pausing again, but needless to say, Sarah kind of illustrates how she is the problem when she says all the things like this. But because she cannot see herself as anything less than amazing, she has to invent conspiracies as to why things aren't working out for her. It's not her fault. It's the 8 lawyers, and Judge Wooten, and Law and Crime, and Court TV, and so on. She is just a hapless person it's all happening to, and she is just at the center of it for some unknown reason. Having one lawyer who couldn't handle their caseload and wasn't equipped to take on her case is normal, but she's gone through 8, and they have all had the same experience with her, so she might be the problem. Sarah continues, all attorneys. Do you even remember why you even wanted to be one? Remind yourself, no one listens, and it works in everyone's favor but mine. That I am a murderer stuck in ale so they can pin on me. They're uninterested, unmotivated, hopeless. They're going to believe me over her haughty attitude. I am not wrong for not thinking less of myself because everyone else has and does. This present attorney foremost. The quote justice system expects me and other inmates, aka quote clients, to accept its subpar, nonchalant, hypocritical, quote next on the list, attorneys they keep aimlessly throwing darts for, and malappointing, praying they don't withdraw. I have not fired any attorneys appointed in my case. From me expecting the highest, equal standards possible for watching the absolute best outcome in my preposterous, mismanaged case. Alright, so pausing again, Sarah has lambasted each and every one of her attorneys, and just attorneys in general. She has said that they are lazy, they don't know what they're doing, they should be disbarred, they should undergo ethics investigations, and she said every lawyer's specific insult you can think of, and yet, she also contends that she would be okay with each and every one of them representing her. It's kind of nice. Put yourself in Sarah's shoes. You're on trial for murder, and you believe your lawyer isn't a lawyer at all. They're a sack. Maybe if you were incredibly depressed and thought there was no hope, you would let a lawyer who you felt was terrible at their job represent you. But if you believed you were some freedom fighter who was exposing a corrupt system through their case, you'd want to work with someone who you thought could actually help you. But not Sarah. She continues, and, quote, representing myself is not an option, as both judges have now threatened me with from being outspoken and intelligent in all my observations of the ongoing abuse I am and have experienced. I have no new experiences from it, always being the same, blame Boone. I refused to be moved and wanting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism. And another great reason not to have my case meeting on the public visitation box is my personal, confidential inmate information, such as my visitation lists with names, my interactions with other inmates and officers, when I eat/when, and my personal jail calls also being thrown online. For what? To hate me more, or to try and get others to, because I don't eat breakfast, or because I know some Latin, I have short hair, my penmanship is nice, or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate, mutate, splice, edit. The world apparently knows all. What's next? How many times I go to the bathroom and what function I perform? No one knows anything, nor seems to want to, from being comfortable in their corruption and striving to be, quote, on top with rating, web hits, and money. My case details, if anyone forgot, and if you think about it, all that keeps getting plasters and plagiarized. Okay, posted and poked fun at about me. It's all in my favor, proving myself right about all the mindless lemmings, shut-ins, the quote justice quote system, advantageously abusing and profiting from everything in my case/cases before my trial and before I've seen. Please be sure to read my attachment for FRCP Rule 3.220, parentheses E, restricting disclosure. Am I the only one who thinks of these things? When can I win? In anything. It's coming. I am not the problem. And if anywhere were to slip on my slides and had to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. Don't know till you try it. 3-point back. Race to the pulpit. Again, always. Sarah Boone. Alright, so skipping forward over some pages of her defining words like attorney misconduct and zealous advocacy, she then writes, the number grows daily. Most all letters and messages are available for review and understanding of the impact my case details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment before my trial. I The defendant in my case have not yet, ongoing 5 years, fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. The continuation of the obvious exploitation allows the world to keep pressing their incorrect, presumed unfair theories, ideas, accusations, forcibly insinuating I committed, quote, criminal acts. My present attorney said it's, quote, not necessary to receive a court order that I've been trying to obtain to download my case information to apply from the OCCD tablets. My former attorneys are withholding some of my case contents I have supplied to them, and which have been deemed lost. Many other items have been returned, but not to myself, but to the, quote, next attorney, and which have been unable to be located to date. I am missing innumerable case items, which I continuously request to be returned or obtained without success. Pausing again, she then goes back into defining legal terms that the judge and all the lawyers in her case would already know, before writing what she thought would be the most damning note of them all. This is her big closer. For some fucking reason, she needs a big closer right now. She continues, publicity, exploitation, and saturation. My personal, individual, quote, criminal case is being advantageously exploited and abused from all my significant, life-saving, suppressible case details, evidence, proof being illegally obtained by coercion, trickery, duress, confusion, and without my permission, in any form, written or verbal, to anyone, then broadcasted, distributed, hand-delivered to the entire planet. States, countries, continent, things that are on a planet, containing all my potential jurors, causing irreparable, erroneous, falseness, greeting, tainting my jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives, theories, and ideas. This obvious exploitation and invasion of my privacy is creating unnecessary, unlawful oppression, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion to my case. A misprejudgment has already been made unfairly against me from the undeniably violations of my constitutional rights and due process of law as a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully ethically should be without disadvantage and free from all partially deceitful and dishonesty made from said evident exploitation. Okay, so there you have it. Sarah Boone is still in prison, she is still harassing her lawyers, and she believes that everyone who has followed this case online is a part of a grand conspiracy to keep her in prison. This cause came before the court on June 28, 2024, on defense counsel Patricia A. Cashman's Esquire motion to withdraw as counsel filed June 11, 2024. The court, having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, having considered the positions offered by counsel Patricia A. Cashman Esquire, having considered the testimony offered by defendant Sarah Boone, and having considered the positions offered by counsel for state, hereby finds: A. On March 23, 2020, by way of information, the defendant was charged with second-degree murder. B. On February 26, 2020, the Office of the Public Defender, 9th Judicial Circuit, in and for Orange County, Florida, was appointed to represent defendant. C. On March 9, 2020, the public defender moved to withdraw due to the defendant retaining private counsel, to wit Mauricio Padilla Esquire and the Padilla Law Group. D. On March 11, 2020, that certain order allowing withdrawal was entered which withdrew the public defender from further representation of the defendant. E. On April 18, 2022, Padilla moved to withdraw due to irreconcilable differences between undersigned and the defendant that may have made it possible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. This motion was served upon the defendant and defendant confirmed receipt. See letter dated April 20th, 2022 and filed on April 26th, 2022. F. On April 29th, 2022, a hearing was held on Padilla's motion to withdraw. At the time of this hearing, Padilla had been representing defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from defendant, a letter dated April 20th, 2022 and filed on April 26th, 2022, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the options were not to proceed on Padilla's motions to withdraw and provide the court more about the irreconcilable differences. Padilla requested an opportunity to amend the motion to address the irreconcilable differences. The court reserved ruling on Padilla's motion to withdraw, gave Padilla until May 3, 2022 to prepare and file an amended motion with a hearing to be heard on the week of May 9, 2022. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. Defendant testified to a, quote, lack of trust between herself and Padilla. G. On May 4, 2022, Padilla filed an amended motion to withdraw, which supplemented the original grounds. Number 1. Undersigned's relationship with defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. Number 2. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client and as such will stand mute on the specifics. H. On May 6, 2022, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds. 1. Undersigned relationship with the defendant has deteriorated to the point where undersigned counsel can no longer give effective aid in the fair representation of Miss Boone's defense. I. On May 10, 2022, a hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. The court advised defendant of the state's concern regarding a strategy of defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. The court appointed the public defender, attorney number 3. J. On June 6, 2022, the public defender moved to withdraw due to a conflict. K. On June 7, 2022, that certain order allowing public defender withdraw was entered, which withdrew the public defender from further representation of the defendant and appointed the office of Criminal Conflict and Civil Regional Counsel. L. On June 10, 2022, RCC moved to withdraw due to a conflict. M. On June 22, 2022, that certain order allowing the Office of Criminal Conflict and Civil Regional Counsel withdraw was entered, which withdrew RCC from further representation of the defendant and appointed Mark Consolo. N. On July 8, 2022, the Consolo moved to withdraw due to a conflict. O. On July 11, 2022, that certain withdrawal order was entered, which withdrew Consolo from further representation of the defendant and appointed Frank J. Bankowitz. P. On July 12, 2022, Bankowitz, in open court, requested a continuance due to his recent appointment, and the same was granted. Thereafter, the court set a pre-trial conference for October 25, 2022 at 9 a.m., and trial during the trial period began November 7, 2022. Q. On October 25, 2022, the court held the pretrial conference and addressed the court's understanding that a continuance was being sought and the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. R. On October 27, 2022, Bankowitz filed defendant's motion to continue. S. On October 28, 2022, the court entered that certain amended order on defendant's stipulated motion to continue, which set a pretrial conference for January 17, 2022 at 9 a.m. and trial during the trial period beginning January 30, 2023. T. On November 22, 2022, the court set a status hearing on Tuesday, December 20, 2022 at 10:45 a.m. U. On December 19, 2022, Bankowitz moved to withdraw due to the irreconcilable differences which have arisen between the undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant herein. V. On December 20, 2022, the status hearing was held. Bankowitz did not appear due to a car accident, and the court reset the status hearing for December 22, 2022 at 11 a.m. W. On December 22, 2022, the reset status hearing was held. Bankowitz appeared virtually, and due to technological issues, Bankowitz was unable to hear the court. The court reset the status hearing for December 27, 2022. X. On December 27, 2022, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. The court advised defendant that the court had received letters from defendant. The court conducted a Nelson hearing, and defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the thousands of pages in discovery that he had reviewed and organized, and his contact and potential use of and collaboration with expert witnesses, including experts that Padilla utilized. Bankowitz advised the court of defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day. Oh, how does she have access to a phone that often when she's already in the jail? Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. In response, defendant reposted that Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands for lack of communication, alleged Bankowitz's action in this case rose to a similar level, and then sought to remove Bankowitz. The court pointed out defendant's inconsistent statements within minutes of them being made and addressed concerns over defendant's motivations, especially when there is something defendant disagreed with. The court specifically advised defendant that she is, quote, not entitled to an endless line of court-appointed lawyers until you find the one that you personally prefer. The court also explained the circumstances where the defendant could represent herself. Ultimately, defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with defendant prior to the pretrial conference previously set for January 17, 2023. Why? The case was continued several times due to Bankowitz's attempts to retain an expert through JAC and JAC's response to the same. Z. During this time period, the court had received several letters from defendant. On August 22, 2023, Bankowitz again moved to withdraw due to 1. Irreconcilable differences between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. 2. The defendant will not be satisfied with any attorney unless the attorney does not have a caseload and can delegate his or her time solely to Miss Boone's case. Number 3. The best possible avenue is to have the defendant represent herself as no attorney can satisfy her. BB. On September 8, 2023, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. Bankowitz addressed defendant's derogatory statements, i.e., dud, buffoon, and berating behavior. The court advised defendant that the court had received letters from defendant. After the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal, the court granted Bankowitz's motion to withdraw and appointed Winston Hobson. Thereafter, the court set a status conference for October 30th, 2023 at 10 a.m. and set a pretrial conference for November 28th, 2023 at 9 a.m. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankowitz. The court further cautioned that, quote, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make, i.e., go to trial and/or testify. The court cautioned as to defendant's unrealistic expectations regarding court-appointed counsel and reminded defendant of her right to retain private counsel, CC. On October 30th, 2023, the status conference was held. Hobson advised to his conversations with defendant and setting a status in January 2024. Thereafter, the court set a pretrial conference/status as to readiness for trial for January 16, 2024 at 9 a.m. and trial during the trial period beginning January 29, 2024. DD. On January 12, 2024, Hobson filed that certain motion to continue, waiver of presence, and requested a 3-docket continuance. EE. On January 16, 2024, the court addressed Hobson's motion to continue, granted same, set a pretrial conference for May 3, 2024 at 9 a.m., and trial during the trial period beginning May 13, 2024, FF. On February 1, 2024, Hobson moved to withdraw due to irreconcilable differences, including but not limited to ethical considerations, GG. On February 9, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis for withdrawing. including disagreements on legal strategy, on what can and cannot be done, a lack of resources, and defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. As to a key substantive defense, Hobson advised that the retained and undisclosed expert is not keeping with what defendant has in mind. The court advised defendant that the court had received a letter from the defendant. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, and Hobson, as well as adversarial relationships, lack of satisfaction, and inability to meet defendant's desires. The court found that all of the defendant's relationships with all of the court-appointed counsel have deteriorated such that defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has the right to court-appointed counsel, that right is not unlimited. The court twice advised defendant that defendant may not be provided another court-appointed attorney and that defendant would have to represent herself if the circumstances similar to Hobson's motion to withdraw occur. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training and knowledge. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. The court set a status hearing for April 12, 2024. HH. On April 12, 2024, the status hearing was held. Cashman advised as to the depositions that had been set, the hiring of an expert, and a request for a future status date to address a trial date. The court set a status hearing for June 7, 2024. 2. On June 7, 2024, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present for the hearing and was sworn. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed Cashman utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism. Cashman advised to her efforts and time spent on the case so far, 20 hours. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not legally be important. In riposte, defendant accused Cashman of lies and half-truths. JJ. On June 11, 2024, Cashman moved to withdraw, citing irreconcilable differences, including but not limited to ethical considerations that have arisen such that counsel can no longer provide representation. KK. On June 28, 2024, a hearing was held on Cashman's motion to withdraw. LL. At no time has defendant refused to accept the services of any of her 7 appointed attorneys. OO. A defendant in a criminal case can forfeit the right to a court-appointed counsel. QQ. As set forth above, defendants' recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on professionalism of Padilla, notably, over a year after the fact, see footnote 9 above, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of these attorneys were required to withdraw. RR. It has become apparent to the court that defendant will not permit herself to be represented by anyone. SS. Additionally, the withdrawal of 8 different attorneys, 7 of which were court-appointed, leads to a determination that defendant had forfeited his right to counsel. UU. As the court finds defendant has forfeited the right to court-appointed counsel, under Florida law there is no obligation to conduct a Feretta hearing, or to otherwise warn a defendant of the dangers of proceeding. VV. The court can find a waiver by conduct to right of counsel. A waiver by conduct requires that a defendant be warned about the consequences of his conduct, including the risks of proceeding. WW. On February 9, 2024, defendant was twice advised that another court-appointed attorney may not be provided. XX. On May 10, 2022, defendant was advised about the dangers of self-representation. YY. On February 9, 2024, defendant was advised about the dangers of self-representation. ZZ. As of February 9, 2024, the instant case has been continued 16 times. AAA. As of June 26, 2024, this case has been pending 4 years, 3 months, 5 days, from the date of the filing of the information on March 23, 2020. BBB. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over. Allowing defendant her 8th court-appointed attorney her ninth attorney overall, will only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought defendant's attention on May 10, 2022. Defendant complains that Bankowitz and Hobson, two court-appointed attorneys, failed to meet and communicate, and when defendant is provided court-appointed counsel who will meet and communicate Cashman, the ways and means of meeting and communicating are unacceptable to defendant. Number 1. Cashman's motion to withdraw as counsel filed June 11, 2024 is granted. Number 2. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for costs to obtain transcripts of depositions for the 2 witnesses Cashman deposed. Upon completion of the transcription of the depositions transcripts shall be sent directly to defendant, Sarah Boone, by Cashman at the Orange County Jail. Thereafter, Cashman shall file a notice with the court reflecting that the depositions transcripts were provided to defendant Sarah Boone, and such notice shall include the date sent and the address of defendant Sarah Boone. Number 3. Defendant Sarah Boone has forfeited her right to court-appointed counsel. Number 4. Alternatively, defendant Sarah Boone has through waived by her conduct her right to court-appointed counsel. Number 5. The trial management conference shall remain specially set for Tuesday, September 24, 2024 at 1:30 p.m. Number 6. This case shall remain specially set for trial for the 2-week trial period beginning Monday, October 7, 2024, and will not be continued for any reason except by extraordinarily good cause, or such extraordinarily good cause shall not include retention of counsel by the defendant. Number 7. Any and all pre-trial motions in this case must be filed no later than the close of business on Monday, July 22, 2024, done and ordered in chambers at Orlando, Orange County, Florida, this 28th day of June 2024. Welcome back to another Patreon-only episode of Dreading, or if this is your first time here, welcome. Today, we will be covering Sarah Boone's latest interactions with the court, which, you will not be shocked to hear, has become contentious. The last time we covered Sarah, she had written over 60 pages of complaints to the court, stemming from the belief that her attorney had a piss-poor attitude and was working against her. Those are her words, not mine. I make that a point because after looking into her last attorney, she is widely known for working alongside difficult clients, and being more or less a last resort of the court when a defendant is too hard to work with. The letter claimed that Sarah's constitutional rights were being ignored, and that she was being talked down to by her attorney, and that she was the only one in the whole wide world who knew the truth about what happened the night Jorge died. When she brought the letter to the court and attempted to defend herself, Judge Kranick asked her specifically what rights of hers had been violated, which she responded by stating her lawyer often told her that the things she wanted to discuss in regards to her case were not important, which, as you might have guessed, is not a violation of her constitutional rights. We read her second and third letter to Judge Kranick, where she continued to brown-nose him in order to get him on her side. But when he ultimately found that she had forfeited her right to counsel due to her antics, we theorized that when she wrote to him next, she would feel differently. And boy, were we right. Today, we are going to be reading her latest 7-page letter to the court, complete with an ad for an attorney to represent her, which, even if a lawyer saw this ad and responded, would be pointless. As the court had ruled, she has forfeited her right to counsel. As far as we have found, she cannot circumvent that ruling by trying to hire someone herself, or finding a lawyer to work with her pro bono. But as always, Sarah doesn't seem to understand that. Usually, we try to wait to cover these Sarah letters until there are at least 15 pages to cover, because then we feel like we can add more commentary. But given the overwhelming response to this letter, and the multiple emails we have received, we decided to take a break from our regularly scheduled content and make this video for those of our viewers who have taken the time to support us over here. So with all of that said, let us begin. July 8th, 2024. Quote, Honorable, unquote, Judge Michael Kranick. Alright, so already pausing a second, and so it begins. When Sarah had initially written to the judge in her case, Judge Wayne C. Wooten, she presented herself as a put-upon young woman with no history of violence who was being unfairly penalized by the justice system. She wrote her complaints about the court case so far, but with the belief that Wooten would see her plight and take pity on her. Surely he would see her using 3-syllable words and realize that she was well educated and a good woman who shouldn't be in prison for killing her boyfriend by locking him in a suitcase and laughing at him as he lay dying. That was something a bad person would do, and she got all A's in high school. She described herself as a victim and wrote to Wooten as if he were the only hope for salvation. However, as time went on, and she wasn't immediately given what she wanted, her tone shifted. No longer was she talking to a person who was going to, as she so hilariously put in her last letter, pick up the sword of injustice and fight alongside her for freedom. Which, even that, take it easy, Braveheart. But rather, she was talking to a man who had gone against her, made rulings that were not in her favor, and was content with her spending her last days in jail, awaiting trial. Wooten became an antagonist to Sarah, someone who was actively working against her interests, and so she began to make up wild theories as to why that was happening. In her mind, she has done nothing wrong, she should not be in jail or prison, and anyone who says otherwise is her enemy. They simply couldn't be looking at the case details and making their decision based on that alone. They had to be part of a larger, broader conspiracy specifically against her, or else their actions simply don't make sense to her. As we have mentioned previously, Sarah has a very grandiose self-image, one that's at odds with reality. After letter number 3, Sarah began accusing Wooten of conspiring against her, profiting off the media coverage of the case and directly selling case information to the public. Whenever someone tried to explain that the case details were public due to Florida's own sunshine laws, she rebuffed them, stating that that was different, even though to be plain, that was not different at all. This action alone shows that Sarah has no care for the truth, as she will easily disregard anything that doesn't align with her own worldview. In Sarah's mind, there is no way she's going to be found guilty for killing her boyfriend, because she has again done nothing wrong. So anyone who is looking at the case, saying that they believe she was at fault are either bots or being told lies. Prior to when Judge Kranick found that Sarah had forfeited her right to counsel, he had yet to make a ruling in the case that she took issue with. She viewed him the same way she originally viewed Wooten, a powerful person who she could align herself with to her own benefit. However, when this last letter was written, he had just made a huge decision that was not in her favor. Her putting the word honorable in quotes is a sign of disrespect, obviously, but this is just the first sign of that. It's likely that by the time this case goes to trial, she will be accusing Kranick of all of the same things that she accused Wooten of and probably more. So I guess we have that to look forward to. But continuing on to the letter. Judge Kranick, where is my discovery? I am still waiting for you to provide me with the contents of what former attorney Cashman supplied to you and the court at the quote surprise status hearing held in secret on 6/28/24 at 1:30 p.m. Pausing again, if you've ever encountered someone like Sarah, you would no doubt know that there is no right way to respond to them, especially when they feel like they've been attacked in any way. In their mind, they are being mistreated and they are the victim, so even if you explained in detail how exactly they got into whatever position they're in, they would still find a way to make it so it isn't their fault. Sarah killing Jorge, not her fault. They had just been drinking and he locked himself in the suitcase magically. How is she supposed to know that he would die in there? Her being arrested for his murder after the police found video evidence of her laughing as he died? Also not her fault. She was drunk and clearly joking. It doesn't actually matter that he did perish due to her actions, so she's blameless. Her lawyers repeatedly asking to be taken off the case because of her behavior? Not her fault. They are all just bad at their jobs and working against her. Sarah doesn't actually care about receiving her discovery, because as we covered in our last video on Sarah, she will just lie. She will claim that her lawyers and the courts are keeping her medical information away from her, that she isn't being allowed to see certain things, and that she hasn't received information that she has, because she wants to further victimize herself. She wants to change how the public views her, so that videos about the case go from laughing at her antics to feeling like the court system is not being fair towards her. As time has gone on, multiple of her original claims against her lawyers have been thoroughly debunked. In fact, the last time she was in court, her previous attorney described how she had tried to work alongside Sarah and give her access to everything she asked for. However, it had been found that it was impossible to be her client, as she would just lie about whether she had seen certain documents before. In Sarah's earlier letters, she repeatedly claimed that she had not been given access to her medical records, that the courts and her lawyers were keeping them away from her, and that was evidence that she was being set up to fail by the court. However, her lawyer did talk about how they did give Sarah a copy of her medical documents, but was also given a copy of said documents by one of her former attorneys, which was covered in Sarah's notes, meaning that she had been given access to the documents previously, notated them for her lawyer, then lied to the court and said that never happened. So when she characterizes the status hearing as being a surprise and the court keeping her discovery away from her, that claim rings hollow. Even if you were the most understanding person in the world and didn't believe everything Sarah said as a lie, she has repeatedly shown herself to be untrustworthy. Your designated clock of unfair judgment ticks empty and incessantly while waiting for you to deliver. As usual, it's in your favor. In your nonchalant, relaxed, unconcerned attitude of me to receive, you are robbing me of precious life-saving time to fully and properly defend myself on top of my already and still being violated constitutional rights and being forced to represent myself based on false information. Pausing again, in Sarah's mind, nothing she has done has led to the circumstances that she's found herself in. She is the good, just person who is being persecuted wrongly, and it's everyone else's fault that she's in there, which again doesn't align with reality. Even if we were to ignore the murder she callously committed, let's just examine her behavior with her lawyers. She has defamed each and every person who has represented her, writing letters that she knew would be published stating that they are lazy, incompetent, and bad at their jobs. She accused them of criminal activity, and directly stated that she believes that they should be disbarred, but then is surprised when they say they don't want to work with her any longer. Even if Sarah was difficult, telling them that she doesn't like them behind the scenes and making their jobs harder, the vast majority of court-appointed attorneys she worked with have dealt with difficult clients. They would have been able to persevere and continue to represent her. She went out of her way to disparage them and state they were too incompetent to handle her case, so they were forced to remove themselves. Sarah continues, I do not even know what is contained in said discovery after being withheld from seeing all to date. And for the first time in said surprise status hearing, along with my supposed digital evidence being produced by Cashman, finally, after never being shown any during her, quote, representation. Her response to me when I asked to review was, your first attorney said he reviewed with you. That was over 4 years ago. You're my attorney now, and no, I did not. This is what I have to deal with. I have not seen in its entirety and completely to date. Pausing again, one of the last things that Sarah said in that paragraph is illuminating. She goes from saying she has never seen the material she was requesting at the top of the statement. Then, after her latest lawyer responded that she has seen it and that there is proof she has seen it, she changes her story. She says, okay, I did see it, but that was over 4 years ago, so I guess the statute of limitation has run out on her memory. I guess Sarah can simply say she has never seen any of the case details if some unknown amount of time passes between the last time she saw them, which is nonsense, but okay. She then tacks on another excuse, that being when she did review it, that was with another lawyer, so it no longer counts, which sort of makes sense. If she genuinely believes there is relevant information in the document to her case, it would track that she wants to call her lawyer's attention to it. But if you simply want to go over the pertinent information from her medical records, you would probably just say that. Instead, Sarah states she has never seen any medical records at all, and they are being withheld from her, and her lawyer is working against her by not giving her unlimited access to them. There is a rational argument to be made here, but because Sarah is the one making it, it immediately becomes irrational. And finally, she reverts back to her original statement, which is that she never saw it in the first place, which contradicts everything she has said before. Put yourself in Sarah's shoes. You're in jail for a crime that you did commit, but you do not feel directly responsible for. You're working with a court-appointed attorney, and you feel like there is some kind of smoking gun piece of evidence in your medical records. How would you, a hopefully rational human being, ask for that evidence? Would you approach your lawyer and explain exactly what it is that you want and why you want it? Or would you tell them that they are purposely and maliciously withholding evidence from you, and then consistently besmirch them publicly, hoping that they simply bow to your decision out of shame? Sarah continues, please note, I do not have access to a computer to view these materials. I am doing my very best to figure this and everything else out as I go in my newly unwanted forced position of prose. Please do not penalize me even greater than being already. I'm trying. Please know also, I am in an open bay dorm living with 63 other inmates. I need to figure out how to view anything securely to avoid further exploitation and mean ignorance. There is no privacy or individual access in jail. So Sarah is now trying to use the position she has put herself in to get better accommodations while awaiting trial. Again, she has done this before in other letters, trying to state that because she is the key to her defense, she should be put in a more isolated cell, away from the other women awaiting trial. This has never worked and will never work. Sarah is not the first person to have unintentionally forfeited the right to counsel, and she will not be the last. But that forfeiture does not result in a swanky new accommodation, more privacy, or even more time to prepare. Cashman, I'm glad I could help you shine in the courtroom in front of the judge by you professionally and finally bringing, quote, everything I've been asking for since day one. And after I included you on my letter to the judge ensuring return, unlike you did not include me on your motion to withdraw, surprise, and I had to find out from someone else, an officer 3 days before this surprise status hearing, so you would even know what to bring. Why didn't you bring any of your 20 hours of meeting with me? As always, it's in everyone else's favor but mine. Pausing again, after looking more into Cashman, Sarah's continued disparaging is frankly strange. Cashman tried to work alongside Sarah. She answered her questions and listened to her complaints, but still gained her ire because she simply didn't agree with everything her alcoholic client thought was important. In court, she explained that she tried to tell Sarah that what she believed would exonerate her was not nearly as important as what she believed, but Sarah wouldn't hear it, literally cutting off communication with the attorney multiple times. Sarah, ever the Karen, is trying to sarcastically throw her efforts in her face, as if she was lying about spending 20 hours working with her. Cashman also showed proof that she did provide Sarah with the items she asked for, but they weren't good enough. The only way Sarah would have been satisfied is if Cashman worked only as Sarah's mouthpiece, saying and doing everything she asked without question. But even that wouldn't have worked, because when Sarah would inevitably be found guilty, she would have turned on her lawyer immediately. Sarah continues, "How much real time will I have to prepare and properly, especially the fact you have me doing everything while incarcerated? What happens when more time must be utilized to discover where my, quote, lost discovery is, that I've been asking for repeatedly, for depositions, to locate my witnesses, contact everyone via collect phone calls? That's a real hurdle. Wait to receive transcripts, any records, everything I need to finally build my defense. Or is your plan, Your Honor, just to leave me out to dry and in a hurricane? Your time constraints are extreme and unreasonable. Your decision you claim to have considered from your order is illogical and unfair. Specifically, that it has been malformed by your ignorance and experience of my case. Misinterpretations, straight lies from the attorneys appointed. They are brazen to stand at your pulpit, in your courtroom, and commit perjury to your face and the world. But yet, it's me. It is my belief, and from your order that actions speak louder than words. The court is sabotaging me, forcing me, pressuring me, setting me up for failure. If any of the prior attorneys would have included, cared, collaborated during their time of representation, you not being brainwashed, impartial from believing everyone over me, and implementing your intricately misconstrued, unfair order formulated from, I would not be writing another letter, would I?" Pausing again, she absolutely would be writing another letter, because that is what she does. There's always going to be another reason for Sarah to write another 10-page letter about how things in her life are unfair, because she will always find some justification for feeling that way. Her husband leaving her because she repeatedly endangered their child while drinking? Unfair. Her being spoken to with an impolite tone because she's being belligerent? Unfair. And so on. It's vitally important that Sarah be the victim, that she is being treated poorly and sabotaged, and that people do not question her about that. Again, everything is being done to her, so her actions are always justified. Meanwhile, it's everyone else who is at fault. She continues, "In the meantime, while your clock ticks ceaselessly and loud, as I wait for you to deliver anything, even more fingers are noticed. They really do point back, and I am defending myself against your inaccurate, libelous, I can write letters too, order, because you would post my included document in your break room, wherever you think it may be seen and understood, unlike me in your courtroom. How about by the copy machine, where your JAs would have been made, the news crews, court TV, professional YouTubers, and photographers, the world, a copy of the notice of hearing, where all aforementioned improprieties occurred, and then some, including the drop-off of my case materials, said order of being, quote, ordered, and me being pulled by my uniform to exit your courtroom, while still trying to speak in defense myself against all the mayhem and chaos, especially the surprise of being there, unprepared and without notice. Oh wait, my posting, everything supposedly, is public record, and there is no notice at all. Another it's in your favor moment. It's a group effort, saboteurs. But surprise, I shall return. Nothing is impossible. Believe, hopeful, grateful, waiting." Thank you for posting, Sarah Boone. Oh, and P.S. Please remember Judge Cranick. Fair, neutral, impartial. You must be always. Heart. I can do all things through Christ who strengthens me. So Sarah then really lets her artistic ability shine through and makes a poster, which certainly is creative. What I personally enjoy about this poster is that it completely ignores that she has just forfeited her right to counsel. So even if the world's best and biggest attorney wants to work alongside her, they can't. But Sarah likely believes this letter was some kind of mic drop moment to Judge Cranick. He would have seen that she put the word honorable in quotes and immediately shat his pants. She thought that this was such a compelling argument that he's going to reverse his decision. But to be fair, the borders on this poster are pretty damn straight. If she did this freehand, it's pretty impressive. If I was the judge, I'd just honestly go ahead and reverse my decision now. The poster reads, "Inmate seeks attorney. Looking for a prosperous challenge? Ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are. With your original creativity, extraordinary expertise, confident ingenuity. Qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, and of course, committed, and maintaining faith in the client and the case with the ability to think different, overcome all circumstances. An epic opportunity awaits. Invest in the oppressed. Believe." This letter was written and sent in on the 8th of July, meaning that we will likely see another letter by the 8th of August. Sarah's last lawyer was able to keep her from writing in as often as she wanted to, but now that she's unhampered by an attorney and has gone completely rogue and ghost protocol, she will most likely go back to writing into the judge at least once a month. Welcome back to another episode of Dreading, or if this is your first time here, welcome. Today we are going to be, once again, revisiting the case of Sarah Boone, as she has sent a 28-page letter to Judge Michael Cranick, who recently sentenced her to life in prison. While we fully expected to move on from this case since it came to an end, Sarah keeps doing frankly ridiculous things, and we are completionists. I promise there are more cases coming, and there will be longer breaks in between Sarah videos. But alas, we received quite a number of emails and comments requesting that we review the 28-page letter. So if this is somehow your first time on the channel and you have no idea who Sarah Boone is, you have unfortunately clicked on the wrong video. I'll leave a playlist in the description box with all of our coverage into Sarah, which is likely over 10 hours long, but I will do my best to summarize. This video is sponsored by Aura. Chances are reasonably high that if you have ever bought something online, or used social media, or done anything on the internet, you have received one of these nifty emails telling you that your personal, private information was shared in a data breach. Yahoo, Capital One, Equifax, Facebook, Adobe, and even more massive, powerful companies that you have shared your personal, private information with have all been compromised across the years by hackers who could use your private data to do almost anything. The first time I ever got one of these emails, I thought nothing of it. The notice said my information was part of a data breach, one that affected close to 1 billion people. With that in mind, I figured so many people would be affected by the information that mine would be lost in the pile. I had nothing to my name and stopped thinking about it the moment I closed the email. But then people started using my personal information to open fraudulent credit cards, which would destroy my credit. It took years to right all the damage that was done, and to this day, I still worry about my personal information being used in that way. And that's why anytime I find a service that makes protecting my personal, private information just a little bit easier, I use it, which is exactly what Aura is. Aura is a company that protects you and your data online, no matter what your exact needs are. They'll remove your personal information from data brokers and people search sites, making it harder for your identity to be stolen. They monitor your personal data, including your social security number, and offer $1 million identity theft insurance, and losses are free should your data be compromised. They alert users when it appears that some unsavory party is trying to open fraudulent lines of credit in their name, and provides you with the ability to lock your Experian file with just a tap. Not to mention that they also provide VPN protection, antivirus, password managers, and so much more. Prior to using Aura, I'd have to go to each site manually where my data was available, manually opt out, and monitor the site to make sure that the information was taken down. I would spend hours of my time verifying information, going over my records, and poring over articles to see if my information was somehow compromised. But Aura makes it so much easier. I cannot recommend Aura enough. And if you're anything like me, then you'll definitely want to try them out. So stop leaving yourself open to data breaches and brokers, and take control of your information by going to aura.com/shredding to get 2 weeks for free. I want to thank Aura for sponsoring this channel and also for making my life so much easier. So with all of that said, let's get into the video. Sarah is a delusional alcoholic and a narcissist who fundamentally believes she is not responsible for her actions. Because she has such a high viewpoint of herself, she cannot comprehend her own negative qualities, even though they are much more present in her daily life than her positive ones. She describes herself as a loving mother, partner, and a high achiever, even though all of her achievements happened in high school, decades ago, and she was divorced by her ex-husband after endangering their son countless times with her drinking. She had been witnessed by her neighbors and family members drinking herself into a stupor when her son was in her custody, and on at least one occasion, he was able to leave her apartment on his own to wander around aimlessly because she had passed out drunk. It was only for the kindness of strangers that he was kept safe, and her ex-husband would state that even though they were no longer together, he would still have to be on call. Sarah would call him every day, multiple times a day, and scold him for things, like not waking her up to pick up their son from school when it was her turn for custody, or not coming to fix an appliance, and more. But because of Sarah's inability to process her own faults, she refused to acknowledge any of that information. All of that either didn't happen, or is being wildly misconstrued in order to make her seem like a bad person, which she is adamant that she is not. She claimed in court that it was Brian who refused to stop talking to Sarah, that he was constantly badgering her to do things, and stuff, and that the marriage had broken down due to differences in parenting styles, which is somewhat true if you think about it. Brian didn't think it was an appropriate parenting technique when Sarah would leave their child unattended to go drink in the middle of the day while he was at work, and she did, so I guess that one thing is accurate. Moreover, this isn't a narrative being spun about Sarah by her bitter ex, who seeks to bury her in the media, or win a court case against her. If anything, Brian Boone's repeated interviews with police and his responses to Sarah in the lead up to the trial have all shown an incredibly passive man who just wanted his son to have a relationship with his mother. All of his stories have been confirmed through direct evidence, as well as witness statements and even Sarah's own neighbors confirming his assertions. Meanwhile, the only person who seems to agree with Sarah's version of events is Sarah herself, and she has gone on record to state that she does not believe she even really has a drinking problem. However, the public was not made aware of Sarah's antics because of her divorce and her subsequent treatment of her son and ex-husband. Instead, the world at large learned of Miss Boone because she murdered her boyfriend, George Torres, by locking him in a suitcase, supposedly during a game of hide-and-seek, and then took a mocking video of him as he begged for air. Then, of course, either threw the suitcase down her apartment stairs and then potentially beat it with a bat, then left him in the bag overnight where he suffocated to death. The details of the crime itself were strange, because someone being murdered via suitcase is eye-catching and demands explanation. But Sarah's strange behavior that was showcased on the police body cam footage only gained more public attention. But again, Sarah couldn't even admit to having an issue with alcohol, which unfortunately had caused her divorce, and most of the turmoil in her life. So even when she was met with direct evidence of what she did via video that she took of George dying, she refused to acknowledge it. According to Sarah, not only is it inconceivable that she would ever be responsible for someone else's death, it's insulting that people would believe that she's stupid enough to leave so much evidence. She sees herself as a smart, kind, and courteous person, someone who people generally look up to and respect. She is the mother every woman strives to be, and the wife any man would be lucky to have, and so on. If she was going to commit a cold-blooded murder, she's of the belief that she would get away with the crime expertly, which is a common belief shared by narcissists that we have covered on the channel. Mark Twitchell, Robert Tellis, and Ali Abulaban were all genuinely shocked and offended by the court cases against them, because even though they had left such obvious and damning direct evidence leading to their capture, they felt that they were too smart to have done so. All of them argued that, like Sarah, they were being framed or set up by the justice system, even though their crimes obviously could not have been done by anyone else. In the nearly 5-year lead up to the trial, Sarah has written letters stating that she was being wrongfully imprisoned for crimes she didn't commit, and that she would be exposing the justice system for its rampant corruption during the course of her trial. But, as you might have seen in our previous coverage, that is not what happened. She was able to maintain her composure on the stand, but unfortunately was never able to conclusively show any examples of police wrongdoing in the investigation into her. Her entire defense was based on the fact that the relationship with George was abusive, and that she had left him in the case in order to protect herself from his violence, even though his death was unintentional. Again, a full breakdown of her defense will be left in the description box down below. Needless to say, she was unsuccessful. The video of her mocking George as he begged for his life was too much to overlook or try to explain away for most of the viewing public, and the jury quickly determined that she was guilty of second-degree murder. It's also important to state that prior to the trial, Sarah had been offered a plea deal. The state was willing to lower the charge against Sarah to voluntary manslaughter, which would have resulted in her spending about 13 years in prison, but she rejected the offer outright. She believed in her case and thought she was going to walk out of trial a free woman. It also seemed that she believed, somewhat, that if she lost the trial, that offer would still be on the table. That 13 years in prison would be the worst-case scenario, but after being found guilty of second-degree murder, she was sentenced to life in prison. And in response, Sarah wrote the following letter to the judge in her case. This letter contains the full, unedited version of the written statement that she gave in court, the one that she was obviously irritated that she had to pare down at the advice of her lawyers. It seemed that she either gave them the letter to review prior to the sentencing hearing, or that she actually practiced her speech with them, and they told her that there were certain elements that she obviously needed to take out if she wanted leniency. Which, having reviewed the statement she gave in court, is wild to say. Sarah did such a bad job in her sentencing hearing that every single person we have seen react to it was shocked. People who had been covering the case longer than we have, who are at this point experts in Sarah Boone, could not believe the things she was saying. And that was the version that she worked on with her lawyer's help. So let's review the unedited disaster. December 6th, 2024. Mr. Michael Kranick. So we are already off to a tremendous start. If you have watched any of our coverage of Sarah Boone's letters before, then you are likely aware of how Sarah's language changes depending upon her opinion of who she is talking to. Initially, another judge was placed on this case, and when she began writing to him, she was especially reverential. The letters opened up with her calling him Honorable Judge, complimenting his ability to see through the lies of the prosecution, and stating that she knew he would be able to help her, because there was no way someone as knowledgeable as he was would be fooled by the case brought against her. In other words, she was being a kiss-ass. She wanted to get the judge on her side, so she complimented him, used unnecessarily academic language, and tried to present herself as something she wasn't, competent and smart. But over time, when the judge refused to overlook her crimes and her contempt for him grew, her language began to change. She stopped calling him Honorable Judge, and stopped complimenting him every opportunity she had, and then began to question if he was outright orchestrating a grand conspiracy against her. She then accused him of profiting off of the court coverage, being in league with Court TV and Law and Crime, and selling the video of her mocking George, even though those videos were made public due to Florida's sunshine laws. The judge was eventually replaced by Judge Michael Kranick, and the cycle started all over again. Sarah tried to get Kranick on her side through flattery and showcasing how intelligent she was. She overcomplicated every sentence she wrote in order to prove that she wasn't like the other inmates, and therefore didn't deserve to be punished for a crime she committed. And then, when that too didn't work, her language became harsher and harsher, to the point where she now even refuses to call him Judge. Normally, how someone addresses a letter wouldn't be a massive deal, but Sarah's letters are actually incredibly useful when it comes to pointing out manipulation. She isn't subtle or even a skilled manipulator, so we can highlight obvious signs of manipulation, which is usually a bit more difficult to do. But moving on. I am enclosing, please, my complete statement to you and the world, as I partially read during my sentencing hearing. By reserving particular parts of my very true and meaningful statement, I was hoping to have been graced with your forgiveness, understanding, and consideration in any level or degree. For me, unfortunately, and regardless of when I had to speak on my behalf, or the number of, your ignorant mind was already made up. So pausing again real quick, because Sarah doesn't like the outcome of anything, it's automatically invalidated in her eyes. It wasn't that Judge Kranick heard her statement, found it to be condescending, and felt that it clearly demonstrated a lack of sincere remorse for the crimes she committed, then decided on the sentence. It can't be that the police and the prosecution came to the conclusion that she was responsible for George's death based on the direct, unflinching evidence. And it especially cannot be that the media reported on the case accurately, as they saw the video of her mocking George and the interrogation footage, and then came to the same conclusion. It has to be that everyone else is in the wrong. Everyone has a weird bias against her, and that for some unknown reason we want to see an innocent woman put into prison. In her mind, that is more logical than the truth. Obviously, Sarah's statement in court was awful. We cannot emphasize just how bad it was, even though what we are about to read is worse. Sarah spent most of her entire time on the stand smugly listing out every person who had wronged her in the lead up to the trial, and stating that she forgives them, even though she clearly doesn't. She is so hopelessly hung on what she feels are specific instances of disrespect that she cannot help but list out every single person she felt was responsible for why she was in prison, starting with, of course, the man she murdered. Instead of showing remorse for his death, saying she is sorry for her actions that night, and saying she wishes she can go back in time and make a different decision, she instead listed off every instance of him hurting her in order to validate her actions. But she attempted to disguise her statement as being her forgiving him, because it was important to her to insult George's memory while pretending to be contrite. She also shifted blame for any of her wrongdoings outside of the relationship onto George, insisting that he would force her to drink even though she didn't want to, because she wanted to be a more present parent, physically forcing alcohol into her mouth so she wouldn't be able to pick her son up from school, and would force her to cancel on weekends when she had custody, which is not true. Based on her previous testimony, as well as her ex-husband's account, Sarah was an alcoholic before meeting George. She was never a present parent and refused to act responsibly around their son, often leaving him alone in order to drink, even when they were married. But because so many stories of Sarah neglecting her son were told in court, she felt the need to counter them. She has to pin her wrongdoings on someone else, because actually accepting any sort of responsibility for her actions would mean that she understands that she is partially to blame, and that is simply unacceptable to her. George didn't make Sarah an unreliable parent. He didn't force her to drink herself into a stupor so often that her ex-husband would have to call her repeatedly every morning she had custody of their son to make sure she would drive him to school and pick him up. She did that herself, but she, at least publicly, cannot face that reality. The fundamental issue that Sarah has with the majority of people who look at her case is that they look at the evidence and they determine that she is responsible for George's death. In her mind, that is unreasonable and shows malice towards her. Because Judge Cranick sentenced her to life, he has an obvious bias against her for some unrelated reason and simply wants to see her suffer. Because the men and women of the jury found her guilty, they were brainwashed by the prosecution, tired and unable to see past the lies being spread about her. And because the reporting around this case has gone over how Sarah taped George begging for his life and showed that she was responsible for his death, well, of course, they're all in bed with the prosecution and only talking about her to make that money. Those Boone bucks, baby. Those Boone bucks. Alright, this is her brain trying to desperately rationalize why this is happening to her, without it being her fault. And to be clear, this is what she believes. She sees herself as a victim in all of this, and believes that because she stated that she never intended to kill George, that she should be released. In the lead up to the trial, we have repeatedly talked about why this defense doesn't work and why Sarah wants it to. Because if you cause a death, even if it was an accident, that is still a crime. She would still go to prison, but she disagrees. She has made it clear through her letters that she feels like a tepid, insincere apology and being a straight-A student 2 decades prior should allow her to get off with a warning. But a man is dead. That's a serious offense. Anyhow, Sarah continues, by your clear error and full-blown unfair bias against me since your involvement in my Crucible case as a whole, I have been unsuccessful in receiving anything from you as a supposed fair and neutral judge, except for your wish that I spend the rest of my life in prison. Pausing once more, so it goes without saying that this is not true. Cranick doesn't have a bias against Sarah, because that would make no sense. He didn't know who Sarah was prior to taking the case. She isn't a spurned lover. He hasn't shown a history of making unfair verdicts against middle-aged divorcees who have gone through 8 lawyers in the lead-up to their trials. Cranick had to spend a long time with this case, much longer than most judges have to, and Sarah made every single step difficult. He saw her through multiple lawyers, gave her repeated warnings about her antics, stepped in and spoke to her on a number of occasions, and tried to properly explain why things were happening to her in simple enough terms for her to understand. So he was well equipped to determine her sentence. But of course, she doesn't like that. She thinks it's unfair. But she continues on. Please know and always remember, Mr. Cranick, I forgive you. Still and sincerely. Please also understand the judge, according to Cicero, is never to lose sight that he is simply a man, and that he cannot exceed the power given to him by his commission, that not only power but public confidence has been given to him, that he ought always, very seriously, to attend not to his wishes, but to the requisitions of law, justice, and religion. So, pausing again, we've covered this case for a few years, and something that is extremely clear is the amount of care that Judge Wooten, the OG represent, and Cranick put into it. Sarah is a difficult defendant, as you can see from our over 10-hour playlist of her alone, and they went through pains in order to ensure that they were giving her a fair trial. For almost 5 years, her trial continued to get delayed because of her own actions. She would routinely disparage her lawyers, purposely writing to the judges, knowing that the letters would be published in order to shame them into doing her bidding. She called them every day, even though they were working on other cases and not working full-time on her case. They told her about their time constraints, their plans moving forward, and urged her to be patient with them as they were working at the appropriate speeds. But in Sarah's mind, they worked for her, and since she didn't like the job they were doing, she was going to leave a negative review. She called each of her attorneys dumb, stated that they should be disbarred, and accused most of them of stealing her money, even though she was not the one paying them. Both judges told Sarah that they were not reading her letters, that it wasn't appropriate, and that it would hurt her working relationship with her attorneys. When the attorney eventually asked to withdraw, Sarah acted shocked, even though she had repeatedly claimed they were not equipped to handle their jobs. I say this to showcase how much patience and grace Sarah's case was treated with, how both Cranick and Wooten went above and beyond to ensure that her trial was fair, and that every decision they made was done with immense care. But now she is insisting that he has a God complex, that he has gone mad with power, and is taking out his unjust anger on her. In Sarah's world, unfortunately, everything happens to her, and nothing is her fault. Her lawyers left because they were just bad people. Her husband left because he's a bald bitch and a bad person. I don't even know if he's bald. I don't think he is. George died because he got in a suitcase. None of her actions matter, and therefore she can do whatever she wants. But there was a reason why no one in her life spoke highly of her. But more on that later, continuing on. I am excited in my appeal, which speaks for itself. My case law as well, in which I am extremely proud to have achieved, and will continue doing so now that I am no longer in your corrupt court and free from your malevolent judicial grip. Ugh. Sarah Boone versus State of Florida? I don't know. It's in all caps, I don't know why. I also have added to my statement as a result of your blindness and impartiality. Foremost, your disgust in me as being an outspoken woman, determined defendant, and proactive client, and hoping the next time you put on your listening ears, okay? And do not unfairly oppress the next, as you have so blatantly done to me. You will never admit to your many judicial errors, nor will the prosecutors theirs, and I will never admit to what you have wrongfully accused me of, and judge me as. So, pausing again. The statement right here is extremely telling, but not in the way Sarah meant for it to be. Let me explain. Sarah is condemning the judge for not seeing things her way, and for being unfair towards her. She says that neither him nor the prosecution will ever admit to their faults in the case, attempting to paint them as being so concerned with their preservation of power that they are refusing to acknowledge they are capable of making mistakes. Now, the first issue with this statement is that the majority of the faults she has tried to use as evidence of bias against her is just the law. She just doesn't like how the justice system operates, because it's negatively affecting her life. But besides that, she goes on to end that statement by saying she will also never admit to fault, but does so in a way where she expects to seem powerful and brave, which is a pretty blatant double standard. She is boldly stating that she is never going to admit that she caused George's death, even now after she's been convicted, even though her entire defense was that she did cause his death, and that by not admitting fault, she's being brave, somehow. She continues on. I am not a murderer. I am a survivor. Sarah Boone. Alright, so this next portion is also a part of the letter that was added after her sentencing, and it was not originally included. I wanted to make that portion very clear, because when I first read the letter, I believed that this is where she originally intended to start her speech prior to being sentenced. It was only after my brother showed how the pages were lettered instead of numbered that I realized the mistake. Sarah continues. Black robe disease, arrogance in a judge, a slang term for a judge who flaunts judicial power and dominates proceeding at the expense of the dispensation of justice. Impartiality is the first duty of a judge. Before he gives an opinion or sits in judgment in a cause, he ought to be certain and absolute that he has no bias for or against either parties. If he has any interest, even the most slightest, in the cause, he is disqualified from sitting as a judge, and when aware of such interest, out to have lawfully and justly refused to sit on the case. The delicacy which characterizes the judge in this country generally forbids their sitting in such a cause. The judge must not only be impartial, but must also follow and properly enforce the law, not abuse. He is bound to declare what the law is and not make it. Be not an arbitrator, but an interpreter of the law. It is their duty to be patient in the investigation of the case, understand the circumstances and difficulties by all parties, careful in considering parts of the whole case, and decent in judgment. Beauvoir Law Dictionary. I rest my case. Quote, but at the risk of practicing judicial centrism, a word I have coined in this presentation, others have called it black robe disease. Whether he was correct or not in my behavior, it is widely accepted that judicial behavior affects the jury. Murray Richdell, The Simpson Trial, 1996. And then there is the worst of judicial ailments, the black robe disease, which is otherwise known as arrogance. Lynn Toller, A Practice Guide to Becoming an Emotional Genius, 2007. Trial judges are affirmatively charged with securing a fair trial and must intervene sua sponte to that end when necessary. Brown v. Walter. That duty encompasses not only the avoidance of error before it occurs, but the fair correction of error that may have occurred earlier in a proceeding. Carlisle v. United States. In the instant case, the trial judge did not analyze the evidence, he added to it. Dealing with the mere mannerism of the accused in giving his testimony, the judge put his own experience, with the weight that could be attached to it, in the scale against the accused. So, pausing again, we can probably all understand what Sarah is trying to imply with those extensive, repetitive, and frankly annoying quotes. I'm sorry I read them that way, but it'll probably happen again. She was implying that Judge Cranick was patently unfair towards her, that he has bias against her for some unknown reason, and that his sentence was unjustified. But the vast majority of the quotes don't actually pertain or feel relevant to the case. Her initial quote from the Bouvier Law Dictionary about the judge making sure he doesn't have any bias for or against any of the parties in the case doesn't mean that he is disallowed from having an opinion on the parties based on their actions in the lead up to the trial. It doesn't mean that he has to be a blank slate and allow any unfavorable information he heard about the defendant bounce off of him. It simply means that he cannot have his own bias towards her or the defense. Like if we found out that Cranick and Sarah had dated in the past, scandalous, that could either lead to him showing favoritism or being unfair towards her. Either way, because there is potential bias, he would have to excuse himself. That same is true with the prosecution. If it was proven that Cranick had a close relationship with the lead attorney, that too could be reason for recusal. But in Sarah's mind, Cranick looking at the facts of this case and telling her that her antics were the reason that her lawyers left was enough to demonstrate that he was simply out to get her. Sarah continues. Kinto Sukuroi is a kind of Japanese ceramic style which means to repair with gold. In this tradition, when a ceramic piece breaks, an artisan will fuse the pieces back together again using liquid gold or gold dust lacquer. So, rather than being covered up, the breaks become more obvious and a brilliant new piece of art emerges from the brokenness. It embraces flaws, weakness, and imperfections, and also teaches the essence of resilience. Every crack in a ceramic piece is a part of its history, and each piece becomes more beautiful because it's been broken. This is the wisdom of Kinto Sukuroi. Pausing again, I was made aware through the comments of our last video that this portion of Sarah's speech was taken directly from a website. I believe the YouTube channel Just a Lazy Gamer made that discovery, so I guess now we know where she got her straight A's from. She continues on. In my wisdom, and with all my repairs then, now and ongoing, God is, has been, and will always be my artisan. All of my gold is forgiveness. This has held me together, made me shine brighter and overcome the damage. From George Torres, the Torres family, the justice system, Judge fucking Wooten and Cranick. And I haven't forgot Orange County Corrections Department, social media, scoundrel detectives, infamy, defamation, ongoing constitutional rights violations, second-degree murder, forced into being pro se. But just as gold is very precious, forgiveness is invaluable. But forgiveness is not an attempt to change or forget who, what, or how you've lived through to be so gold. But an act of grace, humility, and considerable self-compassion to be set free from sorrow. Alright, so pausing again. So obviously, there are two names on the list that were not on there before, that being Judge Wooten and Cranick. It seems that when Sarah had gone over her statement with her legal counsel before she was sentenced, they urged her not to directly condemn the judge who would be deciding her fate, which seems obvious. But this also adds new context as to why she was so irritable when she said that she had to edit her statement down. She was annoyed that her words have to be changed at all, even though it should go without saying that if you're trying to get a lighter sentence, which she already stated she was, that she wouldn't accuse the judge of essentially wielding his power irresponsibly. Apparently that didn't occur to Sarah at the time, and because she didn't get the sentence she wanted, she feels as if she is allowed to say and do whatever she wants now. One of the things we have found to be the most striking about Sarah is that she is piss poor at manipulation. She cannot successfully manipulate anyone, despite having spent the last decade at least trying to, and this is just another example of that. Sarah could have gone on the stand and acted contrite. She could have cried, said that she was sorry for her actions, and falsely claimed that she deeply regrets everything that happened that night. That she is sorry to the Torres family, that she understands why they would never forgive her, and that she would spend the rest of her life mourning the loss of George. Whether or not she meant the word that she was saying is irrelevant, because she wouldn't be saying it for anyone else's benefit but for her own. But she couldn't even do that. Instead, she thought out this passive-aggressive 20-plus long page letter where she blames everyone else, including the man who would be sentencing her. But continuing on, withholding forgiveness denies your brilliance and adds even greater grief and deeper heartache, irreparable cracks on top of the already that no one deserves, no matter the pain or disappointment, untruths or injustice. It doesn't matter, as the more broken you are, even though now different than before, you've become more outstanding and more extraordinary. Above all, when you let go of blame, misunderstanding, I lost my place, where am I? Oh, excuses. Give up your anger and cease from resentment. This is forgiveness. And when you forgive, you heal. And when you heal, you move forward. Pausing once again, just to re-emphasize how inappropriate what she is saying here actually is. She is being sentenced for murder. She was tried and convicted of the murder of a man, and she is talking about how everything she has gone through, including killing George, has made her a better, more outstanding person. His family members are sitting in the courtroom, listening to her compliment herself, while she uses a warped, condescending version of forgiveness to list off her issues with everyone who has ever commented on the case, including them. She found a way to make a moment of her taking some small bit of accountability into her insulting everyone else so she could feel like she was better than them one last time. This next portion is the same as what she said previously. My gold begins with George Torres. Every time he slapped me, kicked, punched, spit on, raped, stabbed, choked, laughed at, pushed, pulled, dragged, whipped, tripped, stole from, lied, terrorized, threatened, humiliated, forced, degraded, made me cry, every time he tried to end me, defeat, or destroy. I forgive George for beating me senseless for trial to sleep because I had to go to work or my son's field trip the next day, for ruining my deceased family's heirlooms, traditions and keepsakes, my son's furniture, destroying the television we watched together, for wrecking our townhome by breaking windows, punching holes in the walls and doors, ramming his entire body into glass doors, kicking in my front and back door over and over and over, for breaking or removing locks from all the doors and sometimes the knobs altogether, so I have nowhere to feel safe, including the sacred space of my son's room where he beat me bloody on his bed, for terrorizing and threatening my blind and deaf dogs, by leaving the gate open that I built to keep them safe, telling me he hoped I'd find their bloated dead body in the pond and scrap their remains off of the pavement, for kicking them off of the bed and throwing across the room because they were trying to protect me, for threatening to make me unrecognizable to my son by breaking all the bones in my face, like his brother Moise did to him after he kept seeing all the bruises from George beating me, like all the times their father beat their mother, for all the drunken rages and fistfights with so many neighbors when wandering into their apartment during a haunting expeditions after I escaped, for drowning me in liquor and wine because I didn't want to drink, causing me to urinate on myself, then butting the end of the bottle in my face and giving me 2 black eyes and a bloody nose, for making me experience what it is to be sodomized, threatening to kill my friends and neighbors when they checked on me to make sure I was alive and in one piece, for threatening to burn down our townhome and set my car on fire because I got a job, for holding me hostage on weekends my son was supposed to come over by keeping my keys around his neck, my phone in his crotch, and a butter knife stuck in the middle of the table as a warning not to ask anything or try to leave, for stabbing me in the leg and not letting me call 911 for an ambulance to seek help, where I nearly bled to death until I concocted a lie to save him from being arrested, for destroying my phone with a hammer because my son called, for experiencing ever being arrested, and after today, prison, for beating my almost blind, crushing my occipital lobe, for having me experience what it means to see stars, like the cartoons where the character has a tall lump on their head. I had that too, many times. Dragging me downstairs by my hair in the middle of the night just to sit next to him, for taking my car and driving drunk with my debit card to buy me alcohol while I slept, even after I kindly explained the importance of my car to take my son to school foremost, me to work, and his to his batterers interventions classes and probation officer meetings, where I would be forced to sit for hours in the parking lot waiting for him. Pausing for just one moment, but if you have watched any of our previous coverage of Sarah, from her body cam footage, her interrogation, or even just her letters, how likely do you think it was that she explained something kindly, the way she says here? Because nothing she ever does or says can be described as kind. Like this letter, she would probably characterize this letter favorably, saying she is taking ownership of her actions, apologizing for the hurt that she caused, and graciously forgiving all of those who have caused her hurt in any kind. That she is taking the high road after being falsely imprisoned and being set up to fail by a flawed justice system, and giving grace to those around her who might not deserve it. But any rational person who heard her say parts of this in court, or has an ounce of basic understanding, can see why that is not what is happening here. The idea that Sarah would have ever kindly explained anything is laughable, especially in the scenario she just described. She also attempts to use her child as a shield by saying that her biggest concern was being able to take him to and from school on days when she had custody, but we've already shown how that rarely happened. Moreover, Sarah's neighbors all individually stated that she was known to drive while drunk, making the assertion that she sat George down to slowly explain why drinking under the influence was a bad decision seems far-fetched. But continuing on, for causing me so much trauma and pain mentally, physically, and emotionally that I had to be hospitalized more than once, for destroying my reputation and integrity, for my M for murder scarlet letter, not letting me feel safe to live, talk to other people, spend time with my son, have a job, friendships, simply go to the bathroom with the door closed, or go to sleep soundly and comfortably. I forgive George for lying, for him trying so many times to end me with his terrifying love. I also forgive the Torres family, his mother and father foremost, also his 2 ex-wives and daughters, all for knowing who George was, capable of and has done in his past, his history of violence and where he learned it, then to keep turning a blind eye when I would ask for help. Pausing once more. This is one of the most despicable moments we've ever seen during a case. It's up there with Joseph Zeeler, calling one of the women he killed a disgusting pig. But to bring up your deceased victim's family and air out their personal business in court is pretty horrific. However, it is notable that that has not occurred to Sarah. Again, despite her nearly 100% fail rate at manipulation, Sarah thinks that by disguising her obvious malice at the Torres family by saying she is forgiving them, that everyone will view what she is doing as being genuine and kind, that Judge Kranick will hear her blame her actions on the family members of the man she killed and be lenient with his sentencing. Her self-concept is so out of line with reality that you could not properly explain what she did wrong in the situation, even though it's obvious to everyone else. Sarah continues. All of his siblings, including Farrell Torres, who was now on his way to prison for stabbing the mother of their baby in the side of her head. For everyone who knew what George was doing to me, sometimes how and when, but allowed and enabled. I forgive them for caring a little too late. I hope they ask themselves while quiet and comfortable in bed at night an uneasy question. What could I have done to stop this from happening? To both of them. And all of the times Sarah tried to, by asking for help. From all of us, and so many times. Pausing once more, but it's also notable that earlier she claimed that one of George's brothers did step in and attacked him for hurting Sarah, that he broke all the bones in George's face after he was made aware that he laid hands on her. So the idea that they did nothing is either untrue or that didn't even happen. Moreover, Sarah and George were adults. Sarah had asked the Torres family for help, and they encouraged the couple to break up. They didn't like them together, and they repeatedly said that they brought out the worst in each other, and whenever the pair would break up or the police would become involved in their domestic disputes, they would both make the choice to get back together, which makes blaming his family nonsensical. What were they supposed to do beyond simply encouraging them not to be together? They couldn't make them break up because they're adults. Telling the family of the deceased that they didn't do enough, that they should have tried harder to get George to leave her, places the responsibility solely on them. This is a truly demented thing to say to anyone whose family member died, especially by the person who killed them. But Sarah once again continues. Another great contributor of my gold is social media with its greed, insensitivity, deception, obvious exploitation, and advantageous gain of my criminal case as a whole, and for sentencing me by anticipation as a result of ignorance and hate conjured and fabricated by the organized crime that is social media, which condemned me in the court of global public opinion since the beginning. My family law case is the new prey, waiting to be picked apart and pillaged from me being made infamous by social media in my criminal case. It simply seems I cannot forgive and be forgiven and just move forward. Social media has made me a pariah. It has caused great oppression and undeniable disadvantages, especially by broadcasting and manipulating my cases online. In my criminal case, as a result, my opportunities to be given a fair, proper, and uninfluenced, successful conclusion was heavily depleted and poisoned, but I forgive them. Also the media tycoons for not having a life of their own, trying so desperately to make themselves seem so right, by making me appear so wrong. Forgiveness for prejudgment, ridiculous theatrics, lies, making and taking blood money from my misfortunes, accidents and catastrophes. It's all over their hands and their keyboards. Pausing once again, this is almost a coherent point, because there is a good amount to be said about social media and how people view true crime through its lens. We've discussed the topic during our exploration of the Delphi murder case, which we are working on remaking due to its tremendous updates, and due to the fact that the case was wildly mismanaged. But that is not what happened in this case. Sarah's case was notable because the very concept of someone being killed via suitcase is eye-catching. Add to the fact that the case occurred in Florida, the state with the most robust sunshine laws in the US, and therefore all the body cam footage was made public, and it immediately drew the public's attention. And while some people absolutely reported on the case as if Sarah was guilty from day one, it's because the agreed upon facts of the case made that point clear. Sarah's argument in court was never, "My actions didn't lead to George's death," but "I didn't mean to cause George's death." Though she tries to deny any and all responsibility now, by zipping up the suitcase and leaving him in it overnight, she killed George. There is no denying that. As far as I have been able to find in our years of researching this case, there's no evidence that large channels made up their own theories and narratives about what happened. The police and experts gave their opinions based on the evidence, but most reports have been concise and to the point, merely pointing out her refusal to accept the direct evidence against her as being strange. Again, everything is everyone else's fault. If the public looked at the case details and didn't agree that she was in the right, it was because the reports were biased. But she continues. And even after all that's been said and done, theorized, hypothesized, scrutinized, and blasphemed in my case, still, no one knows me. Pausing again real quick. No one needs to know Sarah in order to pass judgment on this case. Also, no one needs to personally know any criminal or person in real life to pass a judgment on them at all. But she continues. My gold also runs deep for my prior attorneys, Mauricio Padilla, who sold me the world with empty promises, then abandoned his responsibilities as my attorney after taking 2.5 years of my life when finally realizing he was in over his head, all while hoarding JAC dollars to fund his staycations with his family when in town from Miami, for having resources ready and available, not allowing me, the client, to ever utilize, which could have greatly professed my case and perhaps concluded, only for him to decide water parks, fine dining, and choice hotels were more important, and on the JAC's dime. Pausing once more, but Sarah has a massive issue with how she perceives other people's work, and this is a problem, because there's no reasoning with someone who acts like this. If you recall, Sarah's issue with her attorney was and always has been that she cannot see what they are doing at all times, that they aren't working alongside her, and that they aren't providing her with updates on what they are doing on her case. In her mind, if she cannot see what her lawyers are doing, if she is not given daily updates on the status of her case, if they've been able to find expert witnesses and so on, she thinks that they are disrespecting her and not doing their job. She felt that she needed to be involved in the creation of their defense, that her opinion and perspective was necessary, and that when her lawyers told her that they would be doing the majority of the heavy lifting, they were actually trying to screw her over. She wanted to be treated not as a client, but as co-counsel, even though every time she put forward a potential argument, it was nonsense. Moreover, because Sarah was in jail in the lead up to her trial, she could not actually help them. They needed to contact and re-interview witnesses, talk to experts, do research into relevant case law, all of which took hours of time and energy that she could not see. Because she couldn't see it, she felt like it wasn't really happening. Because her lawyers didn't schedule a daily call with her or give her a rundown of everything they did that day, like a child would have to do with their parents, she openly accused them of trying to sabotage her case via her letters. Most of her lawyers were public attorneys, working at their cases, and told Sarah as much. They informed her that she would be involved as much as they could allow, but they wouldn't be available for daily calls or weekly meetings and the like, which was unacceptable to her. She is now accusing Mr. Padilla of stealing money, even though that was money he earned. He was rendering a service to her, but because she didn't witness that service, she feels like it doesn't exist. She also seems to think that you are only required to pay a lawyer if they make it to court, as if all the work they do before, that should be pro bono. A trial is basically like the World Series of court. The entire lead-up is filled with lawyers working tirelessly behind the scenes, but because Sarah didn't physically see it, she doesn't think it actually happened. Mauricio didn't steal resources in order to fund a lavish lifestyle. He has a high-paying job and was able to use the money he earned working for Sarah and other clients to have a nice life. What he does with his money is entirely his business. Sarah hasn't spoken to Mr. Padilla in years, as he was her first attorney back in 2020. But despite trying to frame this statement as her forgiving him for some perceived wrongdoing, all she has shown is that she's been holding on to her anger towards him for years, that she viewed him leaving her case as an act of malice, one that deserves an apology and a prison sentence. to be clear, she is accusing him of defrauding the state by pretending to have worked for Sarah. She is saying he should be disbarred, all for withdrawing his counsel, and she's angry that she was told by her current counsel that she couldn't say this on the stand if she wanted to try and get a lesser sentence. But she continues, I forgive Frank J. Bankowitz for committing perjury to the judge and on court record about my attempts to be a proactive defendant and client, then inquiring about my discovery, then trying to communicate with no answers or correspondence in any manner for 1 full year and 2 months, before I was able to finally meet with him in the courtroom, only to receive his motion to withdraw. Frank J. Bankowitz is forgiven for his greed in taking $15,000 from the JAC, who honorably aid indignant defendants as myself, for taking advantage of and robbing the justice system by lying and avoiding clients, taking their money and the JAC's. Winston E. Hobson receives my forgiveness, who also unethically perjured himself to the judge and on court record about all the progress and attorney work he did on my case for the 2 months he was court appointed as, for his allegations of my supposed unethical requests, which meant me asking for my discovery and trying to have him file a motion for my lawful inclusion to my pre-trial conferences cited under FRCP Discovery Rule 3.2.20. I wanted to be included in my case and know the progress from being excluded by Bankowitz and Padilla over 3 years prior. Oh, forgiveness. Also when telling me he would return in a week with my discovery, only to receive his motion to withdraw in the meantime. Still not receiving my discovery, and I filing my own motion, enabling me to go to all my hearings, including my pretrials. Continued forgiveness in his greed and selfish intentions. Also for robbing the JAC and indignant defendants of $15,000 more for nothing, justifying any work he really did do in the handful of days he represented me as my attorney. Finally, and with all my gold received from this one, I forgive Patricia A. Cashman for her mean, snotty, egotistical attitude and not listening or caring that I finally received my discovery I kept asking for, which she fully withheld from me, citing her ridiculous, untrue reasons, was because I saw my first attorney 4 years prior and while she was being my present at that time attorney. I saw not 1 page or any digital evidence from my discovery she prohibited me from seeing. Patricia A. Cashman is also forgiven for admitting I had a right to bond I asked her for. I could actually utilize one of my rights as opposed to having them always violated as prior and still ongoing. Then her deterrence of all my opportunities to do so. For all of her lies, condescension, gross unnecessary arguments, and anger that I asked any questions and wanted to understand. For her doing nothing other than giving me an even harder time and request transcripts. Then brazenly lie for over $16,000 for doing so, also from the precious resources provided from the JAC. I forgive Patricia A. Cashman for being a liar and a bully. So, pausing again, none of these lawyers needed Sarah's forgiveness because they did nothing wrong. These lawyers did not perjure themselves, nor did they blatantly ignore Sarah. They simply did their jobs and tried to communicate that to Sarah. But because they detailed their poor experiences working alongside her in court, she has to admonish them. Because they said she was hard to work with, they have to be evil. It's that simple. There are court minutes from when Bankowitz filed his motion to withdraw as Sarah's counsel that properly demonstrate her state of mind. This was after Sarah had written multiple letters, claiming that Frank was purposely ignoring her, that he was an idiot, and that she had called him multiple times a day for case updates, even though he was actively working on other cases and informed her he wouldn't be able to help her. During the hearing, Sarah was asked a series of questions about Bankowitz and stated she liked working with him and didn't understand why he no longer wanted to be on the case. She said she felt like he was perfectly equipped to be her attorney and that she didn't want him to quit. However, later on, when asked about the complaints she had listed in her letters, she changed her mind, saying that he was an idiot who didn't know anything about being a lawyer and should be disbarred. Sarah will say whatever she believes will benefit her at the time, even if that means actively lying and accusing someone else of a crime and threatening their livelihood. It doesn't matter to her. But none of these attorneys did anything wrong. Sarah continues, "Forgiveness for all of those who did not include me to receive my $15,000 share I worked for when Judge Kranick forced me to be my own attorney, to represent myself pro se. I actually and finally got my own discovery almost 5 years later, filed motions all prior should have done, making them the most expensive motions ever, at over $46,000 between the 3 prior attorneys: Frank J. Bankowitz, Walter E. Hobson, Patricia A. Cashman. Would they have done so when supposedly representing me, the motions would have been priceless for the proper use of the JAC funds towards ethics, professionalism, honest, and freedom. I honorably utilized my JAC resources and mentorship as a proactive, indignant defendant, avidly defending myself against the liars, thieves, and real villains in my criminal case. So who really is the criminal? The JAC can hopefully include their forgiveness for them also. Pausing again, that's a pretty sick mic drop from Sarah, but she believes that any person who represents themselves pro se should also be paid by the state, that she deserved nearly $50,000 for the work she did over the short period of time she acted as her lawyer. But that's not how anything works. She isn't a lawyer. She isn't rendering a service to the state by representing herself. She's representing herself because she has proven that she cannot work alongside anyone who doesn't immediately buckle to her every whim. A public defender is paid by the state because they are working for the state on Sarah's behalf. Sarah could not hire her own attorney, but was owed a fair trial, like every citizen, and was provided one. She then forfeited that right due to her own actions. The state, therefore, does not need to pay her because she is not working for them. She's working for herself. But again, Sarah's ego is on full display here, because someone else, someone she views as beneath her, was paid for a job she feels like she can do better. She thinks she is owed financial compensation. She feels like she is owed a world-changing amount of money, even though if you read through any of the motions that she filed on her own behalf, they are nonsense. But the letter is about to get so much worse. Continuing on. Judge Wooten and Kranick I have great forgiveness for also, in not protecting me and listening to my valid requests for judicial intervention so I could properly and fairly defend myself against my charges. Instead, I had to defend myself against the attorneys appointed by the judge and court, against their lies and exaggerations. Reasons unjustifiable why they were creeping away from the battlefield and abandoning their professional duty as my attorney. Pausing once more, the remainder of Sarah's life was in Judge Kranick's hands. She could have walked away, pled guilty to the manslaughter charge that had been offered to her, and been out of prison in about 13 years, but she said no. She thought she had a surefire case, and was set to win, and then when that didn't happen, she decided that the best course of action, directly before being sentenced for second-degree murder, was to publicly reprimand the judge who would be deciding her fate. Say what you will about this case, but Judge Kranick was incredibly fair and thorough with Sarah. He warned her 6 lawyers in that if she could not keep a lawyer, he would force her to go pro se. He set a date for the trial, and told her that he wouldn't be moving it, even if she lost her attorneys and would be forced to represent herself, and he kept to that. He repeatedly asked Sarah in the lead up to her trial and in the trial itself if she was satisfied with her representation, and he went out of his way to ensure that everything was done by the books. But because he didn't agree with her that she was being unfairly penalized, she has decided he is a terrible judge. But Sarah continues, Judge Kranick, I forgive you for not giving me any opportunity to stand at your pulpit, to stand at all, to explain the real, truthful side of the story. Okay, pausing again, but she did tell her side of the story multiple times over. She said what happened the morning of. She said what happened the following day. She said what happened in each of her letters. She said what happened when she took the stand in her pretrial letters. She said what happened when she testified on her own behalf. She said what happened when she took the stand at her sentencing, and she is saying what happened right now. But since that didn't yield the results she wanted, she instead pretends she isn't allowed to speak, that she's been silenced the whole time. Judge Kranick not only provided times for Sarah to share her side of the story, but she created opportunities for herself. The issue is that her story doesn't matter. Sarah was objectively abused. The relationship was exceedingly violent, but that still doesn't justify what Sarah did here. Sarah goes on, I believe if the justice system, including yourself, would and should be done any vital homework on the already almost see-through attorneys from being spread so thin and simply sending an email to Kerr about their present workload, number of clients, trial schedules that are already in place before throwing another inmate defendant unknowing client on the heaping, unimportant pile of warm bodies, more taxpayer dollars could be conserved and less time consumed and wasted for everyone, regardless of what part they pay in the supposed justice system. Pausing once more, are public defenders overworked? Absolutely. But Sarah doesn't really care about that. We know this because when they tried to explain to her they could not answer every single one of her calls because of that fact, she felt like they weren't taking her feelings seriously and told her friends to harass the attorneys as well. It's also clear that she doesn't care about wasting taxpayer dollars, as she's been doing that for years. Sarah continues on. My forgiveness is deepened for taking even greater time of mine away. Years. By not caring to ask me anything about anything to understand so you could justly render your life-defining judgments and withhold any more bias and prejudice. Foremost, Judge Cranick, I forgive you for kicking me when I was done and choking the life out of my constitutional amendments. Most profoundly my sixth, right to counsel as a result of my wholehearted use of my first, right to free speech and being my own advocate since no one else would be and received a paycheck for, and all my free speech, experience-driven letters only for remedy, and any collaboration inclusion, receiving me discovery as an inmate, defendant, and client, not removal of any attorneys to cause more delays or any reason or excuse you try to make to force on me, and have already inappropriately accused me of doing prior to your heavily insinuated strategies of mine, quote unquote, to try and deflect the glaring red flags, disappointments in true crime in and of the justice system. Okay, so pausing once more. When Cranick was first assigned to the case, he made a declarative statement that he wouldn't allow Sarah to continue to waste the court's time by switching attorneys. He noted that Judge Wooten had already allowed multiple of Sarah's attorneys to withdraw, and when he told her this, he implied that she was purposely changing lawyers as a part of a strategy to put forward the motion that she was denied her right to a swift trial. And while one could argue that, in my opinion, Sarah has shown that she doesn't think that far into the future. You can't really presuppose logic onto her, because she's not that clever. In response, every letter she has written since has addressed this allegation, because she felt like he was disrespecting her. To her, that displays that he was biased against her, and should have been removed from the case entirely. Sarah continues, to this day and all forward, I do not forfeit my rights, any of them ever, especially my right to be bold, outspoken, and write in my real-life experiences with the legal and justice systems. You weren't there, Judge Cranick, in anything. No meetings, phone calls, visits, and still took my rights and oppressed harder. I now defend myself against you, praying you do not care to late as all the others, and retaliate further against me as a proud citizen of the United States of my America, and freely, excitedly using my God-given rights to still try and defend myself, to stand all the way up for you to remove my freedom altogether, by allowing and approving my stab wound, bloody body parts, rapes, bumps, bruises, and all the rest of the beatings I endured. I hope you can finally see and understand just some of the pain from the extreme difficulties, obstacles, and unfairnesses, especially in my due process, you have added in my criminal case and life as an inmate, defendant, and client. All is forgiven. For detectives Copsel and Lowen, I forgive their demonization, lies, blacklisting, coercion, law-breaking, solicitation of my case before I even arrived at the corrections department to be booked and fingerprinted. This can be seen in my unbeknownst interrogation video where I ask what they are doing, what all the pinging was during their texting swarm, while I naively sat there waiting to be arrested, which they knew was going to happen the day before. For Copsel, for bold-faced lying on the stand to the judge, and the court on record she didn't tell me to come to the station to pick up my phone. Where else would I go? I didn't even know about the surprise interrogation. Pausing once more, if I could ask Sarah one question, it would be, what does she think everyone else's motive for lying about her is? Here she is claiming that the lead investigators decided to unfairly pin the blame for George's death on her, even though there is clear evidence against her. Yet, she never explains why. She has said that there's a government-wide conspiracy against her, and at this point, there are thousands of people involved. The police, the prosecution, the attorney general, and every person who's been made aware of this case and believed her to be guilty is probably involved. But what makes her so important for everyone to conspire against her? Did she know government secrets? Did she witness an assassination? Her case has no legs to begin with, but this is where it truly falls apart, because as far as we have seen, she's just some lady with an alcohol problem. But back to the letter. I forgive them for also lying how the news showed up to record my walk of shame, handcuffed and confused on camera. I forgive them for trying to make me lose from the beginning, by starting the unquenchable wildfire of sensationalism and distortion, ignorant defamation and greed, by unlawfully broadcasting who they wanted the world to think I was by their schemes, their learned lessons and fraudulent stratagems from the school of manipulation and taking advantage. How much did they make off of me, and are still calling it in, then removing the curtain to expose their personally twisted, murdering monster? Also, my forgiveness and greater gold comes from wondering why nothing viable in my defense was taken from my townhome, aka the crime scene. To aid in my truth, such as the butcher knife, 5-prong garden claw, or hammer under the table together outside where George had easy access to if I tried to leave or call for help while being held against my will during his rageful binges, or my bloody pillowcase stained from being backhanded because I hid the magnum-sized bottle of vodka from him. Why weren't any crime scene photos taken from the holes patched in the walls or doors? Some doors, missing knobs, and all locks George removed, cracked windows, broken furniture, obvious unnatural destruction in my fucking townhome. And how were those missed, uncared about, or not questions so I could explain some of my terror? It makes no difference. All is forgiven. Pausing once more, I can easily explain why those things were not taken into evidence. It's because they weren't considered evidence. Again, when the police came to the townhome, they were processing a scene of a man who had died in a suitcase and had multiple blunt force injuries to his body. They were not looking for evidence of previous abuse, and did not become aware of that fact until after the scene had been processed. Moreover, we know that George did abuse Sarah. That has never been questioned earnestly in court. There are multiple documented instances of George abusing Sarah in the home, in front of others, and police reports were shown in court. Having a knife brought in or photos of the walls would not have made those reports any more real. Sarah continues, Prosecutors Mr. J and Mr. Cassiatori. My forgiveness is also extended for your inappropriate attributed motives, for having to go through years of my pictures, videos, texts, to erroneously piece together your deceitful, damning version of when really happened and who I am. After so much availability and for so long, you were finally able to make the circle fit into the square. Pausing real quick, I mentioned in our video going over her time on the stand that Sarah viewed the prosecution as being the lead malevolent force in her life, that they were the cause of all of her issues, which is why she was unable to agree with them at any point during the trial, and I think this next bit absolutely proves that. Sarah continues, I forgive your antics, theatricals, ludicrous comments to make sure the world got their money's worth while watching with ignorant pitchforks and burning torches, hoping for the best from you, which is my worst. Instead of, quote, dropping the mic, Mr. J, you dropped the hat for yelling, finger-pointing, and intense underlining to force your theatricals and fantastic onto the jury by using imaginary space adventures and fictional characters to blind and bedazzle them with your far, far away from the truth dramatizations. Pausing real quick, so the prosecution used a metaphor during one of their statements, and even though Sarah is a huge fan of that narrative device, she feels like it was unfair. Prosecution used one metaphor, one time, and she thinks that that confounded and hoodwinked the jury, as if they were little babies. But Sarah, of course, continues. In all of your pieced-together productions, I forgive you the most for never seeing the light in people, their human goodness, humor, and big hearts. You wake up and see the opposite, to condemn and take lives in your own way. See the good that does exist in all of us, inherently and unforced, even as the proud Mr. J stated, the kicked dog that bites. Mr. J, who kicked the fucking dog in the first place? In my wisdom, it's usually best to leave sleeping dogs lie. Then they don't bite. My gold also goes out to the jury for not understanding my cracks, from being blinded by the injustice and malpractice and all the judicial and prosecutorial errors, the very apparent violations of my constitutional rights during my case, an entire trial, which caused mass confusion and dysfunction. Stopping again, this portion was taken out because directly insulting the jury of men and women who unanimously found her guilty is such a monumentally bad move. Instead of just accepting that they saw the evidence against her, heard both sides' arguments, and sided with the prosecution, she had to state that they were just too stupid to understand what was actually going on, that they didn't understand the points she was trying to make, and that's why they made the wrong decision. She was just too smart for the jury, and now she is spending the rest of her life in prison, which is just fundamentally wrong. There is no other way to say it. At every possible instance, Sarah has been told that she is in the wrong, and that every single instinct that she has is bad, and will only lead to more negative outcomes. And instead of having any bit of self-awareness that may be that she is the problem, she just still blames everyone else. The letter continues. I forgive the jury, truly, for being wary from this confusion and dysfunction, also from being hungry and tired and wanting to go home to their families after being away from them in full capacity for 2 weeks. I understand. From this, their brash, misguided, corrupted decisions, I was wrongfully judged a murderer and instead of a survivor. But for this, all is forgiven. For this, I can survive and stand tall, having an even greater, the greatest opportunity to fully be understood in the Supreme Court for my appeal. I didn't lose. God just wanted me to win in a different way. Freedom is forgiveness. Heart emoticon. In the end, I forgive myself for not choosing my life sooner, for not being more brave, vigilant, bolder, and outspoken. Stronger mentally, physically, emotionally, and spiritually. For being hopeless, desperate, simple-minded, weak, and inexperienced. I forgive myself for not realizing I was enduring a life of domestic violence and that the vicious cycle of never ends. I had nothing to compare to. I've never been hit by a man before in my life. I was raised that hitting a woman was wrong and should never happen. No excuse. I forgive myself for not escaping permanently, for not fighting back sooner to save myself, my son, my dogs, my home, and car. Having 20/20 hindsight, thinking of everything I could have done differently or better to avoid the outcome. I think about this every day since. Also, all of the good days we had together, for him at least, while I was constantly in hyperdrive, high alert, and paranoid, making sure I did everything right all the time. I knew if not, the great possibility I would be ended as George threatened me with so many times before. I forgive myself for falling in love with a monster, and no matter how grotesque he may have become, I still loved, hoped, and forgave. I tried breaking the spell so he wouldn't be a monster anymore. I saw who he was inside. George made me then, now, and always love him, for all of his cracks also. We made each other our own brilliant pieces of art, from the cracks and repair. Unfortunately, not all cracks can be. In all my forgiveness, George is my greatest lesson, and will forever be a part of me. I think of him every day and speak to him when alone in the rec yard. I ask his forgiveness, and that he looks for me at the gates of heaven, so I can tell him just how sorry I am, endlessly, and that I never stopped loving him, in all of it. And still, when I first came to jail, I put my mat under my bed and cried all day and night for months, only falling asleep from being so exhausted with grief. I wrote him letters. I wrote his family and his daughters apologizing and asking for their forgiveness. But due to fear that my life or sons would be jeopardized, I did not send. I am sorry. I cannot begin to fathom any of their grief and sadness. Forgive me. Pausing again, that last part is more in line with where her entire statement should have been. Although she still takes the time to try and state that George's entire family is a dangerous bunch of criminals who wanted her dead, had she talked about her mourning of George, her regret over her actions that night, and how she is sorry for what she has done, this statement would have been more successful. But there is something else that is notable about this, which I feel could almost pass under the radar, and that's the fact that Sarah says forgive me at the end, instead of I'm sorry. An apology is a plea to the other person to understand your remorse. You feel badly for something, and you want them to know that you feel badly for it. And there is an understanding that sometimes apologies are not enough to remedy the hurt you've caused, especially if you are apologizing for killing someone. But Sarah doesn't say that she's sorry. She doesn't apologize in a way that shows humility or understanding of what she has done wrong. She simply demands forgiveness, and emphasizes that forgiveness should be given because she felt bad nearly 5 years ago. She doesn't want to show growth. She doesn't want to earn forgiveness through her actions. She wants to be forgiven because she doesn't like feeling bad. If you've ever had an argument with someone who refuses to say that they are sorry and simply demands that you move on from the issue, then you know how frankly rude this kind of response is. It's someone ignoring the hurt and injury they have caused and making the other person feel bad for wanting an apology in the first place. It's them trying to make you, the aggrieved party, feel crazy for holding on to hurt and acting as if it's an affront to them. But in this case, it's especially ridiculous given that she is demanding that George's family, the people that she publicly shamed, should be forgiving her and moving on. Sarah continues, almost everything reminds me of him, seeing my stab wound every day especially. Oh, it truly reminds me of all I did live through. George haunts me. He is everywhere. I believe because I do still love him, think of him, and miss his laugh the most. In my heart, I know he is with me and understands that this tragedy was not intentional. I hope everyone can. His family foremost. I didn't mean for this to happen. Please wholeheartedly know that, and always. Forgive me, George. Forgive me, Torres family. Forgive me, Judge Cranick. To the entire planet, forgive me. I graciously and humbly ask for consideration for forgiveness to be extended instead of judgment, for reconciliation and restoration for all of us, to move forward. Alright, pausing once more. Again, I don't know what Sarah expected the sentence to be. It seems that she thought there was a genuine chance that Judge Cranick would give her probation, that since she demanded to be forgiven, she could just move forward, that they would agree that this was the rational thing to do. But a man is dead. Her actions directly led to his death. There has to be some form of punishment for that. She continues, "My apology is profuse and ceaseless." Okay, pausing again, no it wasn't. It totally wasn't. I have unfortunately read every single letter Sarah has written. I don't know fucking why, but I have read them. And every one of her arguments, every filing, everything. She has not apologized one time. Even her last statement isn't an apology, it's a demand. Forgive me. I feel bad because I did something wrong, and therefore continuing to make me feel bad is mean. It's ridiculous. But she continues, "Allow me please to brush off the muck, wipe the blood off of my face, and fix the cuts in my skin. I ask for understanding in what really happened and for how long, for second chances, repentance, and redemption to advocate for all domestic violence survivors, to help them overcome, heal, and still hope, always, to make their voices heard, to confidently walk with their scars on the outside and inside, to help them not ever become a casualty of domestic violence as so many others, to stop the abuse and maltreatment before it's too late. There is always hope. You can survive. In my soft-spoken conclusion, I ask this. Would I be the darling mother, celebrated woman of the year, if it were I who died? How many daughters, mothers, sisters, aunts, grandmothers, nieces, and friends have been because they did? I am a survivor. Learn to do good. Seek justice, rebuke the oppressor, defend the fatherless. Plead for the widow. Isaiah 117. All-encompassing, protect the abused, Sarah Boone. So that was the entire document, which Sarah believed would lead to Judge Cranick deciding to give her a lighter sentence. She thought that if she got on the stand and read that out, accused him of being in a collective that set her up to take the fall for a crime she did not commit, he would sentence her to probation, or maybe a couple of years in prison. That is pretty shocking to say the least, even for her. This statement is objectively worse than the one she gave in court, but that one is still horrible. Sarah believed that this statement would lead to her release, that Cranick and the general public would feel rightfully shamed for what they had done to her, but that obviously was not the case, and still isn't. I expect that we will hear from Sarah soon, but I didn't expect the full letter, showing her original statement, and I sincerely hope that this is the last time we hear from her for a while. At least. So with that said, let me know what you thought of this video in the comments down below. If there was a video you would like to see on the channel, or a case you want to bring more attention to, let me know by emailing me at dreading.official@gmail.com. We're consistently going through our emails and adding cases to our list of stories to research. Remember, stay safe. You know what? Stay frosty. How about that, huh? What does the algorithm think of that? Really amp this fucking video up, take it to the next level.